Not that late, but we accept that. Mr. Maneji.
Thank you, ADJP.
You asked for 30 minutes. It starts now.
I did. So my Leonard Jr. has 30 minutes. So we will, if I take any more than that, we'll take it from her. We've arranged that.
That's in order.
Yes. So what I propose to do this morning is to take you to the ruling to demonstrate the review irregularities in relation to the recusal ground 1.
Just if you can just give me one moment, please.
Yes,
As you know, we are paperless, so I have to get to the relevant page. So can we do the same exercise that was done yesterday? Can someone invite me to the relevant page?
I understand one of our colleagues will do that.
Yes, it saves a lot of time, and for that we are grateful. Yes.
It does. I was just outlining that I will take the court to the ruling.
Yes.
And the purpose is to demonstrate the review irregularities first in relation to the first round of recusal, which I started addressing yesterday. And secondly, the review irregularity in relation to the delay. And then I will take the court to the founding affidavit in the recusal application to show the allegations made on which the recusal was based, to show that they were not generalities, and then to address the question of delay and section 47. The ruling the court will find at 001-37, that's where it starts. And just to foreground this reference, you will recall yesterday I identified for the court the applicable test when one is dealing with prior associations or prior involvement. That test is established by the highest court in the land, was applied by the SCA to SCA judges, was post binding on Justice Khampepe, and is binding on this court. Whatever the court may disagree with, it may not disagree that that is the test. It may disagree on the application of the test. Just to take you to the ruling, the ruling deals with the question of prior involvement from 001-49 under the heading prior institutional roles. And you will see there's an analysis of the facts at 001-52 under paragraphs 53, 55, and 56. That captures the Justice Khampepe's view on the facts on the question of prior associations. So she, in summary, at paragraph 52, at paragraph 53, she says that the work at the NPA must be of direct relevance to the work at the Commission. That's paragraph 54. And she says no proof was produced. And then at 55, she says there must be a logical connection between my prior institutional roles and the work of this Commission. Without this basic information, it is a leap of logic to suggest that there is a disqualification. And then at 56, she refers to the fact that the interference starts from 2003, that is covered in the terms of reference. So there is no overlap in the time when she was at the NPA and the TRC and the time that relates to the interference. And she says on that basis, on the facts, it is not demonstrated that there is a disqualification. And then she does an analysis of the law, and you see that from paragraph 59. She identifies that it is established that prior institutional positions will not without more be indicative of bias, let alone a reasonable apprehension of bias. I took you to the cases yesterday, they say that. And she says there is recognition that judges are the product of their experiences, they don't occupy a place in isolation. That's generally stated in the cases. And then at 60, she adds that no absolute neutrality is required. That's stated in the cases. Then she refers to Masuku, that the experiences of judges are there, it's accepted that they will have prior experiences. In none of these description of and the analysis of the facts and in the analysis of the law do you find any identification of that test I referred the court to yesterday. Just to recap, that test in paragraph 76 of SAFU is that one must show that the subject matter of the litigation in question arises from such associations or activities. And that is repeated in paragraph 78 of Bennett versus APSA, and that test is applied. You see from the reading the judgments how the courts applied that particular test. You see none of that in this judgment. What ultimately the judgment comes down to is that the subject matter of their prior roles and the subject matter of the commission must be the same, or must overlap. That's not the test. Or that there must be an overlap in the time of the investigation and her prior roles. That's not the test. Or that there must be a logical connection. That is not the test, which the courts have identified. So, with respect, what Justice Khampepe did was to not apply the correct test, either in ignorance of that test or simply by committing an error of law in determining the recusal ground. And that, whether one sees it as an error of law or ignoring the relevant test or ignoring a relevant consideration, that is a ground of review. And in our heads of argument, we have given you, firstly, the case of Scalabrini, the SCA judgment. You will find that at the relevant paragraph is paragraph 59 of that judgment. I'm going to take you to the paragraph. It's 056-667.
The invite is slow. Someone was invited.
I can take you to the invite is slow.
Yes.
Did we get the invite?
There you are. Thank you.
In the heads of argument, we've quoted it. We've summarized the judgment at paragraph 79 of our heads, and the court will find that at 05, if I can take you to the heads just to shortcut that, is at 054-35. 054-35, paragraph 79. And we submit there by reference to Scalabrini at paragraph 59 of that judgment that an error of law also results in an irrational decision. The SCA confirmed in Scalabrini that in order to be rational, a decision must be based on accurate findings of fact and a correct application of the law. So that's a ground of review. The second relevant case we've given you is at paragraph 78 of our heads. It is as 054-34. And that is a recent judgment of the Constitutional Court in Lewis Stores Proprietary Limited. In summary, the test is that it is not a misapplication of law to apply the wrong test. It results in a material irregularity in that you basically fail to decide the matter. And in Lewis Stores, which you will find on case lines, it starts from 056-431, and the relevant paragraphs are 26 to 27. And the court will find those at 056-436. I've referred you to the heads at paragraph 78 where we summarize that judgment. So that's a review ground. And that judgment makes clear also that it doesn't matter that the litigant attracted for itself a higher burden. Let's assume, and you will see from the founding affidavit that there was use of the words logical connection in the founding affidavit. It doesn't matter that a litigant attracts to themselves a higher burden. The court's obligation is to apply the correct test. And you will find that said in the Lewis judgment, let me just find the notes for that. Sorry, I didn't note it down here, but I'll find you the paragraph. It comes later than 26 to 27, but I'll find you that reference to Louis Stores. So it's in, I'm just giving the page numbers to my juniors.
What does it say?
Oh, it says, in that case, what had happened, this was proceedings before the Competition Tribunal. So before the Competition Tribunal, if you are an intervener wanting to intervene in the proceedings, in the major proceedings, to assist the tribunal, you must show that you're in a position to assist, to provide proper assistance. So it's not like an amici, you're coming in to assist. And what the applicant had said before the Competition Tribunal was that it had unique insights in the market that makes it possible for it to assist.
What is the relevant paragraph in Louis on that case that you are relying on?
I'm relying, in the first instance, at paragraphs 26 to 27. That is for the proposition that if a court applies the wrong legal standard, that is different from a failure to apply the correct standard properly. It is simply not deciding the case. It goes to access to court. It's a fundamental. It's not just like you got it wrong because you didn't apply the test properly before the court. I was just explaining the second point because there may be an argument that, but the Justice Khampepe relied on what you said in your affidavits. Oh, I've given you the reference to paragraph 26 to 27. That will be at 056-436. That's where you find that. The first proposition about the applying the wrong legal standard. But what I was submitting in addition is that even when a litigant is wrong about the law in their application and sets the standard higher, you don't dismiss the case on the basis of the higher standard that they've attracted for themselves. As a court, you apply the correct standard. And I was explaining in that Louis Stoll's case, what had happened is the intervener had said, we have unique insights in the market, and the tribunal accepted them as an intervener, allowed them to intervene. The major parties appealed to the Competition Appeal Court. The Competition Appeal Court departed from its usual standard that you must demonstrate ability to assist, and said you didn't demonstrate the unique insights that you said you had in the market. You should not have been allowed to intervene. And the Constitutional Court said that's wrong. The legal test is the legal test. It doesn't matter what a litigant says. The court is bound to apply the correct legal test. So I'm anticipating an argument. That's all I have to say now. But I'll find you the reference for that particular proposition. Then the third judgment we refer to in our heads on the reviewability for not applying the correct test is at paragraph 96 of our heads, which is at 054-42. 054-42 refers to the DA, Democratic Alliance with President of South Africa, so-called Simelane judgment, because it was about his appointment as the NDPP. And we submit that when you don't apply the correct test, you're ignoring a relevant consideration. And under the principle of legality, that is reviewable if the ignoring of, firstly, the consideration is relevant, and ignoring the affects the rationality of the process towards arriving at the decision. And as a result, it taints the entire process. In other words, the process of determining the recusal application. It does in this case because when you ignore the relevant legal standard, the whole process that you follow to reach at the conclusion is irrational because it's not based on the correct legal standards. And that is reviewable under the principle of legality under paragraph 39 of Democratic Alliance with President of South Africa. And the reference, the place you will find in the case lines for paragraph 39 is 056-330. You will find that. So what we submit to the court is the paragraph I was referring to in Lewis is paragraph 52, and it's at 056-441, where the court says the test is the test. It doesn't matter that an applicant embellishes their case. The court must apply the law, the legal standard. And so we submit with respect that based on what I submitted to you, the ruling is reviewable simply for the grounds that I've advanced. And that is a review based on the principle of legality. You don't have to determine whether party applies or doesn't apply. Then the second issue I need to address, which was raised with me yesterday, was the idea that all that the President alleged were generalities. And I'm going to take you to the founding affidavit in the recusal application, not before this court, what was before Justice Khampepe. And I'm taking you first to the founding affidavit of former President Mbeki, and you will find that at 077-147. Sorry, that's not where the document starts, but I'm taking you to where the paragraphs are that I want to refer the court to, because there isn't time to locate stuff, but you'll be able to see that. And here, there are two roles identified. It's the role in the TRC, that's the Prior Association, and then it is the role in the NPA. I'm going to deal first with the TRC role, both on the facts before the commission and on the facts added in this court after what the Justice Khampepe said in the ruling. Now you'll see at paragraph at 077-147, under paragraph 16 to paragraph 22, the President deals with prior associations in the TRC. And paragraph 16 is uncontested. That's the fact that she was appointed to the TRC Amnesty Committee from 1996 to 2001. And the committee was responsible for assessing and determining amnesty applications brought by perpetrators of apartheid-era offenses. Stated otherwise, the TRC committee decided whether to grant or refuse amnesty to the various persons that applied for it. That's common cause. 17, here Justice Khampepe would have presided over or participated in the amnesty applications of the accused persons in the CREDOC format. This Justice Khampepe corrected in the ruling that it is incorrect. She was right. And that is, I'll show that after the correction in the ruling, the facts before you illustrate the cases that she actually decided of perpetrators, and that's common cause. And then 18 refers to the ANC 37, that's common cause. That the denial of the amnesty and the denial of the amnesty and the report, what was said in the report. And at 19 it says, this amnesty determinations lie at the heart of the TRC's recommendations on prosecutions which this commissioner has been established to reconsider and account for. Reconsider in that it's reconsidering and accounting for the failure to prosecute.
In that context, yes.
Yes. So those are the facts regarding the TRC. And I'm not reading all the paragraphs. I trust the court will go back to all of them. I'm just going to show the correction. And here I underline the point that the nub of the complaint in 17, which she corrects, is that she was part of making determinations on amnesty applications regarding perpetrators in respect of victims whose families will be appearing before her. In the ruling, she denies only that you are wrong about the CREDOC form. She doesn't say you're wrong about the CREDOC form, but here's another list of those that I was in fact involved in, and they are before me. But even with that, there is no reasonable apprehension of bias. And it goes to disclosure. And I must underline the point when we say a judge has an obligation to disclose, which the cases say, the highest court in the land has said that, it is not to impose a reverse onus on a judge. It is the obligation imposed on a judge by the oath of office under the Constitution. And it's repeated in all of the judgments we referred to. It's repeated in guidelines, the bungalow principles, the code of conduct for judicial officers. All of that underlie disclosure. Judges are being disciplined for non-disclosure. Justice Makubele is one example that has been disciplined for failing to disclose her prior connection and role at PRASA. That's in the context of disclosure. I'm underlying the simple point that the obligation on a judge is unrelenting. It's fixed that you must disclose. If there is any issue that might arise, and especially when it is raised, you must disclose.
It is in the public domain that we disclose every year, as a matter of fact.
You disclose over and above what you disclose like politicians do. That's the lowest standard with respect to ADJP. That is what all the politicians have to comply with. But you occupy a distinctly different position. You dispense justice. For public confidence in justice, you must be beyond reproach. So you disclosed even that you have minuscule shares in Absa Bank. You disclose that you are paid by an institute for which salary Absa pays. You disclose, and that is the SCA giving the example. And the subsequent case in Absa versus Bennett, in Absa versus Arif, in the SCA following Bennett versus Absa, was again an issue against those two judges for the disclosure of the associations with the institute. And the court said, but that has already been fully disclosed and fully dealt with by the Constitutional Court. But the obligation, if I can use the concept of first citizens, the first citizen of the judiciary, the former president of the Constitutional Court then, and Chief Justice later, when he was faced with a complaint from an attorney about prior associations with political parties, he disclosed in full, and all the judges who were implicated disclosed in full on a statement of fact. They disclosed. I have a recollection of a case in which I appeared as a junior against my learned friend, Mr. Soni, in the Labour Court, where Justice Daya Pillay had sat in an arbitration, and there was an issue about her prior involvement in giving advice and the like. When the application was argued for recusal, she put on a statement of fact what she knew of the facts relevant to the recusal application. That is the practice. I searched for that judgment, I couldn't find it. I mentioned it to my learned friend yesterday. We tried to recollect it, but I still could not find that judgment this morning. But I recall it because I was then in the position of my colleagues next to me.
Justice Khampepe took issue with the expectation that she should have filed an affidavit.
Well, she could have filed a statement.
In the recusal application.
Yes.
And in SAFU we know that the justices whose recusal was sought filed a statement. Was it a sworn statement? It's not clear from the judgment.
It's not.
Was it just a statement?
I suspect it was just a statement because you don't want to descend into the arena of
You don't want to be a witness in your own case.
And you must be a judge, yes.
Yeah.
But a statement will suffice. But in our case, we didn't even have to reach the statement at recusal because there was the appointment by the president. There was the letter by the Galata applicants on the 11th of November 2025, and there was the letter from President Zuma. All of those should have generated a full disclosure to clear the air, but none of them did. So, but I was going to the founding affidavit in this court to show the correction of the earlier allegation which Justice...
About the credit for.
I beg my lord?
About the credit for?
About the credit for, yes. So that, my lord and my lady, will find in the application before this court, and the affidavit starts at 009-3. Sorry, 009-13. Yes. 009. I'm just checking that I'm right about that. Yes. So it starts at, where it starts is 009-1, but I want to refer the court to paragraph 32, which is at 009-13. So firstly, you get the ANC leaders that I've already addressed. And then at paragraphs 138 to 148, which will be at 009-58. And I'm not going to go through all of this. You'll see 009-57, it's under the heading prior adjudication of amnesty applications involving parties appearing before the Commission and the interests of justice. And then you will see from paragraph 138, this, it starts by saying, in our founding affidavit before the Commission, we incorrectly stated that Justice Khampepe presided over the amnesty proceedings in the Credit 4 matter, which matter concerns Mr. Kalate's father. When the Kalate group pointed out that this was factually incorrect, we accepted this, but we reiterated in our replying affidavit that the substance of the complaint was not confined to a single amnesty decision, but to the chairperson's institutional and adjudicative involvement in the TRC process as a whole. We annexed the relevant extract from our replying affidavit. You will find that extract. I'll give you the reference, but I'm not asking the court to go there. It is at 009-268. And then it says at 139, paragraph 139, having considered Justice Khampepe's approach and finding in relation to the complaint about the presiding over amnesty proceedings, my legal representatives took it upon themselves to review the TRC amnesty archival records to verify whether Justice Khampepe presided over amnesty proceedings relating to parties before the Commission. The records reveal that Justice Khampepe participated in and was party to the refusal of amnesty in respect of the killers of Richard and Irene Mutasi, as reflected in Schedule 17 of the TRC Amnesty Committee's decision that is given, and the reference is given. That reference is at 009-271. When you go to that reference, you'll see that the panel comprised of Justice Khampepe and others. And it gives the other, I'm not going to read through all of this. You can see the annexes, all of those annexes that I mentioned there are of those cases in which she had, took part in making those decisions. So that's the role before the TRC. Those are not generalities, with great respect. Then I attend to the question of the NPA role. And that the court will find in the application before her, the recusal application, you will find at 077-14, 149, sorry, 149, 077-149. It's a relevant section of that affidavit before the Commission. And I read from paragraph 23. And it's important for me to read because you must see the allegations of fact that are made. It says, Justice Khampepe served as Deputy National Director of Public Prosecutions under then National Director of Public Prosecutions, Advocate Bulelani Nuka, from September 98 to 99. This period coincides with the establishment and operationalization of a Human Rights Investigation Unit within the NPA. The HRU's mandate was to review TRC amnesty records, investigate apartheid-era human rights violations, and make recommendations on the prosecution of TRC matters. And then you're given a reference. As appears from the Weber-Wenzel letter of 11 November 2025, Justice Khampepe played a role in the HRU, including providing advice to the National Director of Public Prosecutions on their approach to TRC matters. Then we refer to Anton Ackerman's affidavit, Advocate Ackerman's affidavit. And then it says at 25, although the precise nature of Justice Khampepe's involvement in the HRU requires further factual clarification, the overlap between her TRC adjudicative role, her prosecutorial oversight role, and the current Commission's mandate cannot be ignored. Compounding this is that Justice Khampepe, knowing the full facts, may feel obligated to clarify the aforesaid role, further drawing her into the investigation of the role of a witness and that of the fact finder. This is untenable, but she doesn't even, she didn't produce that. The reasonable observer would apprehend that a person who previously had institutional responsibility for shaping NPA policy. That's where the NPA shaping of policy comes in. But this is on TRC cases. Would find it difficult to approach with neutrality a commission now tasked to determine whether the NPA failed, neglected, or improperly refrained from pursuing those very cases. That's.
I'm sorry to have to take you back.
Yes.
Paragraph 24, where a reference is made to Mr. Ackerman's affidavit, Annexer FA8. Of that annexer, what is the relevant part?
It's paragraphs 10 to 11 of that. It's given in the footnote. In the footnote to reference there, 24.1. Paragraphs 10 to 11. And that affidavit is before this court. The Galata affidavit, I was going to complete with it because it shows you that this matters arise from there. The High Court.
I was just keen to know the relevant part from that affidavit.
It's in the footnote to the paragraph 24. It's footnote 3. It's paragraphs 10 to 11. I was just saying to the court that you also have a full copy of the High Court application by the Galata Group in this proceedings, and that you will find. I'm just giving a reference. You'll find. I was going to refer to paragraphs 27 to 32 of that affidavit, and those will be at 010-53. 010-53. When you are at that, you will be able to see where that affidavit starts. So the point I'm making about the allegation here is that it is made squarely. The effects alleged. It's not a generalization. And what is the answer to that allegation? Before the commission, you will find in the affidavit deposed by our colleague, Mr. Smenya, is at 077-462. 077-462. You'll find his answer which deals with this allegation. And that is paragraph 35. You will see that just before the page, that section of the affidavit is addressed under the heading Chairperson's Prior Roles and Reasonable Apprehension of Bias. At paragraph 35, this is what our colleague says. In his founding affidavit, the first applicant alleges that the chairperson apparently played a role in the Human Rights Investigation Unit established by the then NDPP, Mr. Bulelani Ngcuka, to advise him on how to handle the cases referred to by the TRC. This allegation is stated to be based on a letter dated 11 November 2025 from Webo Ansel attorneys. There is no denial, there is no dealing with that. All that follows is an argument that that's irrelevant. And that letter you will find at 009-124, the Webo Ansel letter. I'm not going to read it. But what is important is that the Galata Group, in their answering affidavit before the recusal, did not step away from that letter. And the court will find their answering affidavit relevant to that paragraph at 077-722. So it's 077-722. You'll find their answer at they're dealing with that letter at paragraph 34. What they say at that letter is simply to criticize Mr. Mbeki, former President Mbeki. What they say is, even when the Galata Group attorneys, this is in the context of delay, even when the Galata Group attorneys wrote to all the parties on 11 November 2025, drawing their attention to Judge Khampepe's background, Mbeki and his legal team chose not to act. This letter is annexed TMM 5.1, and then they say what is stated. They say it was for Mr. Mbeki to speak up at that time. So they affirm what they said in that letter. They're not saying there was anything wrong with the letter. But what they failed to do is, in their criticism to the litigant, they failed to criticize the decision maker. The decision maker was called upon to disclose at that point. But because, as Justice Batko asked me yesterday, what about their views? You can see they're taking very subjective, one-sided views of the matter. They don't realize and acknowledge that their letter generated a duty on the chairperson to disclose fully her role in the NPA in relation to TRC cases. Or to say, in a statement of fact, I had no role to play And it's not just, I was not part of the unit, it's not an answer. I had no role to play as the second in command in advising the NDPP at the time when he was busy laying the groundwork for the prosecution of TRC cases. Sorry, I'm just being referred to something.
Yeah, it's 30 minutes.
Yes. So there is a response by the commission. Sorry, I beg your pardon for saying there was no response.
So there is?
There is a response by the commission to the letter of 11 November 2025 from the Webber-Wentzel team on behalf of the Galactic Group. And the court will find that at 077-1521, it makes matters worse for the commission, because that letter says, heading, potential further conflicts and requests for clarity on procedure going forward. We acknowledge and note your letter dated 11 November 2025. The letter says you write to express our client's deep frustration with the collapse of the first sitting of the Commission's hearings. The Commission issued directions that recusal applications by the National Prosecuting Authority and the Department of Justice and Constitutional Development must be filed today, the 12th November 2025. The Commission will await the founding papers for the recusal of Advocate Mbeki SC. Further directions regarding answering papers and other processes have also been issued. The Commission will not likely entertain any further delay in the discharge of its mandate. That's the attitude. And it's signed Justice Khampepe, chairperson. So deliberately not disclosing a fundamental issue going to her conflict and headed potential conflicts of interest. No disclosure.
Mr. Manager, it's my duty to point out that we are 40 minutes, almost 40 minutes into...
I'll be quick, but I'll have to finish this. It's an important part of this case. So on the facts we submit, it is simply incontestable, simply illogical to suggest that the subject matter of the Commission does not arise from her prior role. Amnesty Committee, NPA, and the role she played. It is wrong to suggest that the matter arises from interference with prosecutions. Interference with prosecutions is what she is tasked to investigate. It's not what the matter arises from. Because the terms of reference says she must determine whether and if there was interference. Interference is not assumed, otherwise we wouldn't have a commission of inquiry. Or we wouldn't have a commission of inquiry with whether and if. It would only be a commission of inquiry with when and by whom was the interference. But the inquiry here is tasked to investigate what is the reason for the failures to prosecute. Is it interference or is there another explanation? So it meets the test. So as regard remedy, which we submitted yesterday, once that is so, that it meets the test in APSA, it's got nothing to do with remoteness, doesn't matter when the shareholding was or when you were part of the institute, is the subject matter relationship. Once that is the case, you have all the facts before you to decide that she should have recused herself. And you are entitled under TRENCON, which you are familiar with, which we have cited in our heads of argument, to substitute the decision after you've set it aside for the grounds I've advanced, to substitute it with a recusal and to order that she must be removed. In any event, there's a self-standing order to be granted against the President to terminate her appointment. My learned friend argued that I'm not going to repeat. So I'm going to take all of the time allocated to my learned friend, and we'll stand by our heads on the second ground of recusal, on that review. Then I go to the question of delay. There again, I start by demonstrating that the judgment,
Perhaps before you go into the aspect of delay, going back to the relief, standing relief that you suggest, termination by the President, does he need a court to do that? He can't do so on his own?
He says he needs the court because he says it's functus officio. The court can tell him you're not functus
I'm asking you. You are an officer of the
must do
court.
it. Yes, the court can say that.
I'm asking you as an officer of the
The
court.
counsel is here. As an officer of the court,
Yes.
it is arguable whether he is functus or not functus. But it is possible that he is. He needs the intervention of the court to reverse the decision, because once he appoints, that decision is complete. It's like a tender. Once you've awarded the tender, it's complete. If you want a reversal, you go to court for court to intervene.
Self-review or
He
self-review.
could do a self-review, but we, being the other outsiders from the decision maker, can say, given what is disclosed and what you now admit, this order is uncontested, must be granted. Yes. Then I go to delay. And delay is also fundamental because it's one of the misdirections, and my learned friend has demonstrated with regard to his client that there was no delay. Can I just say up front that if you can't find that the judgment, the decision on delay is justifiable in relation to President Zuma, it would be a greatest anomaly in law to deny my client to challenge the same ruling when the outcome in President Zuma will determine my legal rights. So once they are connected and you've given, there's no delay on the one, you can't deny delay on the other. There is a judgment which I can give a reference to. It wasn't decided because counsel agreed. It's a phrase that it's easy to find on SAFLI. It's an SCA judgment with the only Afrikaans name under V. Phrase that fonts something. I can find it's pension funds.
How
Phrase that
how
pension
quickly
funds.
can I find it with something? How quickly can I find something? I can quickly get into SABC.
That is correct. That's my Justice Presiding is absolutely correct. We'll give you the full citation. But in that case, and I acted for the Minister of Finance. A colleague of mine acted for the Registrar. So the challenge was against a regulation made by the Minister. We had 3 challenges, 2 launched in this division, 1 launched in Pretoria. In Pretoria, delay condonation was refused, and the judge said it was a collateral challenge, is not permissible. In this court, 1 case came before Justice Suwendu, she granted condonation. And in the other, I can't recall what the fate of condonation, but the cases were consolidated to be argued before the SCA on appeal. And the judges asked us, so in 2 cases, you still argue on appeal that condonation was rightly refused, but in the one, condonation was granted. If we hear the one where condonation was granted, the outcome there affects all the other 2. It would be anomalous for us not to hear all of 3. And we conferred and said, we are right. You should decide the matter on the basis that condonation is not an issue any longer. And that is, just to answer the ADJP, it's Vrystaatse Municipale Pensioen Fonds. Vrystaatse Municipale Pensioen Fonds will be Free State Municipal Funds, pension funds. This is Minister of Finance and another. In brackets, that's the case number 1161 stroke 201 2020 in square brackets ZASCA 143. It's also reported in the All South African Law Reports. It's 2021 volume 1 All SA 116 SCA 2. If I can just quickly get to the paragraph. It won't take me long. It's paragraphs 40 and 41 of that judgment. It's the judgment of Justice Nafsa. So I can now safely turn to, I'm in delay, yes. I must point out something very anomalous, given the point I've made about the failure to apply the correct test, is that when you get to delay, which in the ruling the court will find at page, sorry, I beg your pardon. the delay point is addressed from 001-69. You recall yesterday, my learned friend Mr. Mpofu and I referred you to Bennett versus Absa, paragraph 74 on delay. You recall that, Justices?
Yes.
When the Justice deals with delay, she quotes from Bennett at 001-71. She references Bennett and quotes from that paragraph. But recall that is the same case that deals with the test for prior associations. So Justice Khampepe was aware of that judgment, but only used it in respect of delay and not in respect of prior associations. So that paragraph 74 is very clear that delay is resolved by reference to the interest of justice. It's not a question of waiver. It's not that you've waived your right. And in that context, it matters the stage at which the proceedings have reached. You'll recall that in Bennett, the justices made full disclosure before the appeal hearing. The appeal was argued, and the party decided, despite the disclosure, he's not complaining about recusal, put the thing in the back pocket for the future. When judgment came out against him, he produced the disclosure and said you should have recused yourself and challenged the judgment. That's not in the interest of justice, because you don't offer the opportunity to the justice to recuse themselves beforehand, to withdraw from the judgment, and for the matter to be argued before a properly constituted court. You don't find that in this case. President Mbeki did not wait for an adverse outcome. The suggestion is that he should. The suggestion in media res that they argue is that he should wait until the findings are made that upset him, and then say these findings are invalid because Justice Khampepe should have recused himself. That's wrong. That is precisely in contrast with what the cases say. And there's a fundamental reason for that. Is because if a judge should recuse themselves and they don't recuse themselves, every step that follows is a nullity. In law, it doesn't require the recognition of this court. For that reason, we don't persist in prayer 7 of the notice of motion, that you must ask, that we've asked, the prayer in President Mbeki's notice of motion that this court must declare that proceedings following the refusal to recuse are a nullity. That follows the matter of law. It doesn't require this court's order. But we've given the relevant judgments in our supplementary heads on nullity, and you will find that, if I can give you the references, because then the court can look at them, it's at page 054-110 of our heads. We refer to the decisions of the SCA, which tell you that those proceedings become a nullity. So you can't wait until the end, because you can't fix that problem. It goes to the jurisdiction of that body. If it does, it should recuse itself. It doesn't have jurisdiction to carry on sitting, because if it sits, everything else is a nullity. You will recall from paragraph 30 of SARFU, they make that point, because subsequent proceedings are irregular, ipso facto irregular. So that's the first point we make on recusal, on the delay, is that President Mbeki did not wait for an adverse finding, and the test is interest of justice, is not waiver. The second point, there are 2 points. I've made 2 points. He didn't wait for an adverse finding, and the test is interest of justice, and it's unlike in Bennett. The third point is that Justice Khampepe, in her ruling, does not compute the delay by President Mbeki. Doesn't. And you'll know that it's an elementary approach, that before you can say the delay is unreasonable, you should know how long the delay was. So Justice Khampepe, nowhere, you can look at the discussion from 001-69 on delay. The conclusion is unreasonable, it cannot be overlooked, but you don't know how long you delayed. Because there are difference of view, different submissions were made to the commission. The first was, he delayed from the time when he tried to intervene in the High Court in March 2025. When they were still trying to get a commission set up, he knew the facts then. The delay starts from there. Which commission was he going to bring a recusal application before? Then they say, well, he delayed from May 2025 when the commission was established. At that point, the terms of reference identify interested parties before the commission. And you will find that the terms of reference starts at 001-79. Maybe the proclamation itself is. And it describes the interested parties. I'm just looking now where that paragraph is with interested parties. I'll ask for help. Always when you look for these things. But interested parties are defined as to include the parties that were in the High Court in the application where 009 263 263. The court will find the terms of reference and will find the definition of interested parties. Right? Yeah, interested parties. It's paragraph 2 at 009-263. Those are the parties in the application proceedings under High Court. Those are the Galata applications.
Was your client one of them?
No.
Okay.
My client applied and they refused him to be an interested party.
He was refused and later, via a notice, he was then notified.
Yes.
Is that where you're going?
Yes, it is.
With that as a fact, with that background as a factual issue that's not disputed, can I remind you, you are running 30 minutes behind time.
Okay, let me finish now. I really am indebted to the court. The period must start from September because that's when the notice.
And that's the point you're making.
Yes, that's a shorter period. It can be overlooked. And we refer to judgments of the Constitutional Court, including one by Justice Khampepe in Tasima, Department of Transport visits Tasima, that you can overlook a delay even where the explanation is ridiculous because the irregularity is egregious. That's the delay. And we are supporting them. We are all in the same boat. But anyway. And I've got 10 minutes because I'm taking my learned friend's time. Recall, Justice. But I accept I'm running quickly now. But there's a fourth point. Is that the fourth point and last point is this on delay, is that the complaint by former President Mbeki relies on two grounds. One is the prior institutional roles. The second is what happened in the proceedings. He couldn't have delayed in respect of that ground. That is not taken into account. It's just dismissed. And in any way, we still don't have full disclosure on her role at the NPA in relation to TRC cases. And recall that in Bennett, the judgment is very clear. It's delayed from the time when you know the full facts. We don't know the full facts. So we may, when we know the full facts, renew another recusal application based on the new facts with the full disclosure. So there's no delay here. But in any event, it would have been in the interest of justice to overlook the delay. I go to section 47. Here we've submitted a note which the court said it had considered, and that is at page 059-1. And we explained why we filed that note in addition to our main heads, our supplementary, and this. It's because it was supposed to be argued up front. And we took the point, firstly, that section 47 is not a jurisdictional provision. This court enjoys inherent jurisdiction to hear legality reviews of budget reviews. It has that jurisdiction. That section does not limit jurisdiction. It places a procedural hurdle in the place of a person like my client who might want to cite a judge, that you must first get permission. It's not a question of jurisdiction, it's a procedural issue, simply a procedural issue. As we speak, until you make the determination that section 47 should have been complied with, these proceedings are valid. The presumption of validity in our law is these proceedings are valid, until you pronounce that we should have complied with section 47. So our learned friend's argument is entirely wrong. It's wrong to compare it to questions of jurisdiction because The existence of jurisdiction is an objective fact. It's either it exists or doesn't exist. It's not conferred by complying with some other permission requirement. So that judgment of the Constitutional Court is correct for what it was dealing with. True jurisdiction, which is a competence of the court to deal with a matter. This court has inherent competence to deal with legality reviews and PAJA reviews. PAJA says so expressly. So it's entirely wrong. It was made with an idea to dissuade the judge, the court, to discourage the court from deciding the application to compel upfront, because he says you can't decide that until you decide your competence. That's wrong. It doesn't apply here. Here, these proceedings are valid until you say that Section 47 should have been complied with. Our key submission on Section 47 is that it does not apply to the current facts. In the note we've given you, we have taken it on ourselves to go through all the judgments we could find, at least in this division and Pretoria, dealing with the old Section 25 and the new Section 47. But we also went to the Eastern Cape, so you have the advantage of the 3 JPs, Justice Khampepe, JP, Mlambo, JP, Mbenenge, JP. There's a commonality amongst the 3 of them dealing with the old Section 25(1). They say, they differ about retired judges, but I'll explain that the difference is immaterial.
Before you proceed, I think you omitted retired Deputy Judge President Sutherland.
Ah, I did, indeed. Oh, that's why I said Judge Presidents, but I was wrong. I should, yes, indeed. I do. I do include that. All of those judgments start by identifying the purpose of the section. They say it is to secure the independence of the judiciary, to ensure that judges can perform their functions without fear, and to ensure the efficiency and efficacy of the performance of the judicial function. If you don't have that protection, and your judgments mean tomorrow when you hand down judgment, I may be happy or he might be unhappy or whoever, every day your work involves disappointing one party over the other. And you can face frivolous and appropriate proceedings. You mustn't find yourself in court all the time neglecting your judicial functions. So they must ask for permission. That permission will screen whether that is there's good cause to grant permission. If there's good cause, permission will be granted. That's the first point. Now, in that sense, in respect of active judges, when you're cited in your capacity as a judge or in your personal capacity, you enjoy that protection. If you just cited in your capacity as a judge or in your personal capacity, they say there's a wild allegation about theft, you are protected.
And once retired?
I'll come to that. I just want to make the principles clear.
No, I understand.
Yes.
Go on.
And I can't assume that the court agrees with me. So with active judges, it's very clear. But you must be cited in your capacity as a judge or in your personal capacity. And you're covered. Then retired judges. Justice Mlambo makes it clear that retired judges are covered. And to that extent, agrees with or qualifies what Justice Mbenenge said. Justice Mbenenge said, retired judges are not qualified unless they are recalled to perform judicial functions. Then they are protected. But Justice Mlambo doesn't qualify that. Right? So that's where we start. That still has nothing to do with this case. So you are cited in your capacity as a judge or personal capacity. You're a retired judge in your capacity as a judge. Like Judge Mutata. Justice Mutata was cited because the aim was to review decisions of the JSC about his outcomes of his disciplinary inquiry, but they cited him in his capacity as a judge. He was not in a representative capacity representing another shadow. It was in his capacity as a judge. When you're cited in that capacity, whether active or retired, in terms of Justice Mlambo's judgment in Mutata, you are covered. But that is not the case with retired judges acting in nomine offici, in a representative capacity. because what is sued is the office, not you in your capacity as a judge. When you are a chairperson of a commission of inquiry, you are there acting nominee officie. You are cited nominee officie, and that's what my learned friend indicated. The target is the office, not you in your capacity as a judge. To that extent, that section doesn't cover you. And in that way, Justice Mushwana is correct, Justice Dippenaar is unfortunately wrong. And Justice Dippenaar is wrong for an additional reason. She says she was bound to follow all the previous judgments, including the ones I just discussed. But all of those were not dealing with judges acting nominee officie. They were dealing with judges cited in their capacity as judges. The section protects them. And there's a further distinction why, even if the court is persuaded that Mantashe is correct, Dippenaar J was correct, the position of the Chief Justice at the time is completely different from the position of Justice Khampepe. The Chief Justice was still active in active service when he was chairing the capture commission. Yeah, the said capture commission. So he still had to go and perform functions as a Chief Justice. Some of us were misfortune of appearing before him or pleasure of appearing before him as Chief Justice. So in his case, there could have been a completely separate reason to justify Section 47 being that it being tied up in litigation could interrupt his judicial function. But that's not what Justice Dippenaar reasons the case of. But I'm saying this because it completely differs from the position of Justice Khampepe. Justice Khampepe is entirely cited nominee officie, and my learned friend referred to the citation. That is admitted, and there is no allegation that it will interrupt my judicial functions. In the case of the CJ, when he was cited in Mantashe, he said so. I am the Chief Justice and the Chair. I'm not two people, I'm one. I'm occupying both. So it makes sense in that case that there may have been interruption of judicial functions. The Justice Dippenaar also relies on the definition of service in the Remuneration of Judges Act. But that's irrelevant completely because that deals with remuneration, doesn't deal with litigation against judges. In Mutata, when the court reads that judgment, at paragraph 24, J.P. Mlambo made a mistake of saying service is defined in the Superior Courts Act. There's no definition of service in the Superior Courts Act. There's not even a definition in the Supreme Court Act, which precedes the Superior Courts Act. So that service point is just wrong. It's a wrongly decided case. And to buttress the point, in those heads that we gave you on the point, we showed you from paragraph 24 at 059-7, numerous cases in which judges have been cited nominee officie in commissions of inquiry. Corruption Watch, Malene Trend referred you to paragraph 4, full bench. Korabi, I think the commission refers to it, but in the context of Paja in the Western Cape, citing the Zondo Chief Justice Zondo nominee officie. In Moyane versus Ramaphosa, Judge Nugent was cited nominee officie as head of that other commission, and Safu will be judges. And then we also make the point that if they were correct that as long as the person has the name judge, doesn't matter the capacity, then you would never review arbitration awards of judges appointed as arbitrators in private arbitrations because they too are judges, but they are cited nominee officie all the time. And paragraph 25, we gave you examples. Close up, Judge Brochowitz was cited NO, retired judge. Hosmet, Van Dijkhoff, Judges Van Dijkhoff, Van der Walt, and de Villiers were cited nominee officie. No issue about Section 47. So it's a red herring, this Section 47 point is dead in the water. It should not detain this court, but this court may need to pronounce on it because there are two conflicting judgments. And we've given you authorities that you're not bound by a judgment of a single judge in this division. You're a full court under 14.1a. You can decide between them which one is correct. You may even reach your own conclusion which departs from them completely, the two of you. You are free to do that, and we submit you should. So those are submissions we submit, my lords and my. In media res, we associate with the submissions of our learned friend. In the heads of argument, we deal with it at 054-56 at paragraph 142. We also refer to a judgment of Basson in the High Court of your colleague Justice Potterer, where the issue was raised in media res concerning a recusal of a member of a disciplinary panel of the Health Professions Council. And she said there are exceptional circumstances when it involves recusal, because every day you sit is an irregularity. So you're undermining the duty to have a fair process. So there's no need to wait for another day. And they could have raised it even before Justice, before the Commission, that this is in media res, we should wait for the outcome of the proceedings. They didn't. It's a latter day idea of lawyers, which happens all the time. So we submit with respect that the declarative that President Zuma seeks in his prayer 2 must be granted. The review and set aside must be granted. Prayer 6 must be granted to remove, because we say there is no other outcome here than recusal. Alternatively, it's the termination by the President, and we don't persist with the declaration that the proceedings henceforth are a nullity. We don't need a court order. It's a matter of law. Those are submissions, and in relation to our second point, my learned friend will just indicate where in the heads you will find our discussion of the grounds.
I thought you said she forfeited their time.
I could just give you the references, my lord, in that case.
I hope you clear.
She wants to do it herself.
She wants to do it herself.
She's never been spoken for, Judge. I don't want to be the first one.
You are on borrowed ground in terms of time. How much time do you require to do that?
2 minutes.
Let's make it half 1 minute.
Oh, wow. Okay, we address the second ground of recusal in paragraphs 101 to 108 of our heads of argument. But there are certain documents that are important for the court to consider as it considers our submissions, and these are annexures to the answering affidavit for the Commission. Annexure number 1, pages 015 to 6-68, as well as annexure IS2 to that affidavit, which is on the pages following. It's important that the court takes into account Rule 3.1 of the Commission's rules, as well as annexure IS5. There are certain references to transcripts. For example, the transcript of the meeting of 27 October, which is quite relevant, and that the court will find at 077-1190 to 077-1193. It's very short. The court ought to also take into account IS7, please, 01587. And the other transcript, that's quite important, pertains to an interview that ought not to have taken place in our submission, is at well, before I get to the transcript, the court ought to please also take into consideration a supplementary affidavit by the NPA, in that the court will find at 077-282, from paragraphs 5 to 8, and submissions by the Talata group, and that's at 077-1922, that's the Talata group before the Commission. And the interview transcript that I refer to is at 077-1538. And the rest the court will probably consider in the course of considering the case at any rate. Thank you.
Thank you. Mr. Brendes, is it not your turn?
Finally, Justice.
At last.
Justices, we make submissions only on the explanatory affidavit by the President. We start with the facts. They have been dealt with by both they've been dealt with by Mr. Mbeki in great detail, but we do want to remind you that the undisputed facts are not just that the Justice Khampepe, appointed as the chair of the commission by the President, was appointed to the TRC as a commissioner. There are three crucial facts, and these are dealt with at case lines 15-16 and I beg your pardon, it's case lines 006-24, paragraph 25. Now, the facts that are undisputed are that the chair sat on an amnesty committee that refused amnesty to perpetrators in the murder of the Motasi couple. She also sat on the amnesty committee that denied amnesty to all except for one perpetrator in the Pepco 3 murders. And she sat in the amnesty committee that denied amnesty to ANC 37, and those include Presidents Mbeki or former Presidents Mbeki and Zuma. The undisputed fact involves the undisputed fact, and there's only one, involves the role played, the alleged role played by the chair on the HRIU. That was dealt with quite extensively by Mr. Maneche in particular, and partly by Mr. Mpofu. But can we remind the court that the allegation arose in that Weber-Wenzel letter? And what the President says is, in his explanatory, is that he didn't know these facts. He admitted the disputed fact at the time that he appointed the chair, and had he known of those facts, he would not have appointed her. The so-called disputed fact dealt with at great length by our learned friend, Mr. Maneche. All we want to say about that is the following. To date, the President is none the wiser about the involvement of the chair when she was at the NPA and possibly involved in the HRIU. There's a bare denial, but that's all. So he's none the wiser. It hasn't as yet been disclosed to him what the chair's involvement was on the HRIU unit. Now, we then move after the facts to what we submit. The rules are that are relied on by the President. The rule of disclosure is clear because, reading the court, it's accepted based on the authorities relied on by our learned friends, in particular Southwood, Bernard, that there's a duty to disclose. We also, so there's a duty to disclose. The second is we rely on the duty to disqualify. Now, both of those arise, and we set that out in our heads, in the context of the principles that apply to judges when they're called upon to disclose and disqualify themselves. We start, and the President accepts this, we start from the premise that judges act judicially, they act without fear or favor, impartially, even-handedly, and fairly. We start from that presumption. But that presumption is accompanied by the duty to disclose and disqualify. And you disclose when there is prior association, and you certainly disqualify yourself when you have prior involvement in the matter in which you now sit, in which you are tasked, in this case, to investigate. Then we go on to say this. What concerned the President is not just this issue of bias, because of course that's been dealt with at great length by former Presidents Mbeki and Zuma, and they of course allege bias. The President's real concern is this. If you read those cases, and it's the Corruption Watch case, it relies on that Mail and Guardian case. The Corruption Watch case also relies on Canadian cases. If you read all of them, then what shines through clearly from those cases is that commissions of inquiry are preeminently concerned with the public trust in government processes, and in matters of great public importance. The country has to have trust in those processes. In a matter like this, where we're dealing with TRC, allegations about TRC, interference in TRC prosecutions, we're dealing with a matter of national unity and reconciliation, which is, of course, founded in the Constitution. So it's important that, for the President, that when he appointed a person to chair the inquiry, that it wouldn't lead to, well, the situation we have currently, which is that there is distrust in the Commission because of the prior association and involvement of the chair. And there's distrust not just by the two former presidents, but there's potentially distrust by other people who are accused at the Commission of either supporting or colluding with interference in the prosecution of TRC cases. And they go wider than just the two former presidents. They include, for example, Mr. Mabandla, Mr. Kazadals, and so on. So that's an important principle, and the President says that's obviously what he's concerned with when he appoints someone. And had he known that there was the potential of damage in the public trust in this Commission, then he wouldn't have appointed the chair. So that's where we start from. Now let's go to the application of those principles, in particular association and prior involvement. There's no question of prior association here, because the chair was at the TRC, she admits that, and she was at the NPA. We just don't know precisely in what capacity she was there. So there's prior association. But the President's case is, this is not a matter simply about prior association, it's a matter of prior involvement. And let's see if we can explain why with respect, Justices. In the Commission, there is, the allegation is that high-ranking members of the ANC government attempted to interfere. The Chikani case is one such case, it's the most celebrated one, but attempted to interfere with TRC prosecutions by the NPA, and the reason they did that was to, they interfered because they were concerned that they might be prosecuted. So that's broadly the allegation made there. That is an allegation, as our learned friend Mr. Maneche says, is going to be investigated at the Commission. The problem is this. We've already, the admitted facts establish that at least three parties there, two, now I refer to them collectively as parties, former President parties, PEPCO 3 parties, and the Watasi parties. At least three of them were involved, at least three of them concern decisions by amnesty committees in which the chair sat at the time, in which amnesty was refused. Amnesty, the refusal of amnesty means that you've got to be prosecuted. And so what you have here is you have an investigation where the chair was in amnesty committees that refused amnesty. A consequence is that prosecution was followed. And two of the parties where she refused amnesty are accused, or at least one of them, Mr. Mbeki, but to a lesser extent Mr. Zuma, they are accused of either colluding or being involved in political interference with prosecutions. And we say that shows prior involvement, because what it shows is that the chair was involved as a lawyer in matters that are relevant to the inquiry. It's relevant that there was a refusal of amnesty for the ANC 37. And an associated relevant fact is that Mr. Mbeki, being one of those, was trying to interfere with prosecutions by the NPA, which is of course a natural consequence of the denial of amnesty, is prosecution. So we say there was prior involvement here. And you can find that Mr. Khampepe was finding that there was. And if there is prior involvement, then what follows is the duty to disclose and the duty to disqualify yourself from sitting in the commission. Now, can I move very swiftly on to the arguments? And the arguments by the Commission and the families in particular against the explanatory affidavit. So the Commission doesn't actually directly address the argument that I just made to the bench. We rely, or the President relies on Corruption Watch and the Mail and Guardian case for the legal standards required of investigations by commissions of inquiry. And that standard, as we set out in our heads, is that the investigator, or the head of that investigation, must approach her task with an opening, inquiring, and fair mind. And one can tell that, this obviously is not the President's case, but one can tell, hearing the submissions by both former Presidents, that they are deeply concerned that given prior involvement, at least prior association, that the Chair will not bring an open, inquiring, and fair mind to the investigation insofar as it relates to them. And they, President Mbeki, we do know, was given a 3-3 notice, and so was President Zuma. So, Public Protected Mail and Guardian apply to the standard applicable to an investigation by a Chapter 9 institution. Corruption Watch found that the standard is the same. In other words, Chapter 9 institution and the Commission of Inquiry, the standard of the person chairing the investigation or heading up the investigation is the same. We agree and we submit that this court is bound by that finding. The Commission assumes that we argue bias. We don't. We argue an open, inquiry, and fair mind. The argument, or the Commission's argument on bias, diverts it into an argument about the test for bias, but we are not concerned with the test for bias, we're concerned with the test for something else. Nor do we propose a new test for bias. We simply argue that on the facts of prior association and involvement here, it is not unreasonable for the former presidents, and certainly Mr. Mbeki, Ms. Mabandla, and Mr. Kazarov, to suspect that the chair of this commission will not bring an open, inquiry, and fair mind to this investigation. As for the families, they concede the requirement of disclosure, but they say it doesn't apply where the information is in the public domain. They say that here the admitted facts are in the public domain. They cite no authority for this contention. They're wrong about the test, because the test doesn't require that it is in the public domain. But let's just test this proposition. So, this situation is almost, it is very akin to the DJP. I see I got your attention there.
I have to pay attention.
Allocating
in case there are costs that follows me beyond my retirement.
It's akin to the DJP allocating a case to a junior colleague. And in those cases, whatever is in the public domain, there is no obligation on the DJP to do a due diligence to work out precisely what is the involvement with this junior colleague who's being allocated the case. What is her involvement in the case to which she's about to be allocated? That's not the way it works. And in fact, it works like that across the profession. Attorneys who brief us don't do due diligence on whether we were involved in a case or not. Well, some do, because they, particularly the human rights ones, because they want to get you involved in the same case you were in before. But generally, they don't. They say, are you available? And then you say, what's the case about? And then you say, as the counsel, you say, I think I might have a problem here. They're not required to do a due diligence. So this requirement, or this argument, that one, it's in the public domain, you should do due diligence, find what's in the public domain, and then make the call, we say it is not the rule. But it's not just that it isn't the rule. It can't work in the context of the judiciary, in the context where judges, retired or otherwise, are being appointed to sit on commissions. And that's because, start with the presumption they will act judicially, fairly, impartially, with an open and inquiring mind. But that comes with a duty to disclose and disqualify on the angle or principles in all the cases that we dealt with, our predecessors dealt with. It comes with those duties. You've got to say, as the person being allocated the task, I think there's a problem here. And can I get back to you? And then you disclose, and then of course the person can make the call. But of course, in most cases, you find the judges disqualify themselves. They say, I'm not even going to get into a debate about what the precise nature of my involvement was. I was somehow involved in it. Leave me out of this. Give me another case, TJK. So that's why they just, families don't approach, they don't propose a sensible approach. And then we also say that their formulation is contradictory. So they contend that a basic due diligence by way of a Google search would have resulted in disclosure. Yet, even the families and their lawyers who were capable of doing a due diligence exercise on the prior involvement of the chair did not refer to the admitted fact that the chair had decided amnesty applications, and in some cases in matters involving their family members. And we don't blame them for that, because of course we don't expect that as litigants, potential litigants, they should do a due diligence of this nature on a judge. Then, the lawyers at Webber Wentzel did write a letter in which they did make an allegation about prior involvement in the HRIU, but even that was denied by their denial, but that was denied by the Commission, and we still don't know precisely what the facts are. So this idea that one must join the Instagram brigade and kind of trawl the internet for facts on judges just can't work practically in the context in which we're in. Then what they say, and this concerns not so much prior involvement in association, but the families say, well, why didn't you just remove Khampepe? We do say that the President is functus. It might well be, Justices, that you find that there's an argument here that he might not be functus. We submit that he is. However, this is the problem. Even if he's not functus, even if he did have the power of removal, after the review was launched, the President can't undermine or preempt judicial authority, that is, of the full bench, by then removing the chair. That would certainly not promote public confidence to be exercised by the President of the Section 84 powers, where, as the previous members of the executive are accused of political interference in prosecutions. And so we say it's a little bit of a red herring. It doesn't really matter at the end of the day. If he's functus, of course, he can't remove it, but even if he isn't functus, then we say to interfere would be damaging to public confidence, because it would be the President, a Trumpian, acting as he pleases. And we don't think that we submit that can be.
Yes. What about sending an emissary?
But again,
an emissary to the chairperson of the commission that to say resign? Is that not in the papers before us? Is that proper?
Yes, we submit that it is, and that's because he's entitled to ask the chair to avoid what we have here. He's entitled to ask her to consider. So he didn't send the emissary to remove her. He says, sent the emissary to ask her to consider removal. We say that is proper, and it is proper in the context where, again, it's about public confidence. So if the chair, after the emissary speaks to her, she considers the matter, takes advice, and then removes herself, well, then we avoid all of this. This idea that everything has to be litigated, just be careful, because of course we are concerned here with avoiding a public spectacle that is damaging in the public eye. So we submit that there were, I mean, there was no threats. He simply asked her to consider. I mean, in the context, Lord, we say that was proper. Particularly where he seeks to avoid where we are now.
Let me make another practical analogy. Would it be proper for me, once allocating a matter to a fellow judge, to whisper in her ear, so somehow send a go-between to say, recuse yourself? Is there a difference?
To consider it, yes. No, there isn't. My lord, that would not be improper. So if my lord becomes aware that a judge whom my lord is allocated a matter, my lord becomes aware that there's prior involvement, then there's nothing improper about it. Professionally approaching that person and saying, you should at least consider, there's an accusation of recusal, you should consider it, because it brings the judiciary into disrepute. And so one wants to avoid that. Same as here, it brings the inquiry into disrepute, and one wants to avoid that. And the President didn't simply remove her, he didn't act, it wasn't a knee-jerk reaction. He attempted to avoid damaging publicity and apparently my learned colleague has a lot more to say than she said earlier. She says I was put to my lord that my lord isn't functus in that situation. But my lord, we said it doesn't matter.
So she agrees with me, right?
Well, she might. We said, my lord, our submission is it doesn't matter in the end of the day. What the President can't be seen to be doing is damaging public confidence in the inquiry, public trust in the inquiry. And he does his best to attempt to avoid that. He doesn't succeed. And he now abides, again, my Lord's decision in the application for recusal. Unless there's anything else, those are submissions.
All right, it's 11 o'clock. I think we make amends in terms of time, didn't we? One moment, please. We are in day 2. And, yes. We are about, 10 minutes away from our usual break for tea. Yes.
I'm not going to use the time just because it's available.
No, by all means, thank you. Okay. Do you want to start, or should we adjourn?
No, my lord, I would like to adjourn because I want to upload a note on case lines. So I need the 10 minutes anyway.
I see. It's been a long morning. May we adjourn? Let's resume.
Mr. Ogo wants to speak.
My lords, my lady, it's not any submissions. It is just to notify the court that the National Prosecuting Authority has filed brief heads to deal with the issue of candor, because at this particular point in time, we did file a explanatory affidavit where we had asked very particular questions to the first respondent.
When did you file?
We filed that together with the condonation application, my lord. The heads are at 054-234, and the condonation application is at 062-1. And they really deal with our explanatory affidavit, more so what is covered in 006-10 to 006-13. The implications, therefore, of what this court should make of the silence of Justice Khampepe when being asked whether or not, when the allegation is put, whether or not she coached Semenya SC in the recusal application that was brought by the National Prosecuting Authority, because that has a direct impact on the National Prosecuting Authority's rights in this matter and their Section 34 rights to determine whether or not, well, firstly, how they enter this fray, because they've abided so far, and that abiding has been qualified.
Is that all?
That is all. Thank you.
I'm in your hands, my lord. I would like to get 10 minutes.
Which is granted. May we adjourn? Here we are. It's after tea. I'm sure we can proceed. Is the commission ready?
Yes, we are ready. Thank you.
You wanted to upload something?
Yes, it has been uploaded to section 054/246.
And what do we call it? What is there?
It is, I think it's called the Commission's Note for Argument. 17 March 2026, 054/246, 05428.
I beg your pardon? No, fair enough.
Yes, Your Lordship,
No, not so fast. I still have to. But did you advise your colleagues? Did you? Is there any objection from any one of them? Your opponents?
My lord and my lady, we don't know what it is. But notice on argument,
Yes.
we have no objection. If it will assist the court.
sorry.
We don't have any objection to the extent that there might be anything that requires any reply, further consideration. We will raise that with the court, but we have no objection.
Thank
Well,
you.
there are two more that have not spoken, but I guess the
No objection.
No objection.
Well, silence means consent, does it not?
Yes.
So where do we find that?
My lord, it is at 054/246.
How long is it?
It is until 054/280.
35 pages long.
35, yes.
All right, here we are. We have not read it, obviously. Yes.
Yes, my lord, I will be following that structure. You will find there that there is quite a lot of familiar references, because the idea is to keep some focus on what I'll be talking about.
I see. So for the moment, we should close the first chapter of your argument. Is that the point? You want to concentrate on this one?
Indeed.
Okay.
So what I plan to do is to run 4 arguments in the time I have. Hopefully, I won't run out. The first being the section 47 point. We'll raise a number of in-limine points, but there are only 2 that I'll be arguing today. It is section 47 and the question of the applicability or non-applicability of PAJA. Then I will go to the we have usefully referred to as the President Mbeki grounds of review, which is the Institutional Association grounds of review. And then I will look at President Zuma's grounds of review, which are the secret communications grounds of review. Now, my learned friends have suggested to the court that the question whether or not PAJA does or does not apply is neither here nor there, because they have referenced legality. Now, we take a different view. The question of applicability of PAJA must be decided, because it is from that decision that you can work out the standard of review. As the court knows, the standard of review for legality is narrower than the standard of review permissible under PAJA. And that is why that in limine point cannot be avoided. It has to be decided either for me or against me. And I will show the court all of the authorities that explain that the review for legality focuses on what is called the rational connection test. And so what we will be asking the court ultimately is not to consider whether from its own vantage point what it thinks the judge should have done, but it is to ask whether or not what she did can be reconciled with the rational connection test. If the answer to that question is yes, the review must be dismissed, because this is a legality review and not a PAJA review. So none of the section 6 of PAJA grounds are permissible in this case, because my learned friends are bound to challenge the decision only through legality. So I thought we should set that out clearly so that the court knows why we've spent some time in the note for argument trying to tease out the distinction. So let me start then with the section 47 point. The question of the status of that argument as jurisdictional or not is no longer pertinent now. It was pertinent yesterday when the court was being asked to make orders without having decided the section 47 point. Today the only issue is whether or not section 47 applies to Justice Khampepe in her commission, in her role as chairperson of the commission. That's the only issue. If I am right that the section applies, it is common cause that there has been no compliance. The consequence of that fact is that the proceedings should be declared pro non scripto or void ab initio. You have no proceedings in front of you. Now that distinguishes this case from the arguments made about piecemeal litigation. Because there is no piecemeal if there is no litigation in front of you. And so you have to first decide, do we have a valid case or not? If we don't have a valid case, we have to either strike it or dismiss it because it's an invalid case. In the second paragraph of our note for argument, we point out to paragraph 47 of the judgment by Judge Dipenar of Mantashe versus Justice Raymond Zondo, where she points out that the implication of section 47 is that proceedings cannot be saved absent prior consent. There is no room for condonation. The proceedings are void ab initio. So when our learned friends repeatedly say this is a question of mere statutory non-compliance, we submit with respect that they don't appreciate the full extent of section 47. When you look at the text of section 47, which we referred to in paragraph 3, again, it's been overlooked in a number of the arguments that have been made. But it's crucial to just remember what it says. It says no civil proceedings by way of a summons or notice of motion may be instituted against any judge of a superior court, and no subpoena in respect of civil proceedings may be served on any judge of a superior court, except with the consent of the head of that court, or in the case of a head of a court, or the Chief Justice with the consent of the Chief Justice, or the President of the Supreme Court of Appeal, as the case may be. So what it's doing, it's regulating two categories of legal proceedings. The first category is civil proceedings. The second category is subpoenas, which is interlocutory proceedings in relation to civil proceedings. So you may not issue a subpoena against a judge, and you may not issue a notice of motion against a judge. It is common cause that a review application qualifies as civil proceedings. So again, we have no quibble with our learned friends about whether these proceedings qualify as civil proceedings. It is also common cause that they have been instituted. It is common cause that a judge has been cited. There is a dispute about the capacity in which the judge has been cited, but it's common cause that a judge has been cited. Now, when we raise this point, the argument that we are met with is summarized in paragraph 5 of our note by President Mbeki. And what they basically say is that Justice Khampepe is not performing judicial functions. She's performing chairperson of commission functions. And her powers are derived from the proclamation. That second premise is not correct. The SARFO case makes it clear that the powers of the Commission are original constitutional powers, sourced in Section 85 of the Constitution. They are exercised through the Commissions Act of 1947, and they are defined in scope by a proclamation. So it's inaccurate to claim that the powers exercised flow from the proclamation. They flow from Section 85 of the Constitution. So President Mbeki is not only wrong about that, but he is also wrong in trying to draw the distinction between a judge in a, I would say, court setting and a judge in a commission setting. This was the distinction that was drawn by Justice Moshwana in Memela, which we cite at paragraph 6 of our heads of argument. But that issue was dealt with and decided by Justice Dipenar, as the court would be aware, which we point out in paragraph 7 of our note for argument. And in paragraph 8, we say there that the judge made it clear that Section 47 is peremptory, it applies to review applications, and that no service would be permissible upon a judge unless consent has been sought from the head of that institution. Now, Mr. Mpofu said yesterday that he doesn't know, or his client doesn't know, who is the head of the court of a retired judge. We don't think that is a serious argument, because at the time of the retirement, a judge is attached to a particular court. So it does not actually seem to be particularly difficult to work out that a retired judge of the Constitutional Court, the head of that court would be the Constitutional Court itself. Now, what Judge Dipenar said in paragraph 46, which we cited paragraph 9 of our note, is the following. I conclude that Justice Zondo, acting as the chairperson of the commission, was thus performing a judicial function, even if a distinction were to be drawn in Section 47(1) between judicial and non-judicial functions, which the provision does not do. And I started by just looking at the text of the section. You see the section is actually quite a wide section. It doesn't have the qualifications that are being introduced by our learned friends. And which the authorities do not support. The chairing of a commission of inquiry falls squarely within what are ordinarily and legally considered to be judicial functions. Consent under Section 47(1) of the Act was thus required. So we submit that the same logic applies here. We are asking the court to find that in the absence of prior consent having been obtained, these proceedings are a nullity. Now I'm going to go and explain on this argument that is made that the Mantashe case was wrongly decided. I'm going to show the court that when you actually look at the judgment by Justice Mlambo in the Motata case, who says what you actually ought to do when you are looking at Section 47 is to construe the text and its purpose, which I don't have to educate the court about that because that's old law. But when you look really at what the purpose of Section 47 is, you see why it's worded as widely as it is. Because it would have been easy for the legislature if it wanted to carve out a space for active judges not in retirement to say so in legislation. It would have also been easy for the legislature, if it wished to leave out judges that are performing judicial functions, to specifically use that wording. And here there is absolutely nothing in the Act that talks about the performance of judicial functions. It simply says no proceedings against a judge. Now, on paragraph 11, we say, on the strength of Mantashe, it is clear that the present application can go nowhere. Insofar as the applicants have failed to secure the requisite permission for these proceedings, in the first instance, such failure is dispositive of the matter, and it follows that the Honorable Court need not consider the remainder of the applicants' contentions. So in paragraph 12, 13, and 14, I'm not going to argue that it was relevant yesterday. This note was prepared for them. It's no longer relevant today because we've got to the merits of the case. So if you look then at paragraph 15 of the note, the arguments in support of the contention that section 47 of the Act does not apply rests on two grounds. There's a third ground that was introduced today by Mr. Mainecha. I'll address it. The first is that Justice Khampepe is a retired judge, and the second is that she is cited in her official capacity as the chairperson of the commission. The third judge is the general reluctance of courts against piecemeal litigation. I've dealt with the piecemeal litigation because this is a question of deciding whether you have valid proceedings in front of you or not. Now, in relation to the first argument, retired judges, Mr. Mainecha says that judges, she said this yesterday, judges remain bound by their oath of office even after they have left office. That's what he said. That is true, we accept that. They may be called upon to perform service such as chairing of commissions of inquiry, and this is already recognized by the court in Mantashe, where in paragraph 37 it says, Memela also disregards that by statutory definition in terms of section 1B of the Remuneration Act, the functions of a judge include service as chairperson or member of a commission. Thus, the very function which Justice Zondo was performing as chairperson of the commission. So if you look at that definition there about what service means in relation to a judge under section 1B of the Remuneration Act of Judges, it includes the function of chairing commissions of inquiry. It's not by mistake that they are called judicial commissions of inquiry. And then we say the same finding appears in Freedom Under Law versus Motata. And that's the judgment I promised I would revert to. This is the judgment of Mlambo JP, who says the import of this provision is to buttress the underlying rationale that retirement cannot be construed as contended by full to lead to loss by retired judges of the protective mechanism of section 47.1. I hold the view that properly considered, the word service in this section must include judges who are retired but who continue to either perform judicial functions when called upon to do by the minister in line with D, or have been appointed to perform other functions as provided in the section in other capacities. In other words, section 47 ought not to limit the scope of application of the leave to sue doctrine to only judges who remain in active service. So you are called to perform other functions, or you are called to perform, you are called to serve in other capacities. That's the language. So clearly, this is what the judge continues to say. Clearly, the immunity implicit in the section also extends to those retired judges who remain in service. So that's not an issue here. It is therefore conceivable that Mbenenga JP's conclusion in NP versus LP could be correct in a matter where the retired judge sought to sue has not featured and will not be called to render any service whatsoever. That's not what we are dealing with. We're dealing with someone who has been called by her own president to perform a public service, which is defined as one of the duties of a judge under section 1B of the Remuneration Act. However, this is subject to what I say in the following paragraph. So that's the support for the argument we make that the effect of retirement does not denude a judge of the protective mechanism of section 47.1. And we rely on Mantashe as well as freedom under law versus Mutata. So, and it would also be illogical if you think about it carefully. Why would you protect a judge in service versus a judge who is retired? The only reason why Section 47 exists is to secure the independence of the judiciary against frivolous attacks. That's the reason cited by Justice Zuma. Now you have to ask then yourself the question, does that reason go away when a judge is performing the function of a judicial commission of inquiry? You've listened to a day and a half of argument. Every speaker who has spoken to you tells you about why it is so important that because it was a judge who was appointed, the independence of the judiciary should have been preserved. Every speaker who has spoken in this case has emphasized that point. So what that means is that the distinction between a judge in active service and a retired judge is an illusory distinction. The bottom line is that Section 47 is intended to protect all judges. All judges. And you can't actually think, if you think the radical consequences of protecting a few and excluding the other, what would be the rationality for that distinction? It cannot simply be on account of the fact that you have retired, because you don't get that from the text of the section. And you also have this problem that the purpose is to protect judges, and judges are judges for life. That then takes us to the second argument, which is, what about the capacity in which the judge has been sued? But there is a range of capacities in which judges can be sued. A judge can be sued. I had a look at another case involving a judge from Pretoria. So someone is sued for non-payment of levies in an apartment where they stay. Even in those cases, the authorities are clear that because you're going to sue a judge in their personal capacity, you have to obtain leave under Section 47. Or a judge may well be sued in their official capacity. So someone was delivering a judgment, and someone is specifically trying to cite the judge because they believe that in the course of delivering that judgment, the judge committed an irregularity. So that's an official capacity. But they cite there, it's Party A versus Justice Modiba. In those instances, well, not because there will be any litigation against you, Justice Modiba, but let me use the presiding judge as an example. But they specifically cite there, they say it's Party A versus Judge B. They are citing them in their official capacity. But even in those instances, it would be necessary to obtain leave of the head of the division to cite those judges. And the same applies here, where we are dealing with a retired judge who's performing official functions called upon by the President, which are recognized under Section 85 of the Constitution, that you still are required to comply with Section 47. Why? Why do we say that? We say that by reference to paragraph 16.4 of our note. And I'm going to say a few things about this paragraph. Because Justice Mlambo says here that in essence, the section seeks to insulate judges from unwarranted and ill-conceived legal proceedings aimed at them. So that's the purpose, is to protect the judges from unwarranted and ill-conceived legal proceedings. And then he says, the need to protect judges from unwarranted litigation is not difficult to follow. The core function of judges is the adjudication of disputes involving competing interests daily. The judgments they hand down, as well as the statements they make in their judgments, invariably displease some litigants and sometimes their legal representatives. It is integral to the adjudication function of judges that they be free from any fear of repercussions for doing their work. Now, if I could just stop here, if you go to paragraph 36 of the founding affidavit by Mr. Zuma in this case, perhaps we should do that now. you will see precisely the problem that we are dealing with. So that's, your lordships and my lady will find that 001/18.
Are we still being directed? There. Thank you.
Yes, I think you have been directed, my lady.
Thank you.
So if you go to paragraph 36, now what we know here is this: the reason you have section 47 is to insulate judges from an attack against their character as a consequence of judgments they delivered. Look at paragraph 36 in these proceedings, these review proceedings. It says here, this is Mr. Zuma speaking, all of the above naturally added fuel to my own personal reluctance, pre-dereliction, and or strong discomfort at the prospect of expecting fairness from the chairperson, given her leading role in writing and handing down the two judgments which led to my unfair, improper, and irregular detention without trial in July 2021. Sorry. So this is precisely what Justice Mlambo is saying. He says you need section 47 in order to protect a judge against a character assassination flowing from the performance of their judicial functions. We don't have to speculate here. This application is an attack against Justice Khampepe because of the role that she played, according to Mr. Zuma, in delivering two judgments that led to his incarceration.
Does it matter that this ground is no longer persisted with?
No, not for the purposes of section 47. Because the attack is there. And if an application had been made, the judge looking at it would have said, look at this attack in paragraph 36. And you know, my lady, there was no need to include paragraph 36. No need at all. It was included intentionally to character assassinate. Now, this is precisely why you cannot actually draw these distinctions, because you have a scenario where a litigant has come to court to specifically say, I've got the following grounds, but these grounds have been accentuated by an animus on the part of a judge. Where does the animus come from? From a delivery of a judgment. Then,
Is it your motivation that paragraph 36, there's no need because the highest court in the land has spoken?
yes. Yes. There is no need to attack a judge on the ground of a judgment they gave as part of a bench of the Constitutional Court. The only reason one can think about is character assassination. Now you have to ask yourself, if Justice Mlambo is saying the purpose behind section 47 is to protect judges against attacks on their character because of judgments that they gave, and here we've got a glaring example of that attack, why then should the section not be held to be applicable? Now it continues here in the paragraph I've cited. It is integral to the adjudication function of judges that they should be free from any fear or of repercussions for doing their work. Now think about this. A judge is sitting, delivering a judgment in the normal course of their work. It's a contempt case. They believe that in good faith, the person should go to prison. Years later, the same judge is appointed as a commissioner in a commission of inquiry. So what the section intends to do is to deal with this problem of the chilling effect. It is truly chilling that you can have a litigant with a free rein to come to court and character assassinate. because of a judgment that was delivered. And that's the loss of the protective measure that Justice Mbeki was talking about. And what he says that it's necessary to enable judges to be free to do their work, knowing that if there is litigation that will follow them from the time they have retired from the bench, that litigation will be taken through a safety valve before it can be approved. And then in the end, which was cited, it says, this is necessary to ensure that they adjudicate disputes unhindered and that they do so without fear, favor, or prejudice. So we say here, these observations apply with equal force to the work of a judge in a commission of inquiry. They explain why Section 47 must be applied and enforced in this case. The duty to chair a commission of inquiry is a core function performed by retired judges. To do this, the judges require the protection of Section 47 so that they can discharge their mandate and functions without fear, favor, or prejudice. In paragraph 18, so we say that the purpose of the section is then dispositive in addition to the text. The text does not contain the limitations argued, but the purpose of the section actually shows why you have to apply it in an extended rather than a restricted fashion. So we have in paragraph 18 gone through the allegations that are made in the founding affidavit, which show why the protections are necessary for judges. We've already referred to paragraph 36, but we also refer to paragraph 42. We refer to paragraph 84. We refer to paragraph 85. We refer to paragraph 89.3. There's an accusation of an ulterior motive, which again strikes at the heart of the judicial function. Judges should not be accused of improper motives. In circumstances, my learned friend is chapping away behind me, so maybe he should give a note to his juniors. Mr. Mpofu is notorious for doing it, but my learned friend is not. So it's very strange today.
Lord, I take great exception to the gratuitous remark. And I'd like the court to protect me. This is serious, not a joke.
And my lords and my lady, I must point out, I did chuckle with my learned friends about something completely unrelated to this case. So I don't understand what I'm being character assassinated for.
Can I make the following general observation? I'm sure I would have the support of my colleagues in this regard. To start with, talking in court when the court is in session loudly. I'm not talking about when you are taking instruction, when you are consulting with colleagues, but when it is loud, perhaps it might interfere. I suggest that in that case, please try to lower your voices so that you can then engage with colleagues as you may find it necessary. But in relation to the case that Mr. Mpofu mentioned, that he requires protection, I think my understanding is that he mentioned that well, he said that you are known for that, but in this case you are not. Perhaps that was not a fair comment.
No, it was not a fair comment. I apologize to Mr.
Oh, there you are. There you have it. Then, I'm relieved.
He saved the day. I don't think I was going to get the protection.
No, I really apologize to Mr.
No, you are protected, Mr. Mpofu.
No.
In court you are, Mr. Mpofu. All shall be equal before the law. You are.
But the point is that, Mr. Maineche, when I say judges should not be accused of ulterior motives, he says loudly, why not? And then he claims that, no, he's talking about something unrelated, but I can hear him, so I have no apology for something like that.
No, with respect, I'm saying why not to comment on an unrelated matter. That's the point I'm making. And my learned friend, I did not ever accuse him of anything when he was sitting behind me and he was taking instructions and he was commenting whatever the comments were. And it is very unfair for him to place on public that I am challenging a submission that he's fairly making to this court. My challenge will be in reply and not in response to him making submissions.
Mr. Manager, I'm sure you heard my observation.
I did, but he repeats the accusation.
Yes.
That is unfair, because he didn't hear what I was being advised on the side, and I'm responding to that, and he suggests I'm responding to his argument. I ask him to apologize for that and retract that accusation.
No, my lord, I'm not apologizing for anything.
Let's not be distracted.
Because
Can we
I
get back
actually
to
had,
the...
I had it, so.
Let's not be distracted. Let's get back to the case.
Thank you, my lord. Now, that deals with the accusation is there that at page 12 of the note, 054/257. And then again, if you look at the following paragraph in footnote 13, paragraph 50, preordained for any specific individual. Paragraph 58, conduct which is unbecoming. So the fact of the matter is that the founding affidavit is packed with insults that have no foundation. And one of those insults is specifically directed at the former judicial role played by Justice Khampepe. Now, that simply stresses the need why Section 47 should be applied on the facts of this case. In paragraph 19, we've said that not only are these allegations repeated in the founding affidavit, they are also incorporated by reference because the recusal application is incorporated in the founding affidavit. We've dealt with those from paragraph 19 of our note for argument. At paragraph 24, 28, 29, and 31 of the submissions that were made before Justice Khampepe. And that's why we conclude in paragraph 20 by saying these attacks are unfounded. They also show that it is incorrect to contend, as does President Mbeki, that Section 47 should not be applied here because the case does not involve the performance of judicial functions. The attacks that we have tabulated above go to the heart of the judicial function. They show that the separation contended for by the applicants between a judge's judicial function and other functions are illusory. Justice Khampepe is being attacked for the role that she played as a judge of the Constitutional Court. She is being asked to recuse, she was asked to recuse herself because of the role that she played as a judge. This is precisely the reason why Section 47 exists. Its purpose is to protect judges against unfair attacks against their judicial and non-judicial functions. You remember the portion I read from the judgment of Judge Motata, where Justice Mlambo says you may be called to perform judicial and other functions, but in either of those capacities you will be protected by Section 47 because of the width of the section. In paragraph 21, we say it is important to state that the section on its terms does not draw the distinction between judicial and non-judicial functions. That shows that the section to achieve its aim, that for the section to achieve its aim, it must be applied as widely as possible. This is simply because judges, retired or not, deserve protection from litigation that is not justified and which emanates from their functions as judges. But we go further than this in paragraph 22. We say you have to take into account the special character of a commission of inquiry. And that's why Mr. Mainecha's references to arbitrators is actually unhelpful for this court. You have to take into account the special character of a commission of inquiry. It's public service. You are being called upon by your president to perform public duty. You are entitled to expect that the usual statutory protections will apply. Says, this case also shows that retired judges performing public service are especially vulnerable to abuse. Justice Khampepe has been threatened and insulted. She has been threatened with precca. She has been insulted. I've shown you all of the insults. She has been accused of criminal conduct without a shred of evidence. Judges in her position deserve the protections of Section 47. She is performing a public duty on a matter of national importance. Yet, personalized attacks have been directed at her with reckless abandon. She has absolutely no one to protect her. Let's be serious. She really has no one to protect her, including the very president who appointed her. She has been left to dry on her own. And so the only legal protection, which is what in paragraph 23 we say, the only legal protection that Justice Khampepe has right now against the personalized invective is Section 47 of the Superior Courts Act. And there is simply no reason why it must be taken away from her. It was specifically designed to protect judges in her position. It's impossible to work out why she should not obtain the protection in that section, especially because Justice Mlambo says it is a protective section. That's the real purpose behind it. We have addressed then the issue of whether or not Memela was correctly decided. There are two fundamental problems with the Memela judgment as identified by Justice Dipena. Problem number one is that it ignores the text of the section. It introduces limitations to the section which are not contained in the section itself. Now, it is a wrong approach to statutory interpretation to define your own limitations which is not contained in the section itself. So what you should have done, what the judge should have done, is to give effect to the words as they are. The second fundamental problem is that it distorts the purpose of the section. And the consequence of that is actually quite serious because it leaves judges who are retired, who are actually at the most vulnerable because they are no longer have the power of the governor. It's better with active judges because of the power of the governor. But as soon as they retire, they lose even that power. And therefore they are especially vulnerable to unmeritorious criticisms and accusations and attacks against them. And so that's the second fundamental problem, is that it ultimately distorts the protective ambit of that section. So that's what we deal with in paragraph 24.1 and 24.2. The last point on this issue is that toward the end of Mr. Mpofu's submissions yesterday, he asked for a personal cost order against Justice Khampepe. Now, I don't want to argue right now whether it was justified or not.
Oh, why not? Why don't you want to argue now?
No, I will not argue in this section of the argument.
Oh.
I'll deal with it later. But I want to just make one point, which is it illustrates why Section 47 is applicable. Because these are not costs that are going to be borne by the office. These are costs that will be borne by the individual, the person. And so if the purpose behind Section 47 is to protect judges in their individual capacities, that protection goes, and a personal cost order is being sought in circumstances where Section 47 has not been complied with. And that simply illustrates the point that you cannot actually have it both ways, where you come to the court and you say, this is not about you, the person. And in the middle of that litigation, it becomes revealed that actually your strategy is a personalized strategy as manifested by the ask for cost. So if anything, it simply reinforces the need to protect, to put the protective shield against the, in favor of judges, if you're going to ask for a personal cost against them without notification. So we submit, therefore, that it's quite clear that Section 47 applies. The distinctions that are being drawn by our learned friends do not apply. The purpose behind the section would be defeated if you drew the distinction that is being asked for, which is not even part and parcel of the statute. And if you are being asked to make a choice between Memela and Mandasha, unquestionably, the Mandasha judgment was correctly decided because it recognized the text of the section in the context of its purpose, and then it sought to apply it. But we say, in addition to that, you have to look at the facts that have been alleged in this case. And fact number one being the specific reference to a judicial function, and fact number two being the request for a personal cost order. So those considerations simply show that you have to apply Section 47, and you have to take these parties back. These current proceedings are pro non scripto. They must go and start afresh.
Mr. Mugaitobi, there's a point Mr. Manager made in his written submissions, but he didn't touch on it when he addressed the court, and I want to get your view on that. He submitted that because these proceedings flow from a dispute that Justice Khampepe has adjudicated on, a ruling of which is reviewable by this court, then in those circumstances, Section 47 should not apply. What's your view on that?
Well, let me make it like this. Section 47 applies to all civil proceedings, whether they are review proceedings or not review proceedings, as held in the judgment of Mandasha. It is in the same way as Justice Zondo has given a decision as a commissioner, and his decision is sought to be challenged. And when the challenge is brought, the question is whether or not the applicant should obtain the leave of the Chief Justice. The argument is the same. It doesn't matter that in this case the decision is a recusal decision. It's still a decision made by a judicial officer performing a non-judicial function, although there's a substantial overlap between judicial and non-judicial. And so if you want to challenge that decision, you have to obtain leave. It's as simple as that. It doesn't matter that there was a ruling made by Justice Khampepe. Justice Zondo also made a ruling, but to challenge that ruling, you have to obtain leave. Even if you had, I see the presiding judge wants to speak.
I'll wait for you to finish.
I'm saying that even if you had, take a different example, if you had made a ruling as a judge sitting where you are, and someone then came to court and said, I want to review it because the judge committed an irregularity, it would still be necessary to obtain the leave of the court, the leave of the judge president, because it's still litigation against a judge. So once civil proceedings encompasses reviews, it must include reviews flowing from the decisions made by the very same judges.
As a follow-up, perhaps, he made reference to numerous other citations. I haven't had time to look at those, where judges are cited in their official capacities.
Yes.
What do you say to that?
No, we obviously agree that there have been those cases in which judges have been cited in their official capacities. But it's clear that there is a body of jurisprudence that has developed that makes it clear that you cannot actually sue a judge or cite a judge, whether it is nomine officio or whether it is in their personal capacity, except by obtaining leave of court. And those authorities the judges are familiar with.
My question is, in those instances, was permission sought? Remember, Section 47.
We just don't know. It's possible
Section 47, there was a previous section,
25.
Yes. So I will be keen to know whether in all those instances whether prior permission was sought from the head of court.
No, we just don't know. I mean, I know that there has been a lot of references to the Corruption Watch case. And when I read that case, I didn't see any discussion there about whether permission was or was not sought. It seems that we are being asked to make an inference that it was not sought. But I don't know as a fact. And what is interesting in that case is that one of the judges who sat there is the JP, and the judges who did the commission were judges in his division.
Which JP?
One of the presiding judges was Justice Mlambo.
Oh,
And the
yes,
judges,
it was.
Yes, and the judges who's, Justice...
Davis and Leo.
Yes, yes. One of the judges was actually a judge in his division. But to answer your question directly, Your Lordship presiding, I don't know because we just don't have these facts. If you look at the decision of, I think it's the former JP Ngwebe, what he says is that usually these are very informal requests. A letter is written and then it's given informally. It's not like there's a judgment written which would be available on SAFRI. So the fact is that we just don't know. And it's going to be extremely dangerous to make a ruling on assumptions which we just don't know. What we know are cases where a Section 47 objection is taken, and that forces the judges to then write judgments. And the most recent now is October 2025, that actually these proceedings are pronoun script. Thank you, my lord. Justice Modiba, I'm not sure if...
I'm
thank you.
answered.
All right,
Thank you.
Could I then move from this topic, having made it clear that we say that you should strike it, dismiss it, declare that it was pronounced scriptum, to deal with the second question, the second in limine point, which is the question of the applicability of PAJA or not. I tried to suggest at the beginning that the reason why it's important for us and for the court is because it defines the parameters of the review grounds, so that you are not all over the place trying to work out what are the grounds that are permissible for review. You've got to decide it right at the beginning to say this is a legality review, and because it's a legality review, we are confined to the following grounds of review. And then the exercise is thereafter about applying those grounds to the evidence. So the departure point in paragraph 27 of our heads of argument is SARFU, paragraph 147. And SARFU makes it clear what the character of a commission of inquiry. It's referred to as an adjunct to the policy formation responsibility of the president. So an adjunct is support or assistance. But that is where it falls. It falls within the policy-making realm. And that is why later on they say the appointment of a commission does not constitute administrative action. So the act of the president to appoint a commission wouldn't be administrative action. What they don't decide in the SARFU case is whether the subsequent act of the conduct of the commission would or would not be an administrative action. But I'll show you now it's actually also been decided. But what's crucial here is that if you're trying to think about the spectrum of public power, from executive to administrative, commissions of inquiry are on the executive side of the spectrum because their function is a policy-making function. So they're trying to assist the executive branch of government to develop policy. And usually commissions are appointed to investigate matters of public concern, usually after a big scandal or usually after a big calamity. But they are on the policy-making executive side of the spectrum. They are not on the administrative side of the spectrum. Now that has enormous implications for the analysis. If commissions of inquiry fall on the policy-making side of the spectrum, that has enormous implications. From the case of Mutau that we cite in paragraph 28, sorry. What that is clear there is that this is distinguishable. In other words, the policy-making function is distinguishable.
I'm sorry to have to interrupt you. I remembered, and I do now, I've just confirmed this, in the composite replying affidavit by Mr. Zuma, by former President Zuma, you'll find that they rely on legality and not perjury. Does that answer your concern?
No,
In reply.
yes, I understand that, my lord. If the court's view to me right now is that perjury is not a subject matter of deliberation, then I will not make the address I'm about to make. If perjury remains a point of contention, then I have to explain to the court why perjury does not apply. If the issue is the only ground of review is legality, what I cannot do is to leave the situation unclear. So if your lordship is saying the reply abandons perjury, that's a different matter altogether.
It does indeed, as a matter of fact, in paragraph 155.
Yes.
Am I right?
No, you're wrong.
Or am I wrong? Okay. So there you are. Please go ahead. I thought I'm reading what is written.
No.
No, I'm sorry, Mr. Mohammed. My lord, yes, if that was indeed the case, then we would not have addressed this objection in our heads.
Well,
That
perhaps you'll,
perjury doesn't apply.
perhaps you'll address me, because let me
Reply.
quote in full paragraph 155 of this composite replying affidavit. It says,
155.
yes, I admit that the relief sought against the president is solely based on the principle of legality and not perjury. I'm quoting verbatim what's written.
Okay, let me just check. Oh, if your lordship could just read that to me, okay?
The composite replying affidavit by the president, Zuma, paragraph 155.
155.
Yes. Do you want me to read it aloud again? You will find it on case line is 017-33.
017, I'm there, 17 dash
017-33.
33.
Yes.
Okay, just a minute, 1 second. Yes, I'm there.
I'm told I'm wrong.
150.
I'll wait patiently.
Yes, please do. What, which paragraph?
155.
155.
Yes.
Against the president. So, no. It's the president of the country, that's Mr. Ramaphosa. So it says, I admit that the relief sought against the president is solely based on principle of legality, not perjury. That is the 10th respondent only.
I see.
Yes.
Thank you for
So
that clarity.
you're wrong, my lord.
It's okay. We sometimes are wrong.
You know.
Yes, I won't
happens to
defend
the
that.
best of us.
Yes. I'll be the last person to say. So, well, they remove the word the chairperson there to mean the president. I thought we were referring
Yes.
here
No,
to the
it was just
first
so
respondent.
Yes, just so that we don't get back to it. It was merely on the question of the relief. Remember that alternative relief against the president in prayer 6. So we admit that that can only be solely based on perjury, or rather on legality, because executive decisions are excluded from perjury. Yes.
Be my guest, Mr. Ngogetoi.
Well, I was asking if Mr. Maineche wants to clarify his position so that I address that as well.
I'm afraid to speak, I'll speak in reply, ma'am.
All right. Well, we learned a few things in the course of argument. But, my lord, I think it's clear that I have to address the court
By all
on
means.
this issue. I can't take chances.
Yes.
Yes. So, we are at paragraph 28 of the note. And so the point I had made by reference to SARFU is that commissions of inquiry are on the executive side of the spectrum of public power. Now, the consequences of that submission are enormous because of what is stated in the Minister of Defense versus Mutau in paragraph 29 in the ITEC case versus Score Metals, in the Scalabrini case. Yes, those are the three leading cases on this point. That if you're going to attack exercise of public power, which is sourced in executive rather than administrative functions, you've got to be very, very careful, because the standard is necessarily differential. Insofar specifically as the question of whether the decision by the commissioner constitutes administrative action or not, that is addressed at paragraph 31 of our note in the judgment of court. It's a decision of the full court of the Western Cape Division, where it is stated there, the decision to investigate and the process of investigation could exclude a determination of culpability. Therefore, such a decision is not final, nor can it be said to constitute a decision adversely affecting the applicant's rights. In the circumstances, it cannot be said that this recommendation constitutes an administrative decision which may be reviewed in terms of purge. So here's the point. When the commission has finished its work and it produces a report with findings, all of it is done, it's got findings and recommendations, that will not be administrative action. Why? Because of the absence of adverse effect. Regardless of what wrong it has done in the course of the investigation. It wrongly finds that you were at a particular place at a particular time, wrongly. And this was the case made by Mr. Korabi. He says, look, you've made an error, you didn't give me out, you didn't even invite me to your proceedings. Right? The full bench says that is not administrative action. Why? Because the nature of the commission is investigatory and recommendatory. In other words, it can never adversely affect your rights at all. And then they make it clear that your rights will only be adversely affected. So let's take the example we're dealing with. Justice Khampepe makes a recommendation that, as a matter of fact, there was political infringement with the independence of the NPA in relation to these cases. And I recommend the NPA to prosecute President Mbeki as a theoretical postulation. Now, that will not be administrative action. He will not be able to come to court and challenge it on administrative law grounds. Because the judges have said it will only have an adverse effect if there is a subsequent action that is taken by the body to whom a recommendation is made. Now you have here a very odd scenario, which is internal preliminary decisions, not even the final outcome of the commission, internal preliminary decisions are being attacked right now on the grounds of adverse effect. That ruling on recusal can never have any adverse effect whatsoever. No matter how wrong or how bad it is, it can never have any adverse effect, because it is an internal decision in the context of a commission that is ongoing, in circumstances where even the final outcome of that commission will not have an adverse effect.
Because, as I understand your argument, it's merely it's have to make recommendations.
Yes. That is their function. The only function is we investigate, we make recommendations. Those recommendations are not binding on anyone. And what is actually even stronger in this case, in favor of the argument that there are no adverse effects, is that this commission's report does not go to the NPA for prosecution. It goes to the president. And the president makes a decision whether to accept or not to accept it. So
we already have his view in this regard, right?
Well, my lord, we only have one view. We don't have a view of the commission.
Well, yes.
We have a view about the chairperson of the commission. What we don't know is when the report is produced, whether or not the president will act upon it or not act upon it. We don't know whether substantively he will disagree with the outcomes. And quite apart from the fact actually that if he really wanted to remove the chairperson, he should have removed him. He should have removed him. It's as simple as that. He should have removed the chairperson. There's no reason why we are in this merry-go-round. If he says, I don't want it, then remove it. It's as simple as that. Why leave it to the judges? I mean, this kind of abdication is just intolerable. So what we know here, which is the point I'm driving to, is this. The final outcome of the commission will not have an adverse effect. Preliminary rulings do not have an adverse effect. No matter how wrong they are, they have no adverse effect whatsoever. So a person who finds themselves in a situation where a commission of inquiry has made recommendations, they never received a notice to appear, but they suddenly find their name and their recommendations. They have been told by judges that it is too early to come to court because the action has not crystallized into a stage where your rights are adversely impacted. This is precisely where we are in this case. The recusal decision has not crystallized to a stage where any rights are adversely impacted. And that is why when you actually try to drill down, well, what rights are they talking about? You get generalizations about fairness, about independence, about neutrality, etc. But no actual rights of theirs are impacted because they can never be impacted by a commission, because the commission can never take any action adverse to them at all. Section 3 of PAJA, which is the section that confers the right to administrative justice, contemplates rights to be implicated. So, for instance, someone is in receipt of a social grant, a substantive right. Somebody is in receipt of a social grant. You want to take it away. The law says in those circumstances there are certain prerequisites that you need to comply with. What that section doesn't contemplate is an abstract argument that I don't want to appear before this person. So PAJA has been expressly excluded in the context of commissions of inquiry by the Korabe decision. But we say that even if you remove PAJA and you are left with legality as a ground of review, the question of adverse effect must still be decided. The applicants must still show the adverse effect of the ruling on their rights. And they cannot show that simply by saying we don't want to appear before this chairperson because we perceive them to be biased, because that perception is irrelevant, because it can never produce an adverse effect, because ultimately that chairperson will make a recommendation. That is the judgment in Rhino Oil and Gas Exploration in paragraph 32 of our note. This is a judgment of the Supreme Court of Appeal applying the same doctrine about finality and adverse effects on the principle of legality. And you can see there that to go to court and challenge a decision on the grounds that it infringes Section 1C, you have to show that the decision adversely affects your rights. And one of the mechanisms of illustrating that the decision adversely affects your rights is to show finality in the decision, but it is to show an actual loss of an entitlement that you have in law. So whether one is thinking about PAJA as per the Korabe judgment, or whether one is thinking about legality as per the Rhino Oil decision, the fact of the matter is that both applicants remain non-suited because they have challenged a decision that has no adverse effect on them, because they can never be adversely affected by a commission of inquiry. No one can ever be. And that is why what you ultimately think here is things like reputational harm. But everybody knows that reputational harm does not give you an entitlement to go to court. You can go to get a PAJA relief. You can go to court and get damages claim if you've got a defamation issue. But there are just no rights that are affected here at all. certainly none that are adversely affected. And that's why we say in paragraph 33, neither adverse effect nor prejudice has been shown. A commission of inquiry cannot prejudice anyone. That is because its recommendations and findings are not binding. A legality review is not available at this stage for the same reasons mentioned above. The decision lacks finality. So Paja then is out of the equation. We submit legality is out of the equation. But if you want to entertain this review on legality, what is the touchstone? We deal then with paragraph 35 of our heads of our note for argument. So Mr. Manage says it's been proven right. I've mistakenly referred to this as heads of argument. So what is the standard of review then if it's a pure legality? The first case is Law Society, which says the power must be exercised in good faith. It must not be misconstrued. It is there so that the repository of the power stays within the vital minutes of the power conferred and being exercised. That's the first, that's the outer parameter. So you should not act in excess of power, ultra vires. So legality starts off, don't act outside of the power. If you are within power, legality says, well, don't act irrationally. In paragraph 36, we say, therefore, any challenge to exercise of public power through the principle of legality is constrained by rationality and ultra vires. But rationality is not a master key that opens all doors, anytime, anyhow, and judicial encroachment is permissible only where it is necessary and unavoidable to do so. And we've cited paragraph 38, 39. Paragraph 40 says rationality is a safeguard against arbitrary action. It only requires that decisions must be rationally related to the purpose for which the power was given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. And paragraph 41, I don't need to deal with that. So the reason we've had to go through this route is to show that the case can only be limited to legality. If it is limited to legality, it can only be an ultra vires case and a rationality case. If it is a rationality case, that is a differential standard. The purpose of a rationality review is to check a rational connection between the decision and the evidence, or between the decision and the purposes for which the power was granted. That is a light touch standard. But also, reviews for legality do not contemplate a decision as to correctness. So even if you took the view that sitting here as a judge of the High Court, I think that Justice Khampepe should have handled this differently. You are not allowed to interfere with her decision because the standard through which you can do so is a standard of rationality. So against that standard, we can then look at what she is accused of having done wrong. Number one is the issue of the test, that she got the test wrong. We deal with this at paragraph 43.
Which test?
The test for recusal.
For recusal.
Yes, yes.
Remember, there's the test for delay as well, which is being accused of not applying correctly.
No, I accept that. I think what I can say about delay is that it's actually very strange that President Mbeki is raising an issue of non-delay, bearing in mind that he tried to intervene in the case that was brought by the current applicants for the setting up of the commission. Bearing in mind the two facts that Mr. Manesha spoke about. Number one, that President Mbeki was aware that he was denied amnesty, including President Zuma. They were aware that they were denied amnesty by the TRC. They were also aware that this commission would be investigating matters related to executive interference with the NPA. Precisely because, and I'll show the court the judgment of Rodriguez. So on the day this commission was appointed, with the chairperson being Justice Khampepe, the clock started ticking for them, because they knew that they were a subject that had been denied, and it's on the grounds that they are advancing. I'm going to show you that these grounds are invalid anyway. But even on the grounds that they are advancing, they should be non-suited for delay, because there can be no debate that they were aware that we are the subjects of the parties that were denied amnesty, and therefore we are prosecutable, but we have not been prosecuted. And they were also aware that this commission is about political interference, and they knew the Rodriguez judgment, and they knew the accusations that were made by Advocate Vusipikoli, that they had interfered with the prosecution of these cases. So it's actually very, very odd to now hear that they only became aware when they got the notices. That's actually just unfounded. So let's go back then to the question of the test. The case that is made by Mr. Manager is that Justice Khampepe got the test wrong. But I just want to ask the court to have regard to paragraph 43 of the note. There we quote verbatim the test articulated by the Constitutional Court in Bennett versus Absa. It says the allegation that a judicial officer has an interest in the proceedings or an interest in a party to the proceedings is not sufficient to give rise to a reasonable apprehension of bias. Now, this does not matter whether it is a historical connection or it is a current connection. The fact is any connection. But what is the test then? It says what is required is the articulation of the connection between the interest alleged and the feared deviation from impartial adjudication of the case. It's there in explicit terms. And then it says, but we must at the same time not lose sight of the fact that at issue is not whether there was actual bias, but whether there was a reasonable apprehension of bias. But the point is this, the test is you have to show the connection between the alleged interest and the deviation from the expected standard. That's really what is to be required. This idea that simply because you are in an institution, necessarily you are tainted, you have an obligation to somehow make disclosures. If you fail to make those disclosures, you are disqualified. It's not actually not part of the test. Then that's the unanimous decision of the Constitutional Court in Bennett. Then you look at Masuku in paragraph 44. Paragraph 69 of Masuku. And just the part that we have italicized. We said this court went on to emphasize that more is needed before the test for recusal will be satisfied. There must be an articulation of a logical connection between the matter and the feared deviation from the course of deciding the case on the merits. So what we know in case one is that the interest alleged must be logically connected to the feared deviation from an acceptable standard. Case number two, what we know is that the matter must be logically connected to the feared deviation. But both of them require this logical connection. But what did the judge say in her ruling to justify the accusation that she misunderstood the test? In her ruling at paragraph 32, the chairperson said that there must be objective evidence in the form of an articulation of a logical connection between the matter and the feared deviation from the course of deciding the case on the merits. That is precisely the test that has been outlined by the Constitutional Court, that you need to illustrate the connection between the interest alleged, whether it's historic or current, and the feared deviation from impartial adjudication. So with respect, there is no basis for the accusation that the judge got the test wrong. She got the test right. It may not be verbatim, but she is aware that what an applicant must do is to articulate a logical connection between the matter and the feared deviation from the course of deciding the case on the merits. We submit that that test is in compliance with Masuku and Bennett. And the court will recall that in Bennett, the question was, well, it is clear that you've got some financial interest in ABSA, but we are not going to hold that against you.
Can I interrupt you there, Mr. Ngaitobi? Mr. Manager will correct me if I'm wrong, if I misunderstood his submission that the first respondent did not either understand or apply the test correctly as articulated in the ABSA case. And just paraphrasing what he said, after a long articulation of the connection, which referred to the role that the first respondent played, for instance, in the amnesty committee,
Yes.
and refused the applicant's amnesty in her role there. But he went on to add, and I thought this is where he was well, articulating the test further. He said the first respondent did not, as was done in the ABSA case, give a statement or an explanation of the role that they played in that case. And he went on to say that the first respondent in this case just was silent, did not say a word about her actual role. And if she had done so, which would have meant she understood the test in ABSA and applied it here, the case might be different. So he put emphasis on that point, that her silence regarding what she had done with regard to institutional or vocational history indicated a bias.
Yes. No, my lord. I think one needs to draw a distinction between the test for recusal and the conduct of the judge. I think the two should not be conflated, because in order for the issue of the test to constitute a reviewable irregularity for purposes of legality, my learned friend needs to show that it is a material error of law. Now, the only reason he's able to say it is an error of law is because he says the judge misunderstood what the test is. He's not complaining at that point about the conduct of the judge. I'll deal with the conduct of the judge. But insofar as the first leg of the argument, which is did the judge get the test right? Because there are judgments that say if you get the test wrong in an appreciable way, what happens thereafter is that you are misapprehending the nature of the inquiry. And therefore, that could constitute a ground for review if the other requirements for a review are satisfied. And so what I am debating now is that where he is wrong is to say the judge misunderstood the test, when the record illustrates that the judge actually understood the test and articulated it. So this is not a case about a misunderstanding of the test, which is your classic review ground for on legality basis. Then we can go to the facts, and there, around the way in which the test was applied, that's a different issue altogether. Because there you are required to be specially differential, to even tolerate mistakes of fact, because ordinarily those would not be reviewable. They would be reviewable in very rare circumstances. But the articulation of the test, I think, became pivotal in his argument, because he has to lodge himself within a reviewable space on legality, because their ground for review now is a very narrow one as soon as they're running a legality argument. So my point, therefore, to answer you, Justice Bakwa, is this. On the understanding of the test, the argument simply cannot succeed, because the test, as explained in Masuku and as explained in Bennett versus ABSA, is the same test that the judge articulated at paragraph 32. So that's number one. Then I must address the other issue that Your Lordship raises, which is the conduct of the judge. Now, we've dealt with this in paragraph 46 of the note, and I'm going to add something more on this. So it is obvious that some cases, some judges elect to put a statement when there's an accusation made against them. But that's not a rule, an invariable rule. The practice actually differs. When I went through just a quick search yesterday to see in some of the other recusal cases, I found that in other recusal cases, what the judges have decided to do is to speak for the first time in their judgment. Now, if you remember Justice Khampepe in this case, she specifically said, I am accepting all of the facts that you are alleging. Accepting all of the facts. I know there's a big issue around the Human Rights Investigation Unit, etc. You don't need to decide that. Because Justice Khampepe said, I'm accepting all of your facts that you've alleged in relation to the NPA and in relation to the TRC, accepting those facts. Now, I am not talking here about the facts about the clandestine conversation, because those are hotly disputed. But I'm talking now only about the two categories of fact, which is the TRC and the NPA rule. So I'm accepting those. But the way I apply the test in Bennett, I cannot find that there is an inevitable and a necessary and a logical connection between these facts and the prevention of an impartial adjudication of the case. That's really where this case ultimately tended. I'll show you now the portions where she actually articulates that. So this case is far from a misunderstanding of the test. The test is understood and the test is articulated. The question that really bothered the judge was these facts that you have alleged that I was in the TRC and I was in the NPA. What bearing do they have on my ability to give you an impartial adjudication? And then on that score, she said, I don't think they have enough of a bearing. And I have my reasons, I've given the reasons. And the question for a review court on rationality is whether or not you can demonstrate that these reasons do not bear a reasonable connection to the material that was before her or to the object of the commission that she was chairing, because it's a very, very narrow ground to attack it. Now let's do that exercise now. So in paragraph 46, I've shown the court that although some judges prefer this route of recording in a piece of paper, other judges don't. Other judges will speak for the first time in a judgment. In AfriForum, Justice Kitley was accused of harboring an animus against AfriForum. She didn't give a statement about that, but her full explanation about the comments that she had made and the fact that she doesn't harbor that animus is apparent from the judgment. In Masuku, Justice Mukhwenga was accused of a pro-Israel bias in a case that involved the criticism about hate speech and anti-Semitism. She didn't give a separate statement, but her full explanation, his full explanation appears from the judgment of the court. So there are those two practices. Neither practice is necessarily correct or wrong.
Yes, without belaboring the matter, just one small addition. Mr. Manager seemed to be of the view that it was arising out of her being a judge, that she was duty bound to give an explanation in those circumstances. But you have answered it with your submissions now with reference to specific judges in specific cases.
No, that's definitely not the law. And it really doesn't matter if Mr. Manager would have preferred for the judge to give a statement. That's just irrelevant. You know, or his client, not him, not to personalize, but his client would have preferred a statement. That's irrelevant. Now, So in paragraph 47, we therefore, sorry, my Lord Presiding, it's 1301. So
I'm aware. I was about to ask you, how long do you think it will take you to wrap up?
I'm going to have this section probably another 45 minutes, I think.
Yes, in that case then.
Yeah, my lord, sorry, I'm imposing myself as the official timekeeper. I wanted to make a request, my lord, in all seriousness.
I thought I was the official timekeeper.
Yes.
In my court.
That's the, you were. No, I'm saying, talk about this side of the aisle. I wanted, on a serious note, my lord, a more serious note, I wanted to make a request, maybe to all concerned. Mr. Mbeki is left with about 30 minutes, whether we shouldn't then eat into the lunch break, so that when we come back, because when we come back on our broad timetable, we will still be about, I think, 45 minutes behind, because Talata group still has to speak.
So what were you suggesting? That
we
we
take lunch at 1:30 when Mr. Mbeki finishes.
Okay, but beyond that, at 4 o'clock, I suppose it would have been done according to your timekeeping.
No, my lord, as I've just said, if even with that adjustment, we will be at least 45 minutes, unless it's we would be at least 30 minutes behind.
I see.
Which means, depending on Mr.
If
I don't
we
want
were
to eat too much, we already gave Mr. Van.
If we were to adjourn at 13:30, what time do we resume?
At 2.
Okay, let's proceed.
Let me just make it clear that Mr. Mpofu spoke for 20 more minutes than he was allocated. No, my lord, it's important to record it because, you know, this is not acceptable. Mr. Maineche spoke an hour more than he was allocated.
Okay, just hold it right
1
there.
hour.
I did not ask you to respond. Perhaps I should ask you for your input before I make a final.
No, sorry, my lord. I'm not going to say anything more. I think
Yes.
I've expressed.
We would bend ourselves backwards to try to. I was alive to that. So by all means, we'll try to accommodate you.
I'm happy, my lord, to speak until past. I will not be finished. So just make that clear.
No, that's fine.
And I'm
In
not
which
gonna-
case, we'll adjourn and then we'll entertain whatever other additional minutes you might require.
Yes, thank you, my lord.
To be fair to you, because since we started, we were chasing time.
Yes, and we didn't raise any issues.
Let's proceed.
To now be told that you've got 30 minutes left is really unacceptable.
My lord, you know, I don't understand what's going on with Mr. Mbeki. All I was saying, my lord, I'm not saying Mr. Mbeki must not be given extra time if he wants, like all of us. All I was saying, I'm making a request in the interest of the court, that if, assuming Mr. Mbeki is going to take the 2 hours, which we allocated him more than ourselves for a particular reason, and if he wants more time, of course he'll approach the court. I'm not, as you pointed out, I can't impose on the court to give flexibility and so on. If counsel wants more time, we've all asked for time and the court has been generously giving us that extra time. So I honestly don't understand what the tantrum is about again for the second time. If it's not an insult, then we're told that we are taking over the role of the court.
Let's not belabor the issue and eat more into the time allocated. Mr. Ngoitobi, please proceed.
Thank you, my lord. So we've just shown the court then that the question of the test for a recusal has been properly understood by the judge and properly articulated. And we've also shown the court that the practice of recording one's view of the matter, let's put it that way, or view of the facts, is not a rule of law. It differs from case to case. We've also shown the court that what Justice Khampepe elected to do is, she actually says so in her ruling. She says, what I will do is that I will record in my ruling all of my reasons, including the correction of some of the facts, such as you presided over in the
Credit for.
Cradle for, exactly. Yes. Now we then go to precisely what the central pillars, that's what we call them, the central pillars of the ruling. Those are the temporality of scope, number one. Number two, the difference in the subject matter. Number three, the absence of role overlap. And number four, the absence of evidence on the alleged secret communication. Now we say when you examine those, you should do so as mandated by the SCA in Rustenburg Platinum Mines, which we cited footnote 41. Now that case is a good illustration of what a court does when it's reviewing a decision. It's a single decision, but it is reviewing it for rationality. What is the court actually doing when it is reviewing it for rationality? In the case, the court therefore says, the question is not whether the decision is capable of being justified, or as the Labour Appeal Court thought, whether it is not so incorrect as to make intervention doubtful, but whether the decision maker properly exercised the powers entrusted to him or her. The focus is on the process and on the way in which the decision maker came to the challenged conclusion. Then it goes on further. The court must examine the connection between the decision and the reasons the decision maker gives for it, and determine whether the connection is rational. So you look at this, she gave these reasons, and can I draw a rational connection between these reasons and the facts that were before her and the object of the exercise that she was performing? And more recently, the case of Rustenburg Platinum has been endorsed by the Constitutional Court in the SARS case, which cited paragraph 50, which says judicial review is described as a remedy afforded to an aggrieved party who seeks to challenge the lawfulness of a decision. And here is the important part. A review is concerned with the decision-making process and how the decision maker came to the impugned decision. So you are always going back to looking at the reasons given and testing those reasons for a rational connection to the evidence or a rational connection to the object of the power. And then the same court explains an error of law, and it is aware of the usual problem that somebody says there is a legal mistake and therefore there is a reviewable irregularity. And it says actually that's wrong, because what you have to find, it says where an error of law, where I'm now at paragraph 51 of our argument, where an error of law is pleaded, a litigant must not only plead facts which indicate that the decision was materially influenced by an error of law, but also indicate how those facts satisfy the requirements for error of law as a ground of review to activate the legal claim for judicial review. So you have to cover quite a number of steps before you get to a reviewable irregularity. So we then look at what did the chairperson actually say on the material that was in front of her, and not material that has come now in review proceedings where there are accusations about, and actually I don't even think the non-disclosure is pleaded. I don't think anyone pleaded it. I asked my junior to actually find it. I don't even think they pleaded it as a ground of review here. It's just been thrown in oral argument, but I don't think it's a ground of review. So we then look at the actual reasons that she gave. Number one is the temporality of scope. So when the judge said, listen, my job here is bound in time, was she delivering a reviewable irregularity or not. So in paragraph 56, she says, but there is a more fundamental problem with the apprehension of bias argument based on my prior institutional roles. It is this: the terms of reference of this commission require that it must investigate whether attempts or efforts were made to stop the investigation or prosecution of TRC cases from 2003. That was well after, remember these are the reasons she's given. This was well after my prior roles at the Amnesty Committee, which ended in 2001, and at the NPA, which ended in December 1999. There is thus a 2003 temporal boundary over the work of this commission, which means that what I did in my prior institutional roles will not be the subject of the work of this commission. Nor have former President Zuma and Mbeki offered any elucidation of what these related matters might be. So what about the temporality of scope that causes our learned friends some anxiety, I mean their clients some anxiety? It is all based on this idea that in order for you to look at 2003, you need some background context. That may be so, but any finding, I stress this, any finding that there was political interference with the prosecution before 2003 will be ultra-virus, because it is expressly excluded from the temporality of scope of this commission. Why did we end up with 2003? Why did we end up there with 2003? I asked the court to look at paragraph 56 of our note to show that 2003 is not a thumbsuck. There is a logical reason why 2003 has been chosen. There is a judgment of the Supreme Court of Appeal called Rodriguez versus NDPP. In paragraph 17 of that judgment, this is what was held. According to the record, Advocate Vosipikoli, who was the National Director of Public Prosecutions during the second period, complained about the interference of the government when he wanted to prosecute apartheid-era perpetrators who had not applied for amnesty or were denied amnesty. It was not contested that from 2003 to 2017, investigations into the TRC cases were stopped as a result of an executive decision. This was indeed interference with the NPA. You go to paragraph 26, and it says that the period 2003 to 2017, it was during this 14-year period that the executive adopted a policy position considered by the state parties that TRC cases would not be prosecuted. It is perplexing and inexplicable why such a stance was taken, both in the light of the work and report of the TRC advocating a bold prosecutions policy, the guarantee of the prosecutorial independence of the NPA, its constitutional obligation to prosecute crimes, and the interests of the victims and survivors of these crimes. Now, this is why 2003 is in the terms of reference, is because from 2003, according to the SCA, there was actually a policy adopted by the executive not to prosecute TRC cases. And if you made a finding that there was interference in 2002, that's ultra-virus. The judge is not going to make that, because in her own decision, she says that I am not interested in interference before 2003. I'm interested in interference only from 2003. And then she says, I had left both institutions, one in 1999, the other in 2001. So the question of the temporality of scope of this commission then assumes provenance, because it simply shows that there is no way that the judge can make findings and recommendations on events that precede the time period. And that time period itself is a time period prescribed by the Supreme Court of Appeal, because it made a finding in the Rodriguez matter. And the reason the state parties who were in that case considered that from 2003 there was a policy adopted that these cases will not be prosecuted. What the judge has to do is then to look at the evidence after 2003 of the interference, whether it is individual cases or not individual cases of the interference. What she is not required to do is what Mr. Maineche is suggesting, which is she is required to find other reasons. She is only required to decide whether there was political interference or not. So as soon as she finds that there was no political interference, that's the end of her mandate. If she goes on to investigate other things, that is ultra vires. So the point I'm making here is that you cannot actually rule in a judgment in circumstances where the outcome of your ruling would be to force the chairperson to act contrary to the terms of reference. In circumstances where the chairperson says, I am bound by my terms of reference, I'm only asked to look at 2003. Of course, some people will go there and say, Judge, we tell you the interference started long before 2003. And the judge has the mechanism to whip that out because she has already said in her ruling, but anything that happened before is irrelevant. That does not stop witnesses from trying to implicate others on events that happened before 2003. But it's a disciplining mechanism that there can be no findings on anything that transpired before 2003, and we know the source of 2003. And so if you therefore look at what they say, we've cited this at paragraph 54 of our note. And basically the whole argument is that, well, it's inevitable that there will be things that happened before that we'll have to look into. We admit that, but we say that as a matter of law, those are irrelevant because she cannot make findings and recommendations about those events. So point number one is temporality of scope, and the temporality of scope is itself clear that it shows her to be outside. Her role at the TRC and at the NPA shows her to be outside. And I'm talking here about the admitted role, to remove this supposed conflict of fact. There's no conflict of fact. The judge accepted all of their facts except one correction. But she then says, on those admitted facts, I'm outside of the scope. Then the second pillar of her ruling is the difference in subject matter. Now, we've set out at paragraph 57 and 58, right, what the attempts are by the applicants to muddy the waters by showing that there is an overlap in the subject matter. But you are a review court. The judge applied her mind to the question of the overlap of the subject matter and reasoned against it. You are not allowed to just say, we don't like your reasons, we've got our own reasons. You have to examine her own reasons for rationality. She dealt with this at paragraph 53 of the ruling, paragraph 59 of our note. And this is how she dealt with it. She says, the question of whether apartheid-era crimes should be prosecuted is not before the Commission. And therefore, the recommendation of the TRC that offenders who were not given amnesty must be prosecuted does not have to be defended or justified. I remember you also heard, actually, yesterday that President Mbeki is an amnesty applicant. His amnesty was refused. President Zuma is an amnesty applicant. His amnesty was refused. And then you also heard that there is therefore this fear that the judge would be required, I think it was President Mbeki more than President Zuma, that there is this fear that the judge would be motivated to defend the decisions of the amnesty committee and to ensure that those people that didn't get amnesty are in fact prosecuted. That's the argument made out on paper. But the judge says, look, I know what you're saying, but my view on it is that I cannot make any recommendation on whether people should or should not be prosecuted. What my mandate is to look at whether there was interference. Look at the last sentence of paragraph 53 of her ruling. It says, nor should such questions feature at all in the work of this commission. So anyone going there to say that I think that President Zuma should be prosecuted for whatever he did under apartheid, for President Mbeki should be prosecuted for whatever he did under apartheid. Anyone who says that has already been told upfront that all of that is inadmissible evidence because the judge says this will not feature in the work of the commission. He says it cannot feature because that's not what I'm required to do. And that's why we say in paragraph 60, this is both correct and rational. The fact that President Mbeki and President Zuma were denied amnesty and are therefore exposed to possible prosecutions is not relevant to the work of the commission. It is speculative to assume that simply because Justice Khampepe was a member of the amnesty committee, she would have an interest in ensuring that persons who were denied amnesty are prosecuted. That's all entirely rational. So this is the second pillar of the ratio, which is that there is a distinction in the subject matter. And it's actually a very strong ruling because it says anything about the prosecutions of people that were denied amnesty is excluded from this commission. I will not look at it at all. Now you have to ask then yourself the question, what is the irrationality with that reasoning? What's the problem with that reasoning? Because the idea that we are trying to work through, if you look at this standard in ABSA and Bennett, is this idea that we're trying to see whether there is a logical connection between the previous role and the adjudication of the current matter. And the chairperson is saying, well, there is no such, because my previous role was unrelated whatsoever to the current job that I'm required to do. And of course, I cannot sensibly go into a commission being totally blind about the reality of South Africa, because there is no such expectation. I cannot go into a commission with no history, because there's no such expectation. SARFO and all of those cases are clear on this point. But she's applying a very rigorous standard that says, well, what is the connection between that role and what I'm required to do now? And then she says, in law, there's no connection. And she says, well, if you try to bring facts here about non-prosecution of people that were denied amnesty, I'm not listening to that at all. The third pillar of the ruling is what we call the no overlap in role. It is addressed at paragraph 45, 50, and 51. This is what the judge says. It says, former President Zuma ignores the fact that the issue of efforts or attempts having been made to stop the investigation or prosecution of TRC cases were not matters that were pertinent before the TRC's amnesty committee, or indeed at the National Prosecuting Authority during my tenure there. Now, if we just stop here, it's not just her tenure. And you know, everyone is going on about, well, are you not telling us? She is actually talking about her own personal experience. And the reason why that is so is because the executive policy not to prosecute TRC cases was adopted in 2003 as per the findings of Judge Ledwaba in the Supreme Court of Appeal. Then she continues to say, nor has he pointed to any direct aspect of my work there that can be said to constitute an articulation of a logical connection between my work in those roles and the present investigations before this commission. So basically, whatever happened in the NPA, there can never be a connection, because what happened there had nothing to do with interference in prosecutions. Whatever happened in the TRC, there can never be any logical connection, because that had nothing to do with the prosecutions, which is the subject matter I'm required to investigate. Paragraph 50. Former President Mbeki alleges that during my time at the NPA, I had institutional responsibility for shaping NPA policy on the TRC cases. I am not aware of any specific policy on TRC cases that I was involved in emerging from the Human Rights Investigation Unit during 1998 or 1999. But assuming this to be correct, right, the fundamental point that the judge is making is that I cannot see any logical connection, because what the subject matter is different, the temporality of scope takes me out of it. So there can be no overlapping roles. This is not a case of a person who used to be a witness or a prosecutor who's now a judge in the same cases that they were witnessing or prosecuting. And then in paragraph 51, further, former President Mbeki alleges that my prior role in the TRC cases creates an apprehension of bias because of the unavoidable overlap between my past adjudicative role and her present fact-finding responsibilities. What this alleged overlap is not spelled out, and I cannot divine what this might be. Now, that of course comes from the fact that she has already separated out the scope of the commission and the mandate of the commission, and then said, based on those, I cannot see the connection. So you then have to ask yourself, well, what exactly is the irrationality in these findings? What is the problem that makes these findings not rationally connected to the arguments that were placed before her? What is it with these findings that makes them not rationally related to the purpose for which the decisions were written? Now, you actually cannot find that. I mean, what you simply find is that what you've been served with yesterday and today is a repetition of the arguments that were before her. Basically saying, well, if we were judging the cases, we would have recused her, and you should just recuse her. But you have not been asked the pertinent question that these are review proceedings. And so go through the eye of the needle and show precisely what is the irrationality in the reasoning that has been given by the judge. That then takes me to the fourth pillar of the reasoning. Now this is, I've dealt with the three pillars of the arguments by President Mbeki, including the so-called incorrect test, which actually is more illusory than real. When you look at the idea of the secret communication, now it obviously falls outside of prior institutional roles. One of the things that will strike the court about this is that President Zuma says that he's got the secret communication, and then he reserves his rights. And I want to show the court from the ruling itself, where it's quoted verbatim. I want to show the court where it's quoted verbatim. So he says he has this communication, but he is giving the judge an opportunity to deny them. And then yesterday we spent an hour and a half on the application for the disclosure of this communication, which is why we say actually we are engaged in abusive litigation. Because a party that claims to have obtained this communication comes to court and pretends as if they don't have it, and then wastes the court's time for a whole hour on material that they claim to have it. Now, if they had it, there would have been no reason not to disclose the material so that everybody can see what are the alleged secret communications that are being spoken about. Now, the judge dealt with that. I want to just show the court where the judge dealt with that part. So paragraph 32 of President Zuma's affidavit says, sometime in November 2005, it was reported to me by a whistleblower that Chairperson had communicated actions which amount to bias, gross misconduct, and or corruption, in that she had inter alia coached and or colluded with one of the parties in the Semenya SC recusal application.
Mr. Mukaitobi, I'm sorry, we're no longer being directed to case lines.
I apologize.
Perhaps on that note, it's now 1:30. It's only fair that we should adjourn.
I'm in your hands, my lord.
Well, I make no excuses for adjourning. This is what we agreed upon.
Yes.
You will then proceed at 2 o'clock when we resume. You will still have that.
As you please.
You do. We adjourn.
Why not? How many times have you said to me, why not? No. How many times? Remember that time I would have my wife is watching. And she said, I know this one said. No. When we come to an apology, I mean, not even justify, I'm wrong. I even asked for that blind judge. I said, where are they? No. I said, here they are. There was I want to know if you still want to apologize. Give it to you. Give it to the judge. Because I'm going to feel and I have a reply with interest. No. I'm going with you. I would still apologize. You will come with me. Yes.
Okay, Mr. Bofu also wants to be asked
No.
if he accepts.
No, I won't open up for Mr. Mbofu now because we'll never finish. So,
Yes, all are not equal.
All right, thank you.
But I do accept them.
Okay, so peace returns to the land. So I want to address the issue of secret communication. I wanted to show the court the actual ruling to actually explain that this is abusive litigation. So if you go to 001/58.
no, you promised to invite us. Where were we? That's where we were when we
Yes,
did.
yes, we were at 001/58.
No, we're yet to be invited. That's the point.
Oh, I see.
I know you are very slow in doing that. Perhaps you can ask one of your colleagues to do that. That's my experience with you.
I'm not even able to do
Oh, you
that.
see.
So,
That's a case in point.
yes. Is the
Any
court
one
invited?
of the officers in court who were doing so can proceed to do as they were doing. Where's Yako? Not here.
Yes, I suspect it was Ms. Mutrok.
Yes. Oh, there you are. Thank you.
Okay.
Yes.
Yes, I think we have them here. So the point I was making, my lord, is this. It's abusive because Mr. Zuma pretends to be asking for information that on his own version he has. Now, this is recorded at paragraph 73 of the ruling by the TRC. And it states the following. Bofu SC then averted to paragraphs 38, 39, and 40 of former President Zuma's statement as an answer to the inquiry. It is opposite, therefore, to quote verbatim the contents of these paragraphs for objective examination. 38. In the build-up to the
Sorry,
hearing,
Mr. Mugaito, we still have not been invited to these pages. Where were you?
Just go.
I received 2 invitations.
Just give me one on him, please. Take the picture, please.
Can I get an invitation again, please? Thank you.
Thank you. So if my lady is at paragraph 73 of the affidavit, of the ruling by the chairperson, she says, Mr. Bofu SC then averted to paragraphs 38, 39, and 40 of former President Zuma's statement as an answer to the inquiry. It is opposite, therefore, to quote verbatim the contents of these paragraphs for objective examination. Paragraph 38. In the build-up to the hearing of the Simenya recusal application, Justice Khampepe, as a member of the judiciary and as the decision maker who will ultimately make a final ruling, conducted herself improperly and exhibited actual bias in favor of the non-recusal of Advocate Simenya. Now look at what happens next. 39. A good example of this is that Justice Khampepe, without the knowledge of the applicants, privately and secretly gave advice to Simenya SC on certain key weaknesses in his case, and even advised him on what to look out for and what to convey to his legal representative, Advocate Masson, in order to succeed in the recusal application. This is a case of plain and gross misconduct, irrespective of the merit or demerit of the Simenya recusal application. Paragraph 40. Purely in order not to jeopardize ongoing investigations into this serious conduct which poses a threat to our democracy, I deliberately and consciously refrain at this stage from revealing the complete evidence available to me. Now that's the first part. So he has evidence. He's not revealing the evidence completely. If the accusation is denied, and that's the point I made earlier, I will be left with no option but to resort to alternative procedural mechanisms in order to secure and or provide the evidence. I trust that this will not be necessary. So here, it's clear that he's got the information, and he says, if you deny it, then I will reveal it.
Just for my benefit, which ruling does this pertain to?
This is the ruling now on the secret communication.
Yes, okay. This is in the recusal.
In the recusal, yes.
Which recusal application? There were two.
No, this is the recusal participation of Judge Khampepe.
Herself.
But she is referring to the recusal application of Mr. Semenya SC.
I see.
Because the reason she ends up here is because the accusation is made that the way you conducted yourself in the manner you dealt with the Semenya SC recusal shows that there's a reasonable bias. There it was actual bias. Shows that there's actual bias. Yes. Now, so the point here is this. On President Zuma's own showing, she has the information, she's not revealing it completely. She will reveal it completely once it is denied.
It's a he.
Well, he will reveal it completely once it is denied. Now the problem here is that yesterday we end up with an application to compel the production of the same information that he claims to have.
And I asked that question, didn't I?
You did. What that simply proves is that this was abusive litigation. Even the harassment that is imminent in this was, the next paragraph from that is that basically I regard this to be threats. In fact, the threats continue because there are still references even here to PRECA. And there are still references to Judicial Service Commission, etc. On information that he says he's got, but he's not revealing the full extent thereof. So the point here that we make is that the judge, therefore, when she says in the ruling, when she says in the ruling, well, I have to find against you because you have not provided the information that you claim to have. You will see this paragraph 65 of our note, where we quote paragraph 80 of the ruling. And in paragraph 80 of the ruling, she says, even in his replying affidavit, former President Zuma did not produce a smidgen of evidence with regards to the secret communication. In his replying affidavit, former President Zuma accepts that he has not provided any evidence of these communications and states that the decision to withhold this communication is to protect ongoing sensitive investigations and that at some future time that will be made available to the Judicial Service Commission or even this commission once specific safeguards have been negotiated. So it's someone who, on his version, is in possession, but he applies for a recusal and he does not disclose the information. And then what he does, he then engineers a reverse on us and comes to this court and say, no, you didn't do enough of a denial of an allegation about facts that are in our possession, even though we never gave you those facts that are in our possession.
Yes, Mr. Right, Toby. Maybe, it's a comment or a question, but it creates what one can call a catch-22 situation in this sense, that with the applicants persisting on the application which we pursued yesterday, he's within the bounds of the law in terms of Rule 53, in that the person who made the decision is duty bound upon the application, the review application of the launch, to provide a full record of the root treatments. So the court can't stop them from doing that. And since this has not been denied by the respondents in explicit terms, other than a reference to private communications and so on, what do we do in the circumstances? I'm talking now in terms of the law, and this is why I call it a catch-22 situation, because that was not an improper or unlawful action, because in terms of Rule 53, this must be provided fully if it's there, and it's not been denied.
I'm not sure Justice Khampepe about the absence of denial. I think that the report, well, the ruling, when you actually read the ruling on this section, I don't think any fair reading of that ruling can be that it is admitted that there is information of this category that exists. I don't think that's a fair reading of that. But to answer your question directly, we have two scenarios. Scenario one is where an application for a recusal is brought on the basis that there is secret communication, but the alleged secret communication is not produced. The question is whether a decision maker in the position of a judge who rejects that application on the basis that they have not provided evidence, whether or not they are acting irrationally when they do so. Now, the point I'm making here is that they are not acting irrationally when they say, when you say that you've got secret communication where I'm coaching advocates in Mbeki. Well, you have not produced the evidence, which you say you have. And on that basis, I'm going to refuse to lend any credence to this. Class category one. This simply makes the decision unreviewable because it's perfectly legitimate for the decision maker to say, if you are saying that what is provided, you cannot deal with it at a later stage. But if you fail to provide it, then accept the ruling that the judge will rationally say that you haven't established a ground for the truth.
Yes, without belaboring the point, the last I would like to say is this then just a reverse onus creation by the applicants in doing that? Because they could argue equally, why are you not producing the evidence?
Yes, but no, I see that, but I don't think it is the argument works because it simply means you haven't discharged the onus that rests on you as an applicant for recusal, especially where you say you have the information. And it's not an excuse, you see, because to say I'm trying to protect, you see, there are just so many protective mechanisms this country can apply, reduction of names, etc., etc. But what you cannot do, you cannot just make an empty assertion and then hinge your case, entire case, on an empty assertion, including the application that was brought yesterday, is also hinged on this empty assertion. So insofar as the recusal application is concerned, it's dead in the water because the basis for the recusal is private communication, which he has, but he is refusing to produce for spurious reasons. The second thing is a separate issue, which is what does one do with the application for to compare. We made the arguments yesterday in relation to that application, but for the substantive analysis of whether or not grounds for review have been established, the answer is clear. There are no grounds of review because you haven't provided the factual substrata to hang those grounds of review. Now, that takes me to the next topic, which is the question of delay, and I want to be very short on delay. We've argued delay in full in our heads of argument. Let me just summarize this. There are two grounds, well, there are three now because of the secret communication, but there are two primary grounds on which the recusal was sought at the time. Ground one is the institutional role at the TRC, ground two is the institutional role at the NBA. Now, in circumstances where the prejudice that is alleged is that there is a reasonable fear that because Mr. Mbeki and Mr. Zuma are likely the subject matter of prosecution because of the denial of amnesty. That's one level of prejudice. The other is that they are also likely to be the subject matter because they held executive positions at the time at which the alleged political interference happened, which is after 2003. In 2003, we know President Mbeki was the president. 2009, President Zuma became the president. And both of them, their presidency coincides with the period that is the subject matter of this commission. Now, the question that the court must ask for purposes of today is when did the clock start ticking? Now, given these four facts about what they know about what the commission will do, and what they know about their own role, and what they know about Justice Khampepe, as soon as they knew that she was chairing the Commission of Inquiry, as soon as the proclamation was signed, that is when the clock started ticking. This idea that no, the clock only started ticking when they received the Rule 3 notices and invited to the commission makes absolutely no sense, because on their own version, they always knew that they were within the scope of the commission's focus, either because they were denied amnesty, or either because they held the position in the executive at the time that is the subject matter of the commission. So it is just intolerable for them to say that they had to wait until they received these notices. If they thought there was a problem with the appointment of Justice Khampepe, knowing full well that they are within scope, the time to challenge it was upon the publication of the proclamation. And you know what is worse, and I'm sure Mr. Vine will deal with this because he's been involved in this. They actually collaborated with the commission, worked together with the commission, including on the Mr. Smenya application, etc. Then at some point asking for a recusal. The Bennett case is clear. The Bennett case is clear. A recusal is one of those applications you bring immediately because of the snowballing effect that it will have. Because what you want at the beginning of the trial to remove the judge, not in the middle of the trial. And that's why the issue of delay becomes very, very, very pertinent. So we would submit with respect that you have to reject this idea that they were entitled to wait until they received these notices, bearing in mind these four facts that I have outlined. But when you actually think about it more well, this case is about a review. It's a review. A decision on a delay is a discretionary decision. The judge is entitled to say, in the exercise of my discretion, I'm going to dismiss this on delay. The circumstances in which you can review a decision on delay are very circumscribed. Very, very, very circumscribed. I ask the court, please, look at the founding affidavit and find there where they bring themselves within the circumscribed circumstances of challenging on review a delay decision. We've cited this at paragraph 139 of our main heads of argument, the authority of Trencom, that draws a distinction between true discretion and loose discretion. And decisions on delay, condonation, those are true discretions. And we say a court on review is not permitted simply to take a different view on delay. It is required to interrogate the reasons given by the Commission to form a view on whether the Commission's discretion was not exercised judicially or had been influenced by wrong principles or a misdirection of the facts, or if the court reached a decision which could not reasonably have been made by a court properly directing itself to all the relevant facts and principles. We cite at paragraph 141 the judgment of Central Energy Fund versus Venus Race Trade. So we come back to this. This is a preeminent discretionary decision. The judge looks at this thing and says, look, as far as I'm concerned, the clock ticked earlier, you should have come to court earlier, you failed to do that. It's a recusal. A recusal is a special application which you must bring expeditiously. You failed to do that. In my discretion, I believe you should be non-suited on that basis. Now you come to court and you say, well, I'm not happy with this. You have to go through that stringent test that is in the Central Energy case. The founding affidavit is totally bereft of any allegation that would bring it within it. Then I must deal with one more point, which is the signature to the ruling signed by one person and not the full commission. The fundamental problem here is what I suppose it's become clear in the course of my argument, is that what you have, you've got very broad allegations and statements made, but actually no attention to the detail. The cases that are relevant in circumstances like this, cases like Skirut versus Minister of Justice, I think it's a 1910 case. Cases like Bates versus the University of Witwatersrand, it's a 1992 case. Cases like All Pay, all proceed on the basis that if there is a legal instrument that prescribes a quorum or a decision-making procedure, anything below that would be unlawful. So the obligation on the applicant in those circumstances is to show the court what is the quorum provision that are they claiming to have been breached. They can't just say the ruling is signed by one person and ipso facto is unlawful. You have to say that under the Commissions Act, where 3 people have been appointed, the chairperson is prohibited by law. Because remember, this is a review for an error of law. So the problem here is that they have simply stated the fact that is common cause, that the ruling is signed by one person, which we admit it is common cause. But what they have not been able to demonstrate is that this is an error of law, because they cannot demonstrate a single rule that was violated. And you can go through the history of these cases from Skillwood up until now. Every time judges look at this, they say, look, the panel is 5 people. The rule is that a quorum is made out of 3, and therefore the document cannot be signed by 2, and that is how it becomes unlawful. There has never been a case that hangs on its own petard by simply saying it's signed by one person, ergo it's unlawful. I mean, this kind of reasoning is really, really specious.
But in this case, Mr. Gauteng, the ruling in the Simenya decision, the chairperson did say on behalf of the commission, isn't it?
Yes.
But in this one,
I think it's been in that. I think she signed it alone.
yes, but specified that it was on behalf of the commission.
No, I accept that, Justice Balko, but maybe let me finish. Let me wait until you finish your full point. But there's something I want to say about that.
Yes. Now I'm just the plain difference in this one. Why couldn't it be done with the other commissioners? Because even regarding the decision that was quoted, I think, by the applicants, quoting Ines CJ, then way back, he says, yeah, it's Skirrod, where he says, if it's a panel must decide.
No, this is where they're wrong. He says, if the enabling instrument specifies a quorum, and then the people that are making the decision are below that quorum. So you always have to go back. In fact, the best articulation of this principle is in the judgment by Justice Nugent J.A. in the all-pay decision at the Supreme Court of Appeal, which was overturned by the Supreme Court of Appeal, by the Constitutional Court. But the analysis of the Skirrod principle is the most impeccable from that judgment, because he says, so someone is doing an adjudication of a tender. There's a bid adjudication committee. It's 3 out of the 4 people meet and they make a decision. And then you ask the question, well, you cannot simply say to a judge, 3 people out of 4 met. You have to show a judge that the rule that is binding requires a quorum of 4. Now that's the true Skirrod principle. Now, and he even says the problem we have actually is that Skirrod has become such an abused judgment, because in circumstances where a party cannot show that there is an enabling instrument that creates this thing and requires a quorum of X, then it becomes unlawful without more. And then he says, but that simply is not the law. That case goes to the Constitutional Court, and Justice Froneman says, no, the reason here I will find the BEC to be incorrect is because the document prescribed under the supply chain policy requires 4 people to meet. So you always need an instrument against which you are measuring the lawfulness. Otherwise, what you are doing is just reasoning from thin air. And so this is the problem that we are facing. So we come back then to the question you're raising, which is, well, in the one, she said it was on behalf of the committee. But on Skirrod, that would not have been sufficient. if the instrument said all three must be present and they must sign, it wouldn't matter that she says, I'm doing it on behalf of the person. So the legal question will never be affected by how she actually goes about signing the document. But the problem here is that they cannot get out of the starting blocks because they cannot show what? The illegality, because they have not produced any instrument that requires interlocutory rulings to be signed by all commissioners. And so when we say in our heads of argument, when we deal with this in our heads of argument, we say, in fact, it seems the contrary to be correct. If you look at the combination of the rules, it looks like the, sorry, I want to just find, so when you look at the where we deal with this at 054/162, so at paragraph 146 of our heads of argument. So what we say that it actually looks like the opposite to be correct. That when you look at the full structure of the rules, on a correct interpretation, it appears that the chairperson is entitled to make interlocutory rulings on a range of matters. We've mentioned this at footnote 45. All of the rules, 3.37, 3.8, 3.10, 8.1, 9.2, 10.8, 11.1, 11.3, 11.5, which empower the chairperson to make interlocutory rulings. Say, well, when you look at the structure of the rules as a whole, it looks like the chairperson, in fact, is entitled to make interlocutory rulings. Now, that's a secondary argument. The primary argument is that no illegality has been demonstrated because no rule of law has been demonstrated to be violated.
Mr. Mbeki, I need to understand your submission. So essentially, you are saying she made the ruling alone.
Yes,
The
yes,
recusal
on the
ruling
common
alone.
cause. Well, it's clear she signed it herself.
And it refers to it's written in the first instance, so she's the one who authored it, and the views of the other commissioners are not apparent from that. And your submission is that because there isn't a rule against it,
Yes,
then there's no irregularity.
absolutely. Yes. So I'm saying is that you have an applicant that says that the decision made like that is unlawful. But then the first question that you would ask yourself, unlawful in terms of what?
Okay, you'll recall that reliance was placed on Masuku. No, in fact, you referred us to Masuku, right? Where you submitted that there was no statement by former Chief Justice Masuku. And in AfriForum, there was no statement by Justice Khampepe at the SCP. But those judgments, it's very clear from the judgment, from both judgments, that the judgments were collective judgments.
Oh,
So
yes,
the
that-
distinguishing factor here would be that it's an interlocutory in the commission and there's no rule against it.
Yes, definitely. I just want to make one point, to emphasize one point. If our learned friends could show that there is a rule that requires that interlocutory decisions made in the commission should be signed by all three, and that rule was not complied, we would accept that it's plainly irregular.
And you would say that SAFU is not binding.
Which one?
SAFU.
But I think there's
Because reliance is placed on SAFU.
there's a distinction.
You'll remember, those findings in SAFU, those
No.
rulings in SAFU that it has to be a collective decision. The
No,
judges who do not agree may refuse to sit.
No,
All
I
of
think
those
there are two.
principles.
No, I think there are two separate arguments. Because there's the argument of unlawfulness per se, because it's signed by one. That's one argument. That's the argument I was addressing. Then there is another argument, which is, does it change the fact that it was a recusal decision? That's what the lady should be asking about. Now, does that make it different that it's a recusal? We would submit that it actually doesn't make it different that it's a recusal, because its character is still the same. It is an interlocutory application. There is no rule against the chairperson signing interlocutory applications on their own. And in addition, it is specifically directed at the chairperson. But the most important emphasis I would place is that if our learned friends could point us to a rule that prohibits the chairperson from signing interlocutory rulings on their own, then they should do that. In the founding affidavit, they point to no such rule.
What about the absence of the views of the other commissioners who may refuse, who are entitled to refuse to sit with them?
But they don't, that doesn't constitute an irregularity, because there is still no law that is violated. There's no irregularity there, because there's no requirement that they should be present and sit. It's unlike a court, where a court there is a requirement that you should sit and bank and decide collectively. So if you have a constitutional court, it's in the constitution that they must sit and bank, and they must also decide collectively. So that much is clear, because there is a clear constitutional provision that applies. It's like here, there is a Superior Courts Act that applies to the three of you. But the problem is here that you have an argument that is hanging in the air. There is no rule pointed out that in this commission, they were always required for all decisions, including interlocutory decisions, to decide those jointly. There's no such thing. The only question that remains is
Just one, please. Council may proceed.
the only question that remains. Check, I think I've said everything I wanted to say. Thank you, Madam. I have nothing else to add.
Thank you.
I didn't want to sit myself down.
By all means, you may be
Thank you.
seated. Sabani?
Thank you, Justices. If I could borrow that bench rather than into it, I want to I'd take it up. I'm just doing hard, but I need the assistance of my juniors. We'll just say here.
There you are.
That was something I thought you just Justices, much has been made about the rights of Mr. Zuma, Mr. Mbeki, and others who have been implicated in the proceedings of the Commission. But little has been said about the rights of victims, those who have been waiting for justice for decades, indeed denied justice and closure. And for all this time, these families have been demanding answers as to why their cases were not taken forward, and they've been demanding those answers since 2019. And Justices, that's really why we are here today, to advance their cause. In order to save time, I will endeavour, I will try very hard not to unduly repeat the submissions that my little friend Mr. Natori has made. We align ourselves with those submissions, and we will only from time to time reinforce them. So my address will largely be about rebutting various assertions that have been made by Mr. Mbeki and Mr. Mbeki. Now, before I commence, I'd like to give the court a sense of where the Commission is at. In the affidavit of Lucanio Kalata, which was filed in response to the affidavit, the explanatory affidavit of President Ramaphosa, he made reference to this at paragraph 35. The case lines references 016-59. He said that the commission had been in existence for about 9.5 months. Several witnesses had already appeared. At last count, some 13 witnesses. Indeed, all the witnesses for the Kalata group had been led at bar 1, and that's just for health reasons. We've heard, for example, from former NDPP.
Excuse me, Mr. Vani, we need assistance with being directed.
Somebody's just done so now.
Thank you. Thank you.
I
We're
think
sorted.
it is.
Thank you.
Which paragraph were you relying on?
It was paragraph 35 of Mr. Kalata's affidavit in response to President Ramaphosa. Now, on the question of costs, we don't have an exact cost, but there have been reports that, as from some weeks back, some 55 million rands have been spent. Mr. Kalata says, by the time this litigation is concluded, not entirely out of the question that that mark could exceed 100 million rands. So that's the context, Justices. My learned friend for the Commission has made extensive submissions on the question of Section 47, so I'm going to not repeat those, but I do wish to make...
Are you saying Section 37 or 47?
Section 47. I do wish to make 2 points. The first point, Justices, is that my learned friends for Mr. Zuma and Mr. Mbeki, they expect the highest standard from judges who serve on commissions. For example, in respect of disclosure, they talk about a very high threshold, a very high onus. So they allege that judges who serve on commissions, like Justice Khampepe, must conduct themselves judicially. But in the same breath, notwithstanding that requirement, they say that they're not entitled to protection under Section 47. And we would submit that they can't have their bread buttered on both sides. The second point...
There's a cell phone going off.
I think it's off now. The second point deals with the question of what was raised in the pleadings, and my learned friend for the Commission has dealt with this comprehensively. That he did omit one particular paragraph that I would like to highlight, and this was in the context of dealing with what was said by Justice Khampepe in the proceedings before the Commission. I'd like to draw your attention to paragraph 38. At 001-18. My apologies, I'm still working on paper. I'm not yet, I haven't graduated to the technical. So 001-18, paragraph 38. So Mr. Zuma says, however, it must be stated up front that the allegations of actual bias, possible judicial misconduct and or criminal corruption represented the proverbial last straw and were pivotal in my decision to apply to the Commission for the recusal of the chairperson. So here you have a situation, Justices, where Mr. Zuma himself is accusing Justice Khampepe of judicial misconduct in the context of what took place at the Commission. He even goes to talk about a possible criminal corruption. So in light of the protection of Section 47, I would think that that would settle the debate, Justices.
If I may, sorry to take you back to your submission just a few minutes ago with reference to paragraph 35 when you were dealing with the conduct of the President, where you outlined how long the Commission has taken and what it has cost and so on and so forth. You still support the submissions made by Mr. Mbeki with regard to Section 47?
Indeed.
You do?
Yes.
It's just that those allegations seem to be challenging what a waste it is to stop this proceedings by using Section 47. Any comment on that?
We don't see those assertions as irreconcilable. We make the point in Mr. Kalata's paragraph 35 that the Commission has expended much resources, has conducted much work, has been in operation for some 9.5 months. And we simply assert that when this court has to consider what action to take, it must also consider that the implications of declaring Justice Khampepe incompetent to proceed has enormous implications. I just simply raise that because my learned friends, for example, had said, well, Mr. Pekoli hasn't testified. The President has said, well, there hasn't been any cross-examination. Cross-examination has in fact started.
Yes. Lastly, there's been a suggestion in this court that if the court finds in favor of the application of Section 47, the proceedings might be annullity. Do you agree with that?
Well, we do agree that it is potentially a nullity. We do point to some case law that it doesn't necessarily follow in all cases. We make mention of the take and save case.
Thank you.
Thank you. So, Justices, I wish to deal with the question of delay. And
Just 1 moment, please.
yes.
Just debating with my brother here, which proceedings would be annullity in your submission? These or the commissions?
But as I understand the argument of my learned friends, on the question. When you speak about nullity, are you talking about nullity in relation to Section 47?
Yes.
Yes. No, that,
which refers to these.
which are these proceedings?
Yes.
Indeed.
And then the commission would still proceed.
Yes, indeed.
Yes. Yes. No. And I'd rather, when it makes clear that we will have.
Yes, indeed. So, Justices, I want to turn to the question of delay, and our central assertion we want to make is that it's not just a question of duration, it's not just a question of weeks and months, it's also a question of the circumstances that we would submit are equally relevant. And I want to refer to paragraph 62 to 65 of our heads. That's at case line 054 to 054-206. Let's just start with the situation of Mr. Zuma. And here we're also going to be relying on Mr. Zuma's affidavit. I'll make reference to it. Essentially, as we understand the position of Mr. Zuma and as to why he decided to bring the recusal application before the Commission, for that we need to look at Mr. Zuma's replying affidavit in the Commission. And that's case line 077-86. At paragraph 16, which we quote in our heads at our paragraph 62. Now, in Mr. Zuma's replying affidavit, he offered some explanation as to why he launched his application for recusal during December at the time that he did. And he said the fact that the most recent improper conduct in respect of the Semenya recusal application constituted the last straw and trigger for the recusal application. And we suggest that this is a most revealing admission, because essentially what it's saying, Justices, is that but for the developments that took place in the Semenya recusal application, most notably the alleged secret communications, Mr. Zuma would not have brought this application. It was that was the trigger. And if that was the trigger, then that is in fact what he has built his entire application around. And then we would submit that the balance of the application dealing with vocational history and the like, we would describe that as embellishment. And given that but for the developments in the Semenya recusal application, Mr. Zuma would not have brought his application. We think that there's eminent justification for the chairperson's ruling that Mr. Zuma's delay was unreasonable and undermined the reasonableness of his apprehension of bias. And turning to Mr. Mbeki, a learned friend for the Commission has already set out that Mr. Mbeki's situation is even more egregious, because he was familiar with the allegations against him because of his intervention in the Kalata application before the High Court. I'm not going to repeat those assertions. So we have to look then for why is it that Mr. Mbeki only launched his application, and I recall it well because it was just before Christmas. We received that application on the evening of Sunday, the 21st of June, 3-4 days before Christmas. The only explanation Mr. Mbeki offers for launching towards the end of the year is that he had to wait for his lawyers to consult Mr. Zuma's recusal application, which was filed on 15th December, before he could act. And the reference, Justices, is in Mr. Mbeki's founding affidavit before the Commission, in case lines 077-162 at paragraph 64. So it's clear then, and our submission is that, but for the Zuma application, Mr. Mbeki would not have brought his own application. He has simply grafted it on the back of Mr. Zuma's application, and we would submit that an application brought in those circumstances cannot be taken seriously. Now, we also wish to turn to the alleged secret communications. And Mr. Matobi has already quoted some of the assertions made by Mr. Zuma in relation to the question as to whether or not he was in possession of these alleged secret communications. And we note that yesterday, ADJP Madar raised the question, can we assume that you're in possession of these communications? To which Mr. Mpofu replied, he said in argument yesterday that that's a false accusation against us, and nowhere do we say that, in referring to having the emails in his possession. I just want to refer the Commission to the replying affidavit of Mr. Zuma. The first reference is at 077-89, and it's at paragraph 23.5 of his replying affidavit in the recusal before the Commission. I quote, "The decision not to provide some of the evidence pertaining to that allegation was not without cause, but based on the pleaded imperative to protect inter alia ongoing sensitive investigations and the like. Such evidence will be made available to the JSC or even this Commission once specific safeguards have been negotiated." And we assume the safeguards are whistleblower safeguards. Now, on the question of the safeguards, we're curious as to why these safeguards have not been invoked, and perhaps my learned friend for Mr. Zuma can address the court in reply. But there are certain safeguards. So, for example, Mr. Zuma could have invoked informer privilege. And indeed, I recall even raising this in argument before Justice Khampepe in the recusal application before her. And the question was, why hasn't the statement or the evidence been put up perhaps in camera? It is a practice in commissions and sometimes even in courts to put up in-camera affidavits, even hold in-camera proceedings. Perhaps the statement could have been redacted where appropriate. But nonetheless, none of that happened. And the question is, why did that not happen? So in that regard, we submit that Mr. Zuma blows hot and cold. We suggest that if he was in fact in possession of that information, it could have been put up in a format that would have protected the whistleblower in question to the extent that that was the case. which then takes us to the submissions that we make in relation to the failure to put up facts, which we deal with at page 32 on our heads of argument. That's 054-216, paragraphs 99 to 102. I'm sure, Justices, I don't have to remind you of the requirement that true facts upon which a recusal is based has to be put up. We make reference to Masuku. The paragraph numbers and pages are in the footnotes, page 19. In relation to what Safu says about this question, in all circumstances, the test emphasizes reasonableness in light of true facts, not the technical legal nuances of the particular case. That's Safu at paragraph 45. Sakawi at paragraph 57 makes a similar point. In other words, if the factual foundation is wanting, then a fortiori the apprehension is misplaced, and that will end the inquiry. If you don't put up the facts, that is the end of the inquiry. And for that we rely on the authorities in footnote 92, Benetton and other versus the state, in Re SV Porritt, 2021, 1 SACR 195 at paragraph 26. We point to an academic article by C. Okwaluba and L. Juma titled The Problems of Proving Actual Apparent Bias, an analysis of contemporary developments in South Africa, a 2011 article. They say, in addition, actual bias must be clearly pleaded and particularized. The burden of proof on actual bias has been described as heavy as a burden of proof, as heavy as the burden of proof of fraud, bad faith, or misfeasance in public office, meaning that the party alleging it must support it with cogent evidence, not mere assertion. And that's what's happened here, Justices. All we have is assertion.
Here, reliance is placed on reasonable apprehension of bias, not actual bias. The extract we've just read from said facts must be put up to support actual bias.
Yes, in this court, Mr. Zuma alleges actual bias on the back of. But it is correct that. I'll just check it again, but.
So on the past association
Yes,
grounds,
no, we are talking about
apprehension
actual
of
bias here.
But on the secret communications, actual bias.
Yes, I believe Mr. Mpofu has always alleged that it was actual bias.
He's just given me an opening. I did not interrupt him. Your Lordship is quite correct. We do allege, your Ladyship, yes, is correct. We do allege actual bias in respect of the so-called misconduct, but we also say alternatively reasonable apprehension. So your Ladyship is correct. In other words, we say that the so-called misconduct is actual bias. If we are wrong about that, then alternatively it induces a reasonable apprehension.
Thank you, Justice. Turning to the declaratory relief, we'll just make a short point. My learned friend from Mr. Zuma says that the alleged communication, the alleged secret communications, breaches clients' Section 34 rights, as well as other rights. Now we simply point out that in respect of the recusal of Semenya SC, neither Mr. Zuma nor Mr. Mbeki were part of those proceedings. And since the disclosure of the alleged communications, or the alleged existence of such communications, none of the applicants who were part of the recusal application against Mr. Semenya have sought to overturn the ruling on that ground. And we submit the reason why they haven't is because there is no basis to do so. Turning to some of Mr. Manekce's submissions, he pointed out that the Law and Prior Association rests on SAFU paragraph 76, APSA para 78, which essentially talks about there is no ground unless the subject matter of the litigation arises from such association or activities. And here we wish to reinforce what Mr. Mkatobi has submitted. The subject matter in question is not simply the fact that the chairperson was at a particular institution, most notably the TRC and the NPA. The subject matter is the political interference. And it's the something more that needs to be looked at. And what is this something more? And we suggest that our learned colleagues for the former presidents have not been able to articulate what that something more is. So they say, for example, well, she was part of amnesty rulings, and following those rulings, there was a general expectation of prosecutions, but then no prosecutions followed. Some of the parties who refused amnesty are now potentially implicated in the political interference. I think the high watermark of the point is that it's alleged that she misapplied the law here, and I don't want to spend too much time because I know this has been dealt with ad nauseum. But Mr. Manekce does suggest that she completely ignored SAFU and APSA and simply didn't deal with the question of the subject matter. But I want to point you to the ruling at 077-1000. So in fact, she does address the subject matter in multiple paragraphs, starting at paragraph 45, 077-997, where she speaks of the fact that President Zuma ignores the fact that the issues or efforts to attempt to stop the investigation or prosecution of TRC cases were not matters that were pertinent before the TRC's Amnesty Committee, or indeed at the NPA during her tenure there. Paragraph 53, at 077-999, the question of whether party error crimes should be prosecuted is not before this commission. Therefore, the recommendations of the TRC that offenders who were not given amnesty must be prosecuted does not have to be defended or justified. And we've submitted in our heads that it's also a question of the rule of law. Paragraph 54. Furthermore, there's no evidence at all to suggest that my work at the NPA during 98-99 is somehow of relevance to the present work of the Commission. And paragraph 56 on the next page. But there's a more fundamental problem with the apprehension of bias argument based on my prior institutional roles. It is this: the terms of reference require that it must investigate whether attempts or efforts were made to stop the investigation and prosecution of TRC cases from 2003. This was well after my roles at the Amnesty Committee, which ended in 2001, and at the NPA, which ended in December 99. So she does, in fact, address in multiple occasions the question of subject matter. turning to the question of full disclosure by judge, my learned friends want to impose a very high standard here. But the fact of the matter is, this is not a ground of review before your lordships and ladyship. We do not see it in the pleadings.
What is not a ground of review?
The claimed non-disclosure by the judge, by Judge Khampepe. It's certainly raised ad nauseum in argument, but as a ground of review in the actual pleadings, it's not there. I'm going to return to the question of disclosure in relation to current President Mbeki. But we are told that, and just to return to subject matter for a moment, we're told that, well, there is a significant overlap because while the chairperson was, for example, at the NPA was receiving lists from the TRC for further investigation and prosecution. And the question is, so what?
I didn't hear Mr. Manager to say there's an overlap. He said the subject matter arises from.
Yes, I accept that.
Being political interference arises from the granting of amnesty, which he was part of the TRC, and the recommendations that then went to the
Yes, the point we're making is that there's a suggestion that at some point Justice Khampepe ought to have disclosed in detail her role at the TRC and the NPA, and because she did not, that would be a ground of refusal. And what we're saying is that we don't see that in the pleadings.
And by reference to the ruling, you are saying that the chairperson or the first respondent does respond to that inherent.
Yes, indeed.
Else.
Yes, indeed.
I think was submitted by Mr. Mbeki, that was adequate. It was just done differently.
Yes, indeed. Yes, my learned friend has pointed out that in some courts a statement has been made, in others simply set it out in the judgment.
Yeah.
Now, on the question of overlap, my learned friends do concede that overlap in itself is not a ground, but they say, well, the fact that, for example, she was receiving these lists, the fact that while she was at the TRC and perhaps also at the NPA, there were meetings being held between the generals and certain government leaders, ANC figures. And again, the question is, well, so what? Unless there's an allegation that the chairperson is somehow connected to those activities, then the fact that they were happening in the same years is irrelevant. And there's no allegation that she's connected, no allegation that she was there, no allegation that she was even aware that those meetings were being held. We're told that, where she has personal knowledge of the matter relevant to the case, it's not proper for her to sit. And again, the question is, knowledge of what? Simply knowledge of the cases. We have quoted authority for the fact that mere involvement in earlier cases is in itself not the ground. I believe that's the Electoral Commission case. We did have it written out, it is quoted in our heads. at paragraph 89 of our Heads Electoral Commission of SA versus Mkhonto Wesizwe Political Party 2025, volume 5 SA, CC. The personal knowledge we suggest is not about the cases, it's about the political interference. That is the subject matter before this commission. Now, turning to the intervention of President Ramaphosa, and this will be my last point in relation to the merits. Mr. Mpofu criticizes us for criticizing President Ramaphosa for not being aware of the background. And he points out that, we all forget that people worked at particular places. And that is true. We are forgetful. But this is not being forgetfulness in passing, that you forget that somebody worked somewhere. This was the decision of President Ramaphosa. Was a deliberate decision to appoint a chairperson of a commission dealing with deeply controversial matters that would consume a great deal of time, energy, and resources. So the suggestion that you can't blame the president for being forgetful or overlooking that fact, we would suggest that is a contention that can't be taken seriously. My learned friend, Mr. Brandes, for the president, said, look, there was a duty on the judge to disclose. And I want to make reference to President Ramaphosa's affidavit 006-26 at paragraph 12. It reads, since her appointment, Justice Khampepe has not informed me of her prior involvement with TRC or the NPA. And that's important to recall. He says, since her appointment. Because Mr. Brandes tells us, look, this is like a situation where attorneys approach counsel. Can you do a particular matter for us? Counsel thinks about it, comes back and says, actually, I might have a conflict here. Best I don't do it. And the other example is a DJP allocating to a judge, not knowing that the judge himself might have dealt with it previously or have some kind of conflict. There's no suggestion that the President first approached Judge Khampepe and said, look, I'm thinking of appointing you. Let me know. The only evidence we have is that the proclamation was issued on 29 May of last year. There isn't any evidence that she was first approached to consider the matter. And then post the appointment, was she meant to come back and say, look, if you look at my CV, you'll see that I was actually at the TRC and the NPA. And we say she has a right to assume that if she's being appointed to head up a commission of inquiry of this nature, this magnitude, which could potentially run into 100 million rands or more, that the President would take the time, not him, but perhaps his advisors, take the time to look at her background. We all know that judges have lives before they become judges. In many cases, they'll have a much bigger vocational history than their time on the bench in some instances. So we would assert that Judge Khampepe was entitled to take the view that that basic check had taken place. And after all, we're not talking about some obscure history here. We're talking about service, for example, on the Truth and Reconciliation Commission, probably the most famous commission in the world. Her positions were not low profile, they were of the highest profile. Indeed, some observers may take the view, and Lukhanya Kalata pointed this out in his affidavit in response to Judge Khampepe. I don't have the reference to hand, but he said, well, given how well known her background was and how easily accessible her CV was, the view that many took was, well, she was appointed because of her expertise in this area. She has the background. She will be able to bring her knowledge of the history, her expertise in South Africa's transition to bear on the proceedings of the Commission. The allegation is made in paragraph 22 of Mr. Kalata's affidavit. It's case line 016-56. Mr. Brandes says, well, you can't expect the President and his team to have to troll the internet, to get onto Instagram. Well, we agree. We don't suggest that there was a need to troll the internet and go through Instagram or TikTok or whatever it might be. But spending perhaps a minute or so just looking at her biography, just at a CV, available on the Constitutional Court website, available at Wikipedia, University of Pretoria, that we would submit was necessary to do. And then dealing with the question of the President Ramaphosa's assertion that once he had appointed her, her hands were tied, he was functus. I don't think there's any serious dispute that if he believed he had grounds to take action and remove her, so we hear from Mr. Brandes that had he known about her background, the TRC and the NPA, action would have been taken. Well, that can't be taken seriously because, for example, from July 25, when the website was put up, on the front page of the website, were the bios of the commissioners, including that of Justice Khampepe. In the bio, it speaks about her time at the TRC and NPA in the years she was there. President Ramaphosa could have acted then. The 11th of November letter, where Weber Wenzel points out her background. If President Ramaphosa felt that this disqualified her, he could have acted then. But he didn't act, and the first we hear from him is on the 6th of March, when he enters into the fray. And it's on that score where we just want to make a quick submission on the question of costs. Clearly, President Ramaphosa is not abiding. If he was abiding, he would have simply said he's abiding, and he wouldn't have filed an affidavit siding with the former presidents. He wouldn't have filed submissions siding with the former presidents. His counsel wouldn't have been here today siding with the former presidents. Now, that being the case, he's not abiding in reality, and for that reason, should this court be inclined to award costs against the former presidents, we suggest on the strength of Lawyers for Human Rights versus Rules Board for Court of Law, we make reference to this at paragraph 158 of our heads, case lines 045-229. A party that enters the fray should also be held liable for costs. And we also make reference to another matter which is not in our heads, that's African Transformation Movement versus Speaker of the National Assembly and others, 2023, Volume 3, All SA 58, WCC. We refer the justices to paragraphs 74 to 77, and in particular a sentence in paragraph 77. On any approach, a respondent who chooses to act as if it were a co-applicant must expect to find itself treated as a co-applicant for cost purposes, should any of the opposing respondents ask for a cost order against it. No further submissions, Justice.
Thank you.
Sorry, my lord, I wonder if we cannot just move to the back and then let Mr. Manager come to where we are.
You have the court's permission.
Thank you.
Mr. Mpofu, can I have your attention?
Yes, yes.
Obviously, we running behind time, and I'm going to suggest, unless there are valid reasons why we should go. I know that we are 1 hour behind SC2 in terms of the time allocations that you suggested. I know you asked for about 45 minutes. Can we cut down to 30? Would that do justice to your matter?
No, sorry.
It won't.
Unless, yes. Unless
you borrow from your friend.
Try and do some frustrating.
You do that. More so because we were very generous. We also worked through almost through lunch. This place is hot, I must confess. There's no aircons working, and it's a punishment to be in this court.
My lord and my lady, I'll take 30 minutes.
Okay, there you go. So there you are.
Thank you, madam. I'm used to that question being raised. But, my lord and my lady, let me then just get on with it and deal with a very important part of this case, which Justice Madiba had raised pertinently, but I don't think it has been addressed appropriately. In fact, and I'm talking about the question of disclosure. And not only has that question not been addressed properly, it has been misrepresented by my learned friends. I'm not saying intentionally. Particularly to the extent that they say that it is not in the pleadings. They both said that, and it's completely wrong. But before we get to the pleadings, let's just talk about disclosure, the whole notion of disclosure in respect of not just a judge, but any chairperson of a tribunal such as the one we're talking about. And maybe let me qualify that as well, just in case I forget. That everybody has been saying that we have been asking for Justice Khampepe to be judged by the standards of a judge. We have not. We have specifically said, when in the first few paragraphs of our pleadings to this court, she is cited here in her non-judicial capacity as the chairperson of the tribunal. Now, of course, she's a judge as well, and that may or may not provide some aggravation as to how she would have behaved or not. I would actually venture to say it does, but that's not our point. Our point is that take her at the lowest possible threshold, not the highest of a judge. And that is why we have pleaded in the alternative under the declarator to say if they have their way that she must be treated as a judge, then she has breached section 165(2), I think, the one about without prejudice and so on. But we go on to say immediately, if, as we would have it, she must not be viewed as a judge, then she has, in any event, breached section 195(1)(d) of the Constitution. So it matters not for us if she has breached a constitutional provision, whether it's 165 or 195, it means absolutely nothing, no difference. And so I'm making the submissions on the basis that the lowest possible threshold has not been met, let alone that one of the judge, if she's going to be. So I just want to put that aside and let's come back to this question of disclosure. Disclosure I don't know why we have to make this point really to our learned friends. I think it was Mr. Maneche who made those examples about disclosure that we do as lawyers every day when there's a potential conflict, so even as tenuous as possible. And I don't want to sensationalize this, so I'm not going to mention names. But this court itself last week gave us an example of a disclosure, well made. And we all said, it's fine. But if that little innocuous disclosure, because quite frankly it was, in my view, not even necessary. But if that had not been made, my lords and my lady, and then it is discovered now, in the middle of the case or at the end of it, that's a major issue. And I don't know if we appreciate this issue of disclosure. It's like, just another thing that you must just brush aside. The lack of what the NPA calls the lack of candor in this matter is a major issue which should decide this matter one way or the other. In fact, on a lighter note, my little friend Mr. Barney disclosed something else to me. I don't know if he disclosed it to the other colleagues about his past association with someone who also remained members in some board or whatever. And I said, don't worry about it. But
so was it a frank disclosure?
It was very frank.
But it was not open to the rest of your colleagues?
No. Oh, was it also? It was also, okay, rightfully, it was also made to Mr. Maneche. And again, as I said, I don't want to sensationalize, so I won't say I'm just making this point to simply say the failure, the mere failure to disclose something as important as this. Just to say, Mr. Maneche gave you this laundry list of things that show that these are not vague or generalizations and so on. And one of them was the fact that Justice Khampepe said in the amnesty hearing, concerning, I think it's called the Motlatsi family, and another one about the Pepco 3. People who are members, as we speak now, of the Talata. Just to disclose that alone. And to disclose whatever it is that she, in her capacity as deputy NDPP, may have discussed with Mr. Mbeki about these cases. Whatever it is, tenuous, it might have been some discussion in the passage, or, you know, but as long, it's incredulous to say that in the year or so that she was working there, when this point of the TRC cases was so hot, there was never a discussion between the deputy and the head. Oh yes, the reference, thank you, is on 006-24. That's the Mutasi family. And then there's another one at 9.4. And then, of course, we know, in respect to the reverse rule, the so-called ANC 37 decisions that she was involved in. Those involved former President Zuma, former President Mbeki, former Minister Ronnie Castles, former Minister Charles Nakula, and I think former Minister Mobandla, if I'm not mistaken. So these are specific issues of people with names and surnames, not generalities, who in respect of whom potential conflict arises. Now, if you don't disclose that, I mean, that's why we don't call it non-disclosure. We call it active concealment. That's as far as we go in our founding affidavit. We say this is an active concealment. In other words, when you have a duty to disclose, your silence is not just silence.
Do you have a reference for us?
Yes, we'll find it, yes. In the founding affidavit or the supplementary. We'll find it, yes. Now, Justice Parker correctly says, look, to Mr. Mbeki, just even using the Plascon event standard, the denials are so weak and tenuous that, quite frankly, you just don't even have to take them seriously. If they are not bare denials, then they are just, where are the emails? Where are the WhatsApps? Where are they? And we are told here.
Mr. Zuma says he has them.
No, that's not true. I explained this to you, Justice Mudau. I explained this to you exactly yesterday. And you, again today, you say to my learned friends, I asked that question, didn't I? But let me explain it again. There is nowhere in these papers, Justice Mudau, that you will find Mr. Zuma saying he's in possession of the emails or the WhatsApps. Mr. Nwakaitobi tells you that Mr. Zuma said, I will disclose the information if the safeguards are given. Mr. Vani says, I will disclose the evidence if the safeguards are given. Evidence could mean bringing the whistleblower, putting them on a stand or whatever, on some, behind some microphone, I don't know, muffling their voices. There is no way. Let's just get this straight so that this case must never be decided on the wrong information. Somebody must tell me where it is that Mr. Zuma says he's in possession of the emails. I'm not even saying he's not, I don't know whether he is, he might be. But in these papers, before this court, there is nowhere where it is said that the what you call the emails or the WhatsApps and his position. But let's put that aside. Now that that is clarified, that then means that firstly, we have a right to demand the disclosure of those emails. By the way, even if Mr. Zuma had the emails, he still has a right to demand disclosure. There's no such, it's the first time I hear that when you ask a party to discover documents, they must only discover those things that you don't have. It doesn't work like that. Well, everyone has ever seen a discovery affidavit will see that you even list the letters that came from that attorney of the other side. In other words, you even list their own letters. They obviously have those letters in their possession. But even that is put it aside. So this is a disqualification that is just created. Sorry, Justice.
In his address, Mr. Mugaitobi referred extensively to the ruling of the chairperson.
Correct.
And he divided it into portions, pillar 1, pillar 2.
Yes.
In his submissions with regard to pillar 4, he made this assertion referring to the ruling itself. I think it's at paragraph 73, if I'm not mistaken. If I'm misquoting, I'm sure Mr. Mbeki will correct that.
I also remember the
Yes, and then he quoted what the chairperson said, citing what was said about the possession of these.
Yes. Well, I can tell you as an officer of this court that when what I've just said now, there is nothing, I'm not saying something here which contradicts something I said at the commission, I can assure you. 2, Justice Parker, let me just make this statement, which in fact I think you alluded to it, but in a different context. Our submission, Justice, is that which the chairperson said in her ruling confirms our view that the emails exist. I made that point yesterday. Why do I say so? Because as you correctly pointed out, she says, if somebody can find me the ruling, she says, by the way, I never gave Mr. Zuma any permission to intercept my private communications. What private communications? So the point we make is that that's what I was saying yesterday. If somebody says, you've just done this, you don't say, well, how did you get it, and so on. You just say, I don't know what you're talking about. And so that's the point we make about that I accept that she said those things in the ruling. And I've assured you that they did not emanate from something that was said which suggested more than the whistleblower information. But the point is that both the non-denials and the half-denials and all that, and this thing about private communications being intercepted, can only serve to any reasonable person to confirm that this is what I call the confession and avoidance. Yes, it happened, just as the official spokesperson of the commission, no less, said that I've spoken to the chairperson, and she says, I did give the advice, I'm sorry, I'm paraphrasing, but there's nothing wrong with it. So if all of those things put together do not convince a person that at the very least what these people are saying is that, yes, this happened, but it's legal at best, which is and that's what then shifts the onus. If you do that, if you do confession and avoidance, it's allowed in law. But then it shifts the onus to you to tell us what the avoidance is. Because as I said, it's a mathematical formula. Confession plus avoidance. Take away avoidance, you're left with confession, which is an admission. Simple. And And that is the issue. But let me not be distracted from my train of thought. The point I'm making, Justices, is this. On this point of disclosure, by the way, it's one of the most egregious forms of the misapplication of the law by this chairperson. And I'll tell you why. She says at all right. She says Mr. Mpofu referred to the Pinochet case, and the Pinochet case has nothing to do with this matter, she says. Now that is a misrepresentation of our argument, but more importantly, the Pinochet case is the locus classicus, it's an international precedent on this question of reasonable apprehension of bias. And anyway, the Pinochet case, I don't have to repeat the facts, I'm sure the court knows. But the essence of the Pinochet case, and we've uploaded it, it's at 055 big A dash 428, sorry. At 077-997 is where the chairperson refers to the Pinochet case. And we had only quoted it, by the way, on this question of disclosure in the recusal application. Now, just because of time, I will let me paraphrase. That judgment was about Lord Hoffman, who had not disclosed to his fellow judges of appeal that he was a board member of Amnesty International or one of its affiliates. And that judgment is important for two things. One, for this issue of disclosure, and two, for the distinction between actual bias and reasonable apprehension of bias. The judges will remember how each judge was at pains, because this is a very esteemed member, Lord Hoffman. Each judge was at pains to say, we are not finding actual bias against you, Lord Hoffman. But when it comes to reasonable apprehension of bias, you must go. And there were, I think, 4 or 5 judgments. And that includes something called the appearance of bias, which I like. I also like that formulation. And that formulation you will find in probably one of the shortest judgments. This must hold the world record of the shortest judgments. The judgment by Lord Nolan at 055 A-444, where he just says, I agree with my views expressed by my noble friends, and so on. And then this is all he says. I would only add that in my case, in any case where the impartiality of a judge is in question, the appearance of the matter is just as important as the reality. Very profound. The appearance of the matter is just as important as the reality. And that's all he said. That was the end. The other judges were more, explanatory. And I'm just jumping this because of time, but I want to zoom into the one about disclosure. So if you go to 055A-445, you find that in the judgment of Lord Hope of Crickhead, whatever that means, said, it is no answer for the judge to say that he is in fact impartial and that he will abide by his judicial oath. The purpose of the disqualification is to preserve the administration of justice. from any suspicion of impartiality. The disqualification does not follow automatically in the strict sense of that word, because the parties to the suit may waive the objection, like we did here. But here's the important part. But no further investigation is necessary, and if the interest is not disclosed, the consequence is inevitable. Right? So that sentence covers everything I've said. The parties may waive, they might say it's fine, let it go. But they say, but if there is no disclosure, the consequence is inevitable. And we presented this to the chairperson and she ignored it. Yes, also at the end of that judgment, that Lord said, this is now at 447, there has been no suggestion that he was actually biased, showing the distinction. He had no financial pecuniary interest in the outcome, but his relationship with Amnesty International was such that he was in effect acting as a judge in his own cause. I consider that his failure to disclose these connections leads inevitably to the conclusion that the decision to which he was a party must be set aside. The court will consider this at its own time. Let's come now to the question of the pleadings. We're told that this has not been pleaded. Well, for shorthand, I will take you to our heads. If I can just take you to our heads. Mind you, this part is, sorry, I'm laughing because of something, the dangers of cut and paste. So this part is taken directly from our founding affidavit. But you'll see amusingly that at 145.4. Oops. Well, I did say we're in the dark in this case.
It's a generator. It should come.
or record. Or record.
Another 15 minutes again.
Barry.
I was just giving Justice Khampepe the reference to the issue of active concealment. Yes, you'll find that at 004-37, Justice, paragraph 17 of the supplementary affidavit, where we say, I am advised, we refer to the spokesperson and all the other things I've spoken about. Then we say, I am advised that it will be argued that this is a blatant case of active concealment of the relevant evidence, which will be of great assistance to the court in adjudicating the Rule 53 review application. It also constitutes malicious compliance, which deserves, should be deserves, not it says deserved here, but deserves to be punished by the appropriate relief as well as punitive and officer cost. So that's where we call it active concealment. And I don't have to develop that. Since yesterday we've explained that it can never be that on the part of a judge, senior counsel, 3 senior counsel in that team, all of them don't know Rule 53. In fact, one of my learned friends, I think, was in the Helen Suzman matter, so he knows exactly the ambit of Rule 53.
I thought this issue was raised in relation to trust associations.
No.
The non-disclosure issue.
No. It was raised in relation to the misconduct, the alleged secret communications. So it was raised in the context of our Rule 53(1)(b). In other words, the accusation that they have not disclosed actively. So it was certainly not on past associations. It was.
That's not how I understood the point.
No. I agree, Justice. I'm saying, yes, you are right. As far as Mr. Manet's argument was concerned, because Mr. Manet, we're arguing different parts of the case. He's arguing the associations that are doing the misconduct as such. Yeah. I mean, we overlap. But all I'm saying is that the question of, in these pleadings, the question of the active concealment or non-disclosure, let me put it that way, is pertinently raised. Firstly, A, as active concealment, which is even higher than mere non-disclosure. And then I also say, Justices, it's totally incredulous to say a case where we spent 2 hours yesterday debating about the failure the Oxford Law Dictionary definition of discovery is that it is the disclosure of documents by a party who has those documents to the other parties. That should be obvious. So this was our entire thing. That's why we said we can't move in this matter until that disclosure. But more than that, Justices, if you go to the founding affidavit, oh yes, I was making the point about when we had the blackout, about the cut and paste. I was saying we cut and pasted the allegations from the founding affidavit, but where it said, I do this, which was President Zuma, that found itself in the heads, so we apologize for that. But that cut and paste you'll find in the heads themselves or in the founding affidavit. I'll refer to the one in the heads, just for shorthand. It's 055-42. Because we are told it is not pleaded. So we say, fail to take into account relevant considerations and remember my previous thing about Pinochet is that disclosure is a relevant consideration in the context of bias. We say, and we list, including 1.5.4.1, the failure of the respondents to deny the allegations of the misconduct, the failure by the chairperson to submit any statement in contrast to the position in SAFU that was discussed at length here.
Where are you reading from?
I'm reading from our heads, Justice, which are
Which paragraph?
055-41 to 42.
Paragraph?
145.5.1 and then 1.145. I'll stop at 4.4. So the points there are the failure to submit any statement in contrast to the position in SAFU. Mr. Manager dealt with that. And then said the distinction between administrative and judicial roles, you can ignore that in the context of what I'm saying. And then 145.5.4, the binding and total prohibition on undisclosed communication with only one party in a dispute. So that's the S versus Roberts point. The point I'm making is simply that firstly, the non-disclosure is the most central point of at least of the misconduct issue. But it also, as far as Mr. Maneche's case is concerned. So let me move away from that. And the overall point is really this. If this court agrees with us, whether it's myself or Mr. Maneche, that the duty to disclose was breached in any form whatsoever, as it was in Pinochet, then the decision has to be set aside. But to round it off is to say Justice Bakwa yesterday then said, no, but he who alleges must prove, which is true. But not in this context, because here we're talking about a duty to disclose, and all my colleagues had explained that that duty definitely lies with the party who has the information. In other words, silence on the part of that party is itself non-disclosure by omission, if you like. So I want to put that to bed. Then let's come to the other issue that Justice Parker raised with my learned friend Mr. Vani about the internal contradictions in their case. So there are two internal contradictions. The one is, the one is about between Section 47 and saying, oh, you know, you are wasting the time of the victims and what have you. Because if you uphold the Section 47 point, there is nothing under the sun that can waste the time of the victims more than that. Because we're not going to go away, I can assure you. What would then happen is that this matter is going to have to play itself out time and time again for another 6 months or whatever. But the answer to that was given by Mr. Mkaitobi in a very subtle throwaway comment he made at the end of his Section 47 point.
Just remind me.
He said, well, if you are with me, then you must dismiss the application or strike. Now, that word or strike, and he was right, was a grudging acknowledgement that even in the worst case scenario of this so-called Section 47 point, the outcome might be to strike the matter off. Now, we all know what that means as lawyers. It means it will just have to come back. It's like agency. It's not so all I'm trying to say is that there is nothing that would ever be not in the interest of justice than to say in this case the Section 47 so-called bar is upheld. But you don't even have to go there, because the Section 47 point has no merit on its own hind legs. The Section 47 point, Mr. Mkaitobi keeps on saying you must prefer Mantashe between the Mantashe and Memela. Now, I made submissions yesterday, and I said, okay, let's concede that. I'm not prepared to be debating Mamela versus Mantashe. But I'm saying, even if you uphold Mantashe, you still cannot apply Section 47 in a situation where A, there's a retired judge, and B, we don't know which court, which head of court must be consulted, and C, which is more important, the citation of the judge in this case is different from Mantashe, because the citation of the judge in this case is identical to the one that was in the corruption watch, the other corruption watch case. That's the point. Because once, and maybe I don't want to be testifying from the bar, but I can assure this court as its officer that the citation of Justice Khampepe in this matter was not some glib thing that happened by chance. It was modeled on the corruption watch kind of citation. And it says, I'll read it again, I know I read it yesterday. It's paragraph 4 of our, sorry, Justices. I know that I was late. Well, I'll find it just now. But it says, I'll paraphrase it. It says, you'll see that it starts with a heading, by the way. With the heading, we'll say, it's the case of Jacob Zuma and the chairperson of the commission, Commissioner Khampepe. That's not a coincidence. Because that is the capacity in which was being cited. But if you say, oh well, you could have put anything there, just to show you that it was not a mistake. We say the first respondent is Commissioner Khampepe, and I jump this the other history. She is cited here in her non-judicial capacity as the chairperson of the Commission of Inquiry appointed by the President in terms of Section 84(2)(f), read with Section 1 of the Commissions Act. That is identical to the citation that is in Corruption Watch. And so Mantashe or no Mantashe, this is a case where you are bound by the Corruption Watch case. My learned friend, Mr. Mbeki, I'm not sure which of my learned friends, says that they're not aware of a case where there was a judge cited in this kind of situation and Section 47 was not complied with. Well, I want to remind them that they end up, unlike Mr. Vani, I don't expect them to remember this from Wikipedia. But I want to remind them that both Mr. Mbeki and Mr. Vani supported an application that I had brought in the Marikana Commission, which later became the Constitutional Court case of Magediwana versus Legal Aid and so on. And in that case, I know this because I did the pleadings. Obviously, because of the interest of the Commission, we cited the Legal Aid Board and so on, but cited Judge Falam, who was chairing, a retired Judge Falam, and Judge, now he was not a judge then, Judge Tokote, and the third person, and that, in that case, there was no, we never asked for Section 47 from, I don't know who, I suppose in their formulation it would have been from AD or something. But, so I'm just reminding that as an example. But the point I'm really making is that the section 47 point on its own is not good in this case, even if you prefer Mentasha, which is wrong. When Mentasha was wrongly decided, that's our view. But even if we're wrong. Now, I think it was Justice Mudiba who introduced the nice concept of value chain. And I'm making this point in relation to the so-called, I don't want to enter the debate, Justice Black, about wrong test and the right test and so on. To shortcut this, I'm going to say even on the test articulated on the wrong test articulated by the chairperson, she fails that test. So irrespective of whether it's the right test or the wrong test, because her test is called the logical connection test. So let's call it that. Now, if you take the value chain theory, and Mr. Manager was at pains to point out that we are talking about the ordinary member of the public here. You want to tell an ordinary member of the public that a person who decided amnesty decisions about the non-prosecutions of persons and then went to work at the place of prosecution called NPA, where those people were supposed to be prosecuted, must now investigate whether her two former employers did something wrong. I mean, if you talk about logical connection, nothing can be more than that. The point here is that you know, let me put it this way, so I think this point will just then make itself. Everybody, this is a matter of fact, everybody, but everybody who stands to be prosecuted for apartheid atrocities was denied amnesty. There are no exceptions to that rule. That is why this commission is called the Commission into TRC Cases. So if you are just a random apartheid murderer who never went through the TRC, you are not covered by this particular commission. This commission only covers every single person who was once denied amnesty by Justice Khampepe.
Mr. Mpofu, of the time allocated in my watch, it's about 6 minutes left. But for the interruption of power, you would have finished at about 4:15. And so by 4:30, I anticipate that perhaps you should be closing now, so that your colleague can then have an additional 30 minutes.
Justice, well, and if you insist, but I really would have wanted to give an opportunity to reply to some of this.
No, by all means.
Yes. All right.
We have to balance that for the reasons
that
you mentioned yesterday.
I understand.
Let's be sensitive to that. This is central Johannesburg. Some people take taxis and all of that.
Yes.
Yes.
No, I am. But, you know, for the record, I only took 10 minutes more than my allocated time, unlike all my learned friends, except Mr. Van. But that's fine. That's fine. I know. Now, the point I want to make is that not only is it not true that Mr. Mbeki tried to cloak the Section 47 as a jurisdiction, but I think his what I call his subtle concession is that it is not when he talks about striking. But I want to say, maybe let me make this point because it's very important and my client feels very strongly about it. It has been said by Mr. Vani, wrongly, that everything we say here is all about the rights of former President Zuma and the rights of former President Mbeki.
And not those of victims?
Yes, and not those of the victims. And this is a narrative that is peddled by the so-called usual suspects in the media and everywhere. This is addressed pertinently by President Zuma at 004-44. And I'll just read it as it is.
Can someone invite us as you?
Oh yes, 004-44.
I'm not being invited, I don't know.
44 onwards. He says, in this regard, it will also be imperative at this stage, once and for all, to deal with the false notion peddled in the ruling of the first respondent, and unfortunately echoed by some of the participants, that the recusal of the first respondent would somehow exacerbate the previous delays in obtaining justice for the victims. Nothing could be further from this one. You finding it, Justice?
There's no invite in my case, but I can punch it. Okay, I'll share with my sister.
All right.
Oh, 0444. Thank you. Council may proceed.
Thank you, Justice. Unfortunately echoed by some of the participants in the recusal of the first respondent would somehow exacerbate the previous delays in obtaining justice for the victims. Nothing could be further from the truth. First, this theory is premised on the myth that the remaining commissioners would be incapable to carry out the work of the commission and, or if needs be, to chair it, irrespective of whether or not the first respondent may be replaced. The fallacy of this argument will be exposed during legal argument on my instructions, which I'm doing now. Second, and most importantly, the notion that the long-suffering victims of some of the most heinous apartheid atrocities may obtain quote-unquote justice, fake justice, that means, from an unjust, biased, tainted, and illegal commission is nothing short of misguided with respect. To the extent that those who support that narrative rely on the media hype or legal advice, then they are badly advised. The plain truth, of course, is that true justice can only be achieved when the process itself is conducted in line with and not in breach of the Constitution and the law. To argue otherwise is both incorrect and short-sighted. No good or valid outcome can possibly arise from a flawed and illegal process. Therefore, and contrary to the false narrative, delays of justice can only arise from the recalcitrant refusal to step aside even in the face of apparent misconduct and blatant bias, but not from asserting the rights enshrined in the Constitution. Similarly, the narrative that the applicants have something to hide is equally mischievous. For the record, I outrightly deny any insinuation of having made any illegal deals with the alleged murderers and their representatives. There is therefore nothing to hide at all in that regard. On the contrary, I will present my version in that regard on any day before any other commissioner who is not tainted by bias or other illegality. There are hundreds, if not thousands, of suitably qualified individuals in this country who can perform that task. It is not reserved for or preordained for any specific individual. So that is something directly to address the victims. Because what all you are saying to the victims is, and we understand their frustration. There's no one who understands that more than I do. I said and I was corrected by Mr. Talata, Mr. Talata and his man here. I said, and I'm repeating it, I'm probably the only person in this room, except for the victims themselves and their families, who attended the funeral funerals of these people, of the cradle four. And to any suggestion that this demanding justice and fairness and equal treatment is aimed at them must not be repeated by anyone who knows about the history of this country, because it is false. The last people to do that would be President Mbeki and President Zuma of all people. So any delay, the reason we're here is not because President Zuma and President Mbeki want justice. It's because Justice Khampepe refuses to recuse herself, even in the face of the person who appointed her, saying she must do so. So let's put that aside. The last point is that I was saying that the metaphor or allusion of the blackout that just happened now is what we said about yesterday, that we are forced to litigate in the dark. We are litigating in the dark exactly because we don't have the information that will lead to the resolution of this matter. And I'm saying that in relation to the relief, because Justice Khampepe also raised this question of the relief that we seek. Another delaying factor that will take place here is if this matter is referred back to the Commission for any reason. Because to do so, we simply, once again, I can almost put money, given past experience, will bring us back here in the next couple of months. Because the outcome will be the same, if not worse. And therefore, we implore this court for the reasons that somewhere I'm now rushing against time. Towards the last few submissions, allegations in our founding affidavit, Justice Khampepe, you'll find that we say this, in this case, the case for substitution has been made. And that's the submission I want to make. And before I sit down, I want to say that for that proposition, ironically, we rely on the very good judgment of Justice Khampepe in Trencon, the well-known Trencon case. In Trencon, Justice Khampepe said, there's no point in taking a decision back to the to that tribunal where it came from. It would be a waste and an exercise in futility. Sorry, because, and she said there were four requirements. And she articulated, I'm just going to paraphrase. She said, when you substitute, one, there must be exceptional circumstances test. I'm sure everyone agrees about exceptional circumstances in this case. Two, the court is as well qualified as the original authority to make the decision. Three, the end is a foregone conclusion, as I've just said. And four, bias. All those requirements articulated by Justice Khampepe must apply to her as they apply to those she mentioned them for. And equally, I don't have time now to talk about costs, but I will refer this court to paragraph 175, and I stand corrected here, 227 of the Public Protector versus, is it 237 of Public Protector versus SARB. So sorry, I promise this is my last submission. Okay, it's here. I've got it. It's 237. Okay, I'm going to have to strain my eyes. It says, and it's the last thing, and all I'm saying is that it applies to her. She said, Justice Khampepe with Justice Teron in that case, regard must be held to the higher standard of conduct expected from public officials. And again, that applies whether she's 195 or 165. And the number of falsehoods that have been put forward by the public protector in the course of the litigation. This conduct includes the numerous misstatements like misrepresenting under oath, the reliance on evidence on economic experts in drawing up the report, failing to provide a complete record, right, ordered and indexed so that the contents thereof should be determined, failing to disclose material meetings or WhatsApps and emails, and then obfuscating the reason for them and the reason why they have not been previously disclosure again. And generally failing to provide the court with a frank and candid, that's the NPA's word, candor, frank and candid account of her conduct in preparing the report. The punitive aspect of the course order therefore stands. That was Justice Khampepe.
Is that what you're asking for?
More.
Or you're asking for more?
I'm asking for the punitive costs, and I'm also asking for personal costs. Because in the same way that in that case, remember when I'm talking to her as an administrator, she's not better or worse than the public protector that was being dealt with in the SARP case. So for the same transgressions and the same failures of non-disclosure, and if in this case, if you apply the fact that she's also judicially trained and a person of who probably has even a higher standard to uphold than the public protector, if there's such a thing, in this case, those costs are more than well deserved, but certainly punitive costs. And we would say that what was good for the public protector, Kobana, as she imposed in that matter, is good, must be good for her.
Is that your last word?
Well, if you ask that question, it won't do justice. Sorry, just 1 second, Justice for the question. Oh yes, thank you. Just references, I promise. I won't make any submissions. There was I think my learned friend, Mr. Vani, again, inadvertently, I'm not suggesting he was misleading the court, sought to demarcate our case as if the misconduct allegation is only about actual bias, but not about reasonable apprehension of bias. And I corrected it, I think.
You started with that when you were addressing my sister?
No, it was when he was speaking, then I clarified it, but I just want to give you the references. So, and it's 055-9, that's 25.1 and 25.2 of our heads. And then, I hope is that correct. And then 55-10, okay, these are all heads. And then actual bias and misconduct of 55-14. So all I must, let me say this because I can't vouch for this. The only point I want to make, Justice, is that everywhere, including in front of the Commission and here, our case must not be misrepresented. We say that, yes, as far as the exchange of emails is concerned, it's actual bias. It can be reasonable. It can be negligently corrupt. But we say, if we are wrong about that, then at the very least, this kind of behavior, the active concealment and all that, surely gives a reasonable apprehension of bias to a reasonable observer. So in other words, that same ground we use it. But obviously, when it comes to the vocational history, it's only about reasonable apprehension of bias. I just wanted to clarify that.
Thank you, Mr.
Escort, Mrs.
Where's the mic?
Escort, please. My lords and my lady, I'm going to follow the structure of the argument as presented by my friend Mr. Toby. The sequence of issues, and we stand by everything we said in our 3 sets of heads,
Yes.
and I don't have to repeat what we argued today. On section 47, we just want to make an elementary submission that the interpretation of a statute is an objective exercise. A statute doesn't mean something given the facts of a particular case and something else for the facts of a different case. Whether an acting judge cited nominee officio in a representative capacity of the office the person occupies at that particular time is covered by section 47 doesn't depend on the allegations that Mr. Zuma makes against that nominee officio citation. So if it was, this is a beautiful judge, then nothing was said about, anything negative was said, but they were acting nominee officio in a representative capacity. The section means the same as it would mean in the context of this case. So the submissions you had from both of our learned friends going to chapter and verse of what former President Zuma has alleged about Justice Khampepe is completely irrelevant to the interpretation of the section. You apply the established principle of text, purpose, and context, and you determine the meaning of that section. And also bearing in mind that it must be a constitutional, you must prefer a constitutionally compliant way. And we submit that in Justice Mbenenge's judgment, Justice JP, he referenced section 47.2 as another indicator that the section is limited to the capacity as a judge. Because in that section, when the permission is given to subpoena or summons that judge, the head of the court must be told when that is going to take place in the life. That shows it is there for the proper management of the court to ensure that the judicial function is effectively and efficiently carried out. There is reliance on the word service. In Full versus Mutata, Mlambo JP, in paragraph 24 and 25, discussed service. That was entirely obiter, firstly, because Judge Mutata was cited in his capacity as a judge relating to the outcome of the disciplinary inquiry. It wasn't in a representative capacity. That's the first point. The second point is that in paragraph 24 of the judgment, and the court will have regard to it, Justice Mlambo made an obvious error to thinking that the word service is defined in the Superior Courts Act. He says in this act, when in fact there is no such definition there. So when Justice Dipenar says, I also rely on the service determination in Full versus Mutata, she's relying not on a binding dicta, because that's not the ratio for the decision, it's an obiter statement in Full versus Mutata. But secondly, she doesn't bear in mind that that was an erroneous reference to the Superior Courts Act. So Justice Mlambo didn't determine whether service should have an implication for the interpretation of the Superior Courts Act. He assumed it was in that section, in that act. Because otherwise you'd have to explain how one interprets one statute by reference to a different statute which deals with different material. They're not in pari materia, as they say. Remuneration of Judges Act is about remuneration for the service they undertake. And that's why it's broader in scope. But section 47.1 is not about remuneration. It's about protection against, it provides a hindrance to access to court by litigants. So it is a provision that must be narrowly interpreted. All of those judgments on section 25.1, only until Mantashe, all of those were concerned with either judges cited in their capacity as judges or cited in their personal capacity. None of them were about commissions of inquiry where the judge is serving and is cited nominee officio. Those kinds of cases are Corruption Watch and like. As for using Mantashe for the present case, there is another distinguishing factor which is important for this case, which is always overlooked, is that in Mantashe, the Chief Justice was still in active service and made the point. Here, Judge Khampepe is not in active service. In his answering affidavit, and you'll see from our note, the CJ said, I am both the CJ and I am the chairman of the commission. So there was potential there for interrupting with the judicial function, which doesn't arise. So even on the expanded meaning that is being presented to the court, Mantashe remains distinguishable from the present case. And that is why this court, being a full court, will have to make its own determination as to what is the proper interpretation of section 47(1). Does it apply here? And we submit it will do so having regard to the context of the actors as a whole, and not the section in isolation, because that's not how we interpret legislation. That's the first point to respond to. Then the Pacha point. The Pacha point really rests on a proposition that there is no breach of rights. I had opened, could you open Take and Save? It's Take and Save, it's in our bundle of authorities. Yes, because in Take and Save, paragraph 2, it makes it very clear what rights are breached when a judge who ought to recuse himself or herself refuses to recuse himself or herself. It's the same as Sarfu at paragraph 30, which I referred to the court. But Take and Save says it a bit more. Justice Harams then explains it better. But we say again, with respect, that it's a very interesting debate by our learned friend, Mr. Nico Atobi, in relation to our case. But it doesn't matter for our case. As you heard it, all of the grounds of review that we raised are legality grounds. It's either re-res or rationality. That's all. So we are in legality. All he can say is that the rationality standard, when you come to the assessment of facts, is differential. We accept that. It's differential. It sets a lower threshold. But what Take and Save, the paragraph 2 that I want to refer the court to, the court will find at 056-687. And it says this: everyone is entitled to a fair trial, and that includes the right to a hearing before an impartial adjudicator. This common law right is now constitutionally enshrined. Present a reasonable apprehension of bias, the judicial officer is duly bound to recuse himself or herself. The law in this regard is clear, having been the subject of recent judgments of both this court and the Constitutional Court, and does not require any statement. So in testing whether there is an adverse effect on rights, one has to assume that she should have recused herself, because that's the only way one tests that. If she had to recuse herself, then there is a breach. That's the Pacha point, but it's really an exercise for academics. Then the legality review. Our learned friend borrows from Pacha and says, even legality review arises only in the case of finality, where there is an adverse effect on rights. It's got no, you refer to some authority. But that's a wrong proposition. At least, at the very least, well, he then says, decisions, findings by commissions of inquiry and recommendations have no capacity to adversely affect rights, because they must be either accepted or rejected by the president, or whoever the commission is for. And therefore, decisions of commissions of inquiry do not have final effect. Well, just in the context of Pacha, he forgets that commissions of inquiry perform a range of functions. When you look at the rule, you'll see the rules, you'll see that Justice Khampepe decides gives directives and the like, and can employ people. So when she dismisses somebody who takes it to the labor court, takes the commission, you can't say, well, this decision has no effect. You must look at the character of that decision. So if a recusal ruling has finality, because there's no suggestion that Justice Khampepe is going to reconsider it tomorrow. No, it's a final decision. She's sitting, and by sitting, it commits an irregularity every day. So that's final. But if the proposition was correct, then there would have been no review in Corruption Watch, because that was a legality review of findings and recommendations of the Security Commission. So that puts play to all of that discussion about why the legality review is not available to us. I turn to the ground of review. Here I'm as bold to say, with respect, that the argument of my learned friend Mr. Toby on the test, on the legal test, and the argument of my learned friend Mr. Vani make the case for me. Because my learned friend Mr. Toby was forced to support the test the justice adopted, which I will show it's a wrong test. And Mr. Vani, implicitly realizing the error, went to the right test at paragraph 78 of Bennett versus Absa and tried to show the court how in the application she still got it right. So this is the ground of review from my learned friends. Why do I say so? Let me take you to paragraph 43 of my learned friend's note for argument. That's Mr. Nuka. In paragraph 43, he says, getting the test right. The allegation that the chairperson misunderstood the test on recusal is unfounded. The test is that explained in Bennett, and he quotes paragraph 53. You will see in that test, in that paragraph, that the court was dealing with a reasonable apprehension of bias based on financial interest, a shareholding interest that they said just actually ahead in ABSA. The same with Masuku. It's also about money. It's a financial interest. In this case, there is no allegation whatsoever that Justice Khampepe has any direct interest in the cause before her or in the outcome of those proceedings. So we're not talking about a financial interest, we're not talking about a direct interest. When you go to ABSA, well, Masuku may not have been about money, but, or is Kosen, I think that's what I'm referring to. But even Masuku, I think I'm wrong. So the courts, they refer to Masuku, I think that quotes Kosen, and paragraph 69. It's all about interest. It's about direct interest in the outcome. So we're saying you have a personal interest in this litigation, you can't sit. And it's important to take a step back. So when we know the general test, the double reasonableness test, that's the standard for recusal. But different facts give rise to the double reasonableness test or the inquiry into it. Sometimes the objection might be that you have a financial interest. Sometimes might be that you have, this is a case you've already judged, you prejudged the case. And in other cases might be prior associations. What the Constitutional Court was doing in Bennett was to ask itself, if it is dealing with financial interests of the nature of shareholding in a company, when would that shareholding give rise to the double reasonableness test for a reasonable apprehension of bias? And the court will find in Bennett that the paragraph 53 is in the context of that discussion. So a paragraph...
Just one moment. For some technical reasons, my brother has been disconnected. I'm going to share, in the interest of time, my laptop.
I appreciate
In the
that.
meantime, my registrar was trying to assist him to reconnect. So it will serve a useful purpose, a very useful purpose, if someone was to invite us.
Yes. I haven't given any, sorry, have I given, in relation to the judgment, I haven't given a page reference yet. Can I just ask you to take the court to Bennett versus ABSA, paragraph 39. Paragraph 39 is 059 dash, my page is cut off at the end.
Until and unless we're invited, we can't be of any help.
Yeah, yes, paragraph 39 is it? 056-123. Yes, and you've been directed. You see the heading is recusal, and it talks about the shares in paragraph 39, and it carries on. And at paragraph 42, what page is that? It should be the next page. It's shareholding in ABSA by Kachelia JA. And you will see, and then 43, it talks about the disclosure. And then 45, it deals with the applicable legal principles. It said ownership of shares in a
Not so fast. Where are you?
056-126 on applicable legal principles.
One moment. 056 day hyphen what?
126.
No, it's not taking me like this. Just suppose the just see what one. Can I just be invited again?
I invite again, please. I'm sure this will be injury time. I accept that there is no injury time. I'm not negotiating. With justice presiding. Is the judge, are the justices there?
Well,
Not yet.
My neighbor is there, not me.
Oh, maybe sharing is caring. So, under the heading applicable legal principles, you see paragraph 45 says ownership of shares in a litigant company is one of the possible sources of interest that a judicial officer can have in a litigant. And then you look at the last sentence of that page, of that paragraph, says the question for decision in this case is when will shareholding or other financial interest in a litigant company by a judicial officer give rise to a reasonable apprehension of bias. Then they discuss all of that, and they discuss, the justices are discussing, then they get to paragraph 53, which is at 056. Yeah. They say 056-130.
We are there.
They say the approach of our law to perform must be informed by our test for apprehension of bias. And then they go on. At the last two sentences, what is required is the articulation of the connection between the interest alleged and the feared deviation from impartial adjudication of the case. But we must at the same time not lose sight of the fact that at issue is not whether there was actual bias, but whether there was a reasonable apprehension of bias. 54, it seems to me that asking the question whether there is a realistic possibility that the outcome of the proceedings would affect the judicial officer's interest is a useful practical method of deciding whether a judicial officer has an interest in the outcome of the case. And then they deal with all of that. They conclude on interest, and they stop. They conclude that the court will have a look at that, but they really, I think, concluded at paragraph 66, where they carry on application of principles to the facts. So they identify the principle, then they apply it to the facts from paragraph 67, which is 056-138. So they decide the shareholding issue, and then you recall at paragraph 74, they go back to the question of delay, because here the complaint was raised late. And then the conclusion on the financial interest is at paragraph 77 in this page, 056-142. And they say at paragraph 77, for all these reasons, the applicant has not made out a case that Kachelia J.A. should have recused himself by reason of his shareholding in ABSA. Finished. So both my learned friend, Mr. Nukai Toby, and Justice Khampepe relied on the test for financial interest to determine prior association. What is the test for prior association? The next paragraph is heading prior association with ABSA Bank. It starts at paragraph 78. That's where the test is laid. You don't have a long discussion because that test is taken from paragraph 76 of Salfi. And it says, prior association with an institution cannot form the basis of a reasonable apprehension of bias unless the subject matter of the litigation in question arises from such association or activities. Justice Khampepe keeps saying you need something more after showing associations. Yes, something more is here, unless the subject matter of the litigation in question arises from the associations or the involvement.
So
And-
before I lose my thought, so in this case, you make reference to certain families who are party to the matter in front of her. Is that right?
Yes, but
I'm paraphrasing.
can I conclude the test first? Because otherwise we're confusing the test and the application of the test. The test is you look at whether whether the subject matter of the litigation, in this case the inquiry, arises from such associations or activities of Justice Khampepe in the past. Now, in this case, she didn't ask that question, so she did not answer it. You can't answer a question you did not ask. That is the Lewis judgment, that is the Scalabrini judgment, that is DA versus the President of the RSA. She asked the wrong question and answered the wrong question. The right question is this one. She didn't ask it, she didn't answer it. That's a classic review ground. Even if you're in the labor court, that's a review ground. Even under the Arbitration Act, where the limited grounds of review, you just have not determined the issue before you because you asked yourself the wrong question and you answered the wrong answer. So I don't even get to the application for the grant of review. On this alone, the ruling must be set aside. There is no answer to this. You can read all of their heads of arguments, and I'm talking about my learned friend Mr. Toby and my learned friend Mr. Bali. They don't contend with this test. They're talking about the logical connection for financial interest because they are defending a wrong ruling, wrongly determined ruling on a wrong test. That is a classic ground of review. Whether you're in legality, common law, PACHA, that's a review ground. Now, it's impossible for this court to find that nevertheless she determined the matter properly. Because what is she determining? She's determining the wrong inquiry. So she can't get it right. So I don't even have to get into, for review ground, I don't have to get into whether she might have accidentally found it right on the facts. Because she didn't ask the right question. But on remedy, I accept. I have to show you that the test is made on the facts. Because we're asking for you to find that she should have recused herself. But I'm addressing myself now just to the ground of review. On the ground of review, the argument of my learned friend Mr. Toby at paragraph 43 not only assists you understand our ground of review, it makes it conclusive that the review ground must be granted. On postponement, they say it's a discretionary decision, and so we must show that she used the wrong principle, or there was a misdirection on delay, or there was a misdirection of facts, material misdirection. I demonstrated a misdirection to you this morning, that you can read all the pages and paragraphs on delay. You will not find a single word or single sentence where Justice Khampepe says President Mbeki delayed by 10 days, 3 months, 8 months, 9 months. You can't determine unreasonableness of the delay without first determining the duration of the delay. That's why PACHA says beyond 6 months the delay is presumptively unreasonable. You must then explain why it shouldn't be a bar to you proceeding. In legality, which is what we're in, there is no cutoff point. So there's a whole world in which you can be. In SAFU, at paragraph 7, you'll see that the delay there was more than 3 months. You'll find no word by those judges saying this recusal must be refused because of delay. Nothing like that. Bennett versus Absa is a different kettle of fish because the judges made full disclosure. The litigant chose not to raise recusal until there was an adverse finding. That's completely different here. There's no adverse finding against my client. In fact, it is the suggestion of our learned friend Mr. Vani and Mr. Toby that we should wait until an adverse outcome. Then they're going to argue Bennett.
So we are between two stools, so to speak. We don't do that, and we're not going to do that. So the review ground, even in delay, is established. On the facts, I said it is incontestable, and I've not heard my learned friends contest that the reason for this commission of inquiry is that there has been a failure to prosecute apartheid-era perpetrators who were denied amnesty. That's true. Where does that come from? Is that in any way, does that arise from any of the earlier functions or activities of Justice Khampepe? 100%. She denied the amnesty to these perpetrators. She also went into the NPA to implement the decision to prosecute. That is common cause. They can say she wasn't in the HRU unit or whatever it was, but she was there as the second in command to prosecute apartheid-era cases. That's what she was doing. So there is it's as clear as daylight that the subject matter of this inquiry, which is whether and if there was political interference, arises from the failure to prosecute, which she is clearly associated with, she was clearly involved in. As our learned friend, Mr. Brendas for the President said, it's not just association here, it's involvement. So this is the clearest case of disqualification. Then we hear about Rodriguez, that in Rodriguez, somehow the court has already determined that my client interfered. You will read Judge Miller's judgment in the High Court in the intervention application, which we have cited in our heads of argument at page 054-4 at paragraph 6. It's a footnote 3. You read that judgment, it's not uploaded, I think. That judgment makes it clear that he read this affidavits you see here, this lengthy affidavits by the Karate group, he read those and he said there is no evidence connecting President Mbeki to political interference. There are articles written by newspapers and books. Bonzelia is going to testify there. That's not evidence in court. In Rodriguez, former President Mbeki was not a party. So one can't say he was involved and the case is made a determination. If that was the case, why do we have a commission of inquiry? If the SC has already said President Mbeki is guilty of interference, we have a commission of inquiry because there is no such a determination, and Judge Miller was right.
Yeah, but Mr. Manager, I do not want to extend in respect of time the question, but when you say, when you try to discount Rodriguez states clearly that the policy decision by the executive, this doesn't.
Yes, but for delay, the question is, could President Mbeki have challenged, brought a recusal for Justice Khampepe after the Rodriguez judgment was handed down? No. Could he have done so when he intervened in the High Court in March this year? No. Could he have done so after the terms of reference were issued in May 2025? No, he was not an interested party. There was no Rule 33 notice. The ADJP took it out of my mouth that the only time he becomes an interested party is when the Rule 33 notice is issued. That's our submission. I'm not suggesting that the ADJP agrees with me. I'm just saying, in paraphrase our submission. So whether you look at Rodriguez, the intervention, Justice Miller's judgment, Justice Miller in fact said our client doesn't have a direct interest in that litigation. So how does he suddenly have an interest to stop a commission merely because it has been promulgated? He's not yet before the commission. When he comes to the commission, yes, from September, I accept there is delay. But how much is that delay? Justice Khampepe doesn't tell you. She doesn't compute it in order to determine whether it's unreasonable. Because the question only arises for all overlooking delay if it is unreasonable. You don't overlook it in a vacuum. So that is the context in which I made the submission regarding Rodriguez. But the submission I made is this defamatory submissions we submit with respect that, in a sense, his administration has already been found by the SCA to have
interfered. If that was so, we would not have a commission of inquiry.
Yes, no, I said I don't want to debate this, but all I can say is, where was Mbeki during those years which have been delineated by the specific?
Yes, he was in government, but we're talking about delay in bringing a recusal before the commission of inquiry. You mustn't forget that, because, and the question you must ask yourselves is, when does the time start ticking for him to bring a recusal? Can he bring a recusal when Rodriguez is handed down? Where is the commission? There's no commission. Can he bring a recusal in March of this year, of last year when he tried to intervene? There's no commission. Can he bring a recusal in May 2025 to ask for the recusal of the chairperson? He's got no place before the commission at that time. They haven't called him to come and do anything. The only time he's before the commission is the Rule 33 notice is issued. Then I accept, and I accept emphatically, that at that time the clock starts ticking against him. But in determining recusal, the delay also, you mustn't forget that he doesn't only rely on prior institutional roles. He also relies on what are roles in the conduct of the proceedings. You couldn't have known that in September. It only happened in November. That's the first point. The second point is, to this day, we don't have a full disclosure as to what Justice Khampepe was doing in the NDA regarding TRC cases. The only reason delay mattered so much in Bennett versus Absa was because the judges there made full disclosure and said, once you had full disclosure, you had the full facts, and that's what the judgment says. You are not entitled to wait, you must bring it immediately. And may I correct one thing, because an argument has been made that we rely on disclosure as a ground of review. We don't. We're not saying disclosure is a distinct ground of review. We don't keep that. We're saying disclosure is an element of determining whether recusal was called for. And we have given you the judgment in Dube at paragraph 13. And Safu and Absa say the same thing. When there is doubt, there must be recusal, because you failed to disclose. And there's a failure to disclose here. The non-disclosure exacerbates the spleen. It doesn't alleviate it. It makes the suspicion even more pronounced. So with respect, it is particularly relevant. And the commission, in terms of reference, do not say there is political interference. Go and investigate who did it. It says whether and if. So it must be read properly. It says whether and if. It must still be a finding by the commission whether there was political interference and by who. It's possible that, having investigated and had everybody, the commission says there were two potential explanations for the failure to prosecute. One is internal failures within the NPA. Two is some interference by one or two politicians. But we conclude that the real cause is the internal failures and is not political interference. The commission can do that. You can't foreclose that outcome. If you were the judges sitting in that commission, you could realistically reach such a conclusion. So with great respect, that doesn't give them. Then you have the decision not by the commission. My learned friend, Mr. Nika, told me tried fancy footwork in respect of this. Justice Khampepe, as chairperson of the commission, is a creature of statute. Fedshaw and many other cases following Fedshaw says the creature of statute can only exercise those powers conferred on that creature of statute. He relied on the rules. I asked the court to read the rules. They are at 077-10-999. 077-10-999. You will see those rules, and I can give you several examples because I've read them. 4.2, 5.2, 7.1, where the chairperson is given powers to do things on her own, the rules say so. You can issue directions. You can decide the order of witnesses by yourself and so on. It says all of that. But a recusal application is an application contemplated in Rule 11. It says any party wishing to make any application to the commission which is not otherwise provided for in these rules must do so on at least 7 calendar days notice in writing to the Commission, but the chairperson may condone non-compliance with this notice period on good cause shown. That's what he can do. 2, the Commission may condone non-compliance with or extend any time frame provided for in this rules on good cause shown or when it is in the interest of the work of the Commission to do so. 11.3, wherever this rules make provision for any person to apply to the Commission or to the chairperson, the application must be a substantive application on affidavit with a notice of motion. It happened here, and section 47 was not raised. This is a notice of motion calling upon the recusal of the presiding justice. If there was a section 47 argument, it should have been raised there. Media arrest should have been raised there. They're all belatedly raised there. The affidavit must, among other things, reflect the relevant facts, the order sought, and the grounds relied upon to seek that order. The application must be lodged with the Secretary of the Commission, who will ensure that the original is delivered to the chairperson and a copy to the Commission's evidence leader. The applicant in that application must cite every other person whose rights may be adversely affected by the order sought and set a copy on him. We were cited in President Zuma's application, and the chairperson issued a directive that anybody who wants to support President Zuma's application must file their affidavits. We did, and now we are told we shouldn't have. As soon as possible after the chairperson has become aware of such an application, she must issue such direction or order as to the future conduct of the matter as may consider appropriate. That's the end of that rule. The chairperson is given no power to then decide the recusal application by herself. That explains why the recusal in Advocate Zumenia's application was decided by the Commission collectively, and the order is given on behalf of the Commission. And the notice in terms of Rule 3.3 to my client, which the court will find at 009-129 at paragraph 2, says the Commission is constituted by the chairperson, Justice Homu, and our learned colleague, Andrea Gabriel S.C. On the statements, you heard that there is no rule to put statements before. But how will the other members decide with you when they also don't know what you are doing in the NPA if you don't put up a statement? And then reliance is placed on AfriForum and Masuku. But those judgments are so distinguishable from the present case. I don't know why they were cited. In AfriForum, there was a transcript, a full transcript of the exchange which gave rise to the application for recusal. So all the judges had the transcript. They could determine for themselves what the facts were before them. In Masuku was also the transcript of the portion of the transcript of the webinar which was referred to in that. So the courts had the facts, the full facts relevant to the recusal. We don't have. This court still doesn't, because there has been no disclosure. So nothing dependent on the judge's personal knowledge. There was transcripts of proceedings that were put up. I've dealt with the issue of disclosure. So with great respect, this is a case that cries out for corrective relief by this court. And we emphasize that all judges in this country swear an oath. There are judges who are in the Constitutional Court, Supreme Court of Appeal, the High Court. You are all judges subject to that oath under the Constitution. The Constitution is supreme. It binds the courts and everyone. So when you have to decide this case, you must remember where I started with paragraph 10 of SALF, that this is what the judges of the highest court in the land, the first court in this country, under the Constitution, to be the Constitutional Court, said this to all of us. At the very outset, we wish to acknowledge that the litigant and her or his counsel who find it necessary to apply for the recusal of a judicial officer has an unenviable task, and the propriety of their motives should not lightly be questioned. Where the grounds are reasonable, it is counsel's duty to advance the grounds without fear. It is my duty. It is the duty of my learned friend, Mr. Mbeki, the duty of our learned friend for the President, Mr. Brainders. On the part of the judge whose recusal is sought, there should be a full appreciation of the admonition that she or he should not be unduly sensitive and ought not to regard an application for his or her refusal as a personal affront. Is a reminder not only to Justice Khampepe, but to this court, that you are asked to perform the task that she failed to properly perform because the ruling is reviewable. And you must do so bearing in mind paragraph 10 of the Constitutional Court judgment in Suffolk, and that all judges, but all judges are subject to the oath of office, and all of judges are responsible to protect the independence and public confidence in the judiciary. Recusal is at the core of it, because we are promised a fair trial before a presiding officer who has an impartial mind. And Corruption Watch says that standard applies with equal force to a commission of inquiry. Those with respect are sufficient, and we ask for the orders in the notice of motion, except for that last order, the declarative that I mentioned, that we don't ask for nullity, because that follows as a matter of law, not matter of discretion by any judge, applying section 172 of the Constitution or applying section 8 of PAJA. It follows as a matter of course, and we've given the court the references. Those are submissions, and it only remains to us to thank the court for its indulgence and the time we put to you to have to listen to us. Thank you.
Mr.
Yes,
Off,
I promise.
I thought you said
I
your last
did.
word.
I did. 2 minutes.
No,
You
let's
can-
make it 1 minute.
You can cut one. One is
Yeah,
fine.
no, one.
59 seconds is fine. 3 quick ones which will assist the court. One is in relation to the section 47. I wanted to point out the curious omission of Justice Homo, because nobody has said why did we not have a section 47 application with Justice Homo. And I'm just putting that out there. So it's one of these delaying tactics. 2, I want to refer the court to a case that we've uploaded, 055A-530. It's a case of Dupree with a Z at the end versus the Truth and Reconciliation Commission. It's exactly on point on this question that Justice Mudau was entertaining from Mr. Mbeki about the finality of the outcome and so on. Because I did read out the English case, but it looks like if it comes from me, it doesn't make. Here, the SCA, in this case, from pages 055A-563.
On the list of authorities, where is that?
No, it's not there. We just uploaded it this morning. When Mr. Mbeki was making these submissions, I just remembered.
Yeah, it should have been here by now.
It's not. Okay, I'm told it's also 078.
What's the name of the case?
Dupree with a Z at the end. DU space PREEZ versus TRC. -71, yes. And it might be in a different format. So somewhere in that case, you will find that there's a reference to the argument that was made by Mr. Mbeki. And it says, I did not understand respondent's counsel seriously to dispute this, and indeed the court appears to have
Where are you
accepted.
reading from?
I don't know. Where am I reading
If
from?
you don't know where you're reading from, I think we
Yes.
should.
No, I do, but I don't know on that 078
What
format.
page is the judgment?
Yes.
Page in the judgment?
No, I have it in a different format. Anyway, I don't want to waste time. Let's same page.
What page? We are on that judgment. What page
Do
on the
you
judgment?
have 055A-560?
Give us the judgment page number. Do you have the actual judgment with you?
I don't have it, Judge. I've got it in PDF from the as printed. That's why we posted it.
Yes.
So in their format, I don't know which. Just look for the. Okay, same format. Oh, okay, fine. Then it's on page 34. Page 34 of the printed of the typed. Where it says The appellant's contention that carrying out their statutory function, the Commission and the Committee were under a duty to observe principles of national justice, and then they quote the English case which I quoted yesterday, Re Pegamon Press. And then 078-104, Justices.
That's the case line reference number, yes?
Yes, and I wondered what that part does is just to refer to that English case, and then it goes on for 2 pages, and then at the end it says, subject to the grant of amnesty, the ultimate result may be criminal or civil proceedings against such persons, and that's persons such as President Mbeki and clearly the whole process is potentially prejudicial to them, and their rights of personality, they must be treated fairly. That's all. And then the last one is, which is really going to be, I'll be fired if I don't make the submission. I was asked to please implore on this court, in terms of the granting of the relief, that after all, even if it's there's so many papers and so on, who are in urgent court, and because of the dynamics of the case and the fact that the commission is continuing, for the court to please consider, because there's all these volumes of paper, at the appropriate stage, obviously, if it might not be feasible to grant an order and reasons later, because the danger of many months rolling by or even weeks might exactly be that the commission will be continuing. I'm not insisting, I'm just putting it out there to say that since we're in urgent court, we normally ask for those kinds of orders. And I know, I'm not saying tomorrow, because obviously that's not going to happen. I'm simply saying as if the court could really bear that as soon as humanly possible, at the minimum, the order will be granted, because every day, as all my learners and friends have said, the irregularity continues.
Well, it depends on how we decide the matter.
Either way.
Yes.
Well, either way, the country needs to know. Sorry. That's all.
I was hoping that is all. Yes, Mr. Nino.
My Lord, I managed to have 15 minutes of reply. But it's 17:28 and I'm sensitive to pressures. So I'm going to cut it to 10 minutes. So could I start with the accusation of active concealment?
With respect, we have to intervene. My learned friend only has the right to reply in relation to the in limine points. But section 47 and Pacha, in media res, he has no right to reply on the merits of the case. Disclosure, active concealment, whether he likes it or he doesn't like it, he has no right to reply. It's bound up with the merits. The merits issue is not in the limine points. With great respect.
Mr. Mugaito,
Yes.
we reason that your colleague is correct.
I've got absolutely no problem. Yes. In fact, what I'm simply going to do is to show you, because we handed up a judgment on Safi, to simply show you here's the judgment, here's the paragraph. I'm not going to argue the point at all.
Okay.
Because my rights is on eliminate points. That's all I'm going to do. Now, you may decide that you don't want the assistance, but I'm simply offering. Now, on the active concealment, what you will see is in the ruling of the Chapter C, those issues are dealt with right towards the end. Just want to find so those are dealt with yes, from paragraph 87 077/1010, paragraph 87 up to up to 107. That's the first one. And then the second one, the judgment we handed up on pay. I didn't give you the quotation. And paragraph 64 of that judgment. That's the judgment by Justice Nugent. So you will find that specific but I'm sorry, it's actually very slow. I think it's the internet connectivity. Probably slow, so. But I want to refer the court specifically to paragraph 64. The 64 is at 058/268. So you will recall the argument here is the argument around whether it's necessary to establish a law that is violated on the signature issue. So the judgment I had in mind was paragraph 64 of the on-pay judgment that refers to skilled. And then then the last point just on these notices is to just go back to the finding of the chairperson. And I want to show you the specific paragraphs where all of these tests, Sarfu, Bennett, are cited. So that you don't go under the wrong impression that the chairperson didn't in fact deal with it.
With great respect, this is not an in limine reply. He's suggesting that the chairperson got the test right. That's precisely what I just argued. He has a note. He's given you a note on the test. Why is he replying when he's got a note? This is just not just. It's not justice.
Well, we made a ruling, Mr. Inspector, in that regard.
Yes. So
You wanted to show us reference.
the last reference, yes. So this is at 077/991 up until 077 so 077/911 to 077/995. So those are the three references that you have to take into account.
Thank you.
Now, let me then deal with the arguments on section 47. The first argument is that the section is an the interpretation of the section is an objective exercise. There is no dispute about it. But the reason why we have to cite the facts of this case is to underscore the importance of the protective nature of the section. And also debunk the myth that there is a distinction to be drawn. Because it's actually interesting what our learned friends do. On the one hand, they say that you have to disabuse your minds of the facts. But on the other, they say you have to look at the fact that Justice Khampepe is not cited in a personal capacity or qua judge. But the reality is you have to take those facts into account, particularly what is pleaded in the founding affidavit. Mr. Bofu specifically pleaded, what his client pleaded these facts, and couldn't actually respond to them in relation to their implication to Section 47. So we repeat again, Justice Khampepe is attacked in relation to her judicial role, and she is also attacked in relation to the performance of the public functions in terms of Section 85 of the Constitution. Now, those two attacks underscore the significance of the protective nature of Section 47. That's argument one. Argument two is that Mandasha is distinguishable because the Chief Justice was still in office. That is a distinction, but it is without any difference. I asked the question, what is the difference between a judge in office and a judge who has retired for purposes of the necessity to protect judicial independence? Remember that Justice Mlambo says the purpose behind Section 47 is to ensure that judges can perform their functions without fear, without favor, and without prejudice. From that perspective, there's just no difference whether you are in office or you have retired. Argument number three refers to take and save, paragraph 2 of the TRC. Now, unfortunately, that judgment is completely inapplicable because it refers to a judge that is presiding over a case which has final effect. When you give a judgment, it has a final effect. It is not referring to a case of a judge presiding in a commission of inquiry with no final effect. In fact, by citing the case, they've just illustrated the point I've been trying to drive earlier. Then there is the problem about legality and whether it's necessary to show adverse effect. We've referred the court to the Rhino Oil judgment, paragraph 33. It's explicit that even a review based on legality, it is still necessary to show adverse effect. Now, yes. Now, the Paja point is completely answered by Korabi. Because Korabi says, for as long as the decision has no final effect, Paja is inapplicable. And final effect here simply means if the Commission of Inquiry's findings will not be binding on anyone, all of the interlocutory decisions that are made towards arriving at the final decision must suffer the same fate. Simple point is this: the Commission's recommendations are not binding, and that is why no decision, a decision to recuse, also has no impact on any rights, precisely because no one is bound by the outcome. It doesn't matter what the outcome says, no one is bound by that outcome. So again, that comes back to this point that it really doesn't matter for our legal friends to say, well, look at, take a look. Bottom line is that that is a judicial decision. Here we're dealing with a commission of inquiry whose outcomes are not binding. And then final point. When one looks at the, it's not clear which ground, Paja grounds or legality grounds that are being pursued. And if one is looking at legality grounds only, which is the point we try to make about why you have to decide whether Paja or legality grounds. If the case is limited to the legality grounds, there are only two bases on which you may interfere. Basis one is ultra virus. Basis two is lack of rationality. It's very crucial that you keep that framework in mind. Otherwise, one gets confused about which ground you're talking about. And when it comes to ultra virus, it's clear that we are not in ultra virus territory. When it comes to rationality, even there the standard is narrow, it's differential, but also it asks the question whether or not the reasons given can be justified by the evidence before the decision made, and the reasons and the purposes for which the inquiry was established. So we would therefore submit that on Section 47, Mr. Bofu says because we suggested that we could strike it, it therefore means that it's not non-scripted. It's not clear to me that he's right there. If we are right on section 47, the remedy that is already provided for by Justice, by the Mantashe case, is that you have to dismiss the case because there is no valid litigation before you. Now that doesn't result in a lack of finality. It actually results in complete finality. They may ask for permission, which is the point he's driving. They may ask for permission. But a judge looking at this may say that this litigation is abusive, I'm not giving the permission. And therefore that could be the end of this proceedings. So the idea that he's trying to plant, which is upholding section 47, results in the non-completion of this proceedings. It's actually unfounded.
Well, she was not a judge yet. It won't be this JP will decide.
It
If
could
it
be,
is to be anyone, it will be the Chief Justice.
it might be the Chief Justice, but it may result in the Chief Justice not granting permission, in which event it will be the end of this proceeding. So this idea that they'll keep coming back is actually unfounded on the structure of Section 47. So we would ask that you uphold the Section 47 objection and declare that the proceedings are non-scripted. I've got nothing else to add.
Mr. Mbeki,
No, well, you will like this one.
I would like this one.
You will. I was just tending to echo the words of my learned friend to thank the court for all the indulgences. But of course, if the court doesn't want to be thanked. As God.
Thank you, Mr. Mbeki.
It's not much.
Well, it has been a long day in a courtroom where the aircons are not working. For that, we apologize. And but that's a situation beyond the control. We rely on state resources. With that said, having had counsel, the submissions made, judgment is reserved. As soon as the judgment is ready, will be notified. We are adjourned.